Today also mentioning.
No, my lord, praying leave, my lord, as the my
To
lord,
do what?
my lord, the demolition order was passed. I got the order, my lord, yesterday.
Move before the vacation
Demolition-
bench.
No, my lord, demolition will be taken place on 24th, my lord.
Demolition
Leaving
under
that-
which act?
Under my lord, eviction of unauthorized act, my lord. There is a appellate of everything, but
Leave is granted.
my lord, kindly take it to 2 p.m.
To 2 p.m. Yes. Give notice to the other side. Yes. What is the urgency?
The urgency is that there is the question of pre-deposit in an appeal under section 45 of the RERA Act. 100% may be the maximum. Penalty and interest has been imposed on.
There is a law point. What is the urgency?
Law point, my lord, is this is the law point. The urgency is.
Come back after it.
My lord,
No. File in due course.
In the vacation.
File in due course. No. No vacation.
The difficulty is, my lord, it is not heard. My lord,
Nothing will
first,
happen.
The imposition will be there.
No.
Well, item
Time limit will
46
expire.
and 47, my lord, Lordship was pleased to grant me the leave, my lord, disconnection, my lord. This is a restaurant, my lord. If it is not been restored, my lord, they do puja, I cannot run my
No,
business.
it's already appearing as an upgrade, madam. No further exam.
At 2 p.m., my lord,
No.
Mr. Konok Kiran Ban is appearing for the WBC.
Other side is informed.
Yes.
46, 47 করে দাও তো 2 p.m. ওঠার পরে। Yes.
My lord,
My lord,
similar
not-
prayer,
My
my
lord,
lord.
may I permit to mention one matter, my lord.
46, 47.
The petitioner was granted bail.
Why are you mentioning it today?
My lord, under compelling circumstances, my lord, I'm mentioning, my lord, since in order sheet, it appears that the bond in figure, it has been written 10,000 and in word, it has been written 20,000. My lord, earlier I have mentioned this matter.
You're a prisoner. Bond means what bond?
My lord, the petitioner was enlarged on bail, and
It
he
is
was
appearing in the list.
no, my lord, it is not appearing in the list. My lord, when my lord was sitting at the circuit bench at Jalpaiguri bench, along with the
So what
justice.
can be done today? I don't understand why you are mentioning.
My lord, I am mentioning, my lord, for this, my lord, this minor correction may be, my lord, corrected today.
Jalpaiguri
If-
bench is functioning.
My lord, Jalpaiguri bench is not functioning, my lord. Since
How can it be listed today and heard
My lord,
today? Why
my
did you
lord,
mention yesterday?
my lord, I have been advised, my lord, if my lord give consent to list this matter at
No, no.
at supplementary
No,
list,
cannot do. Sorry.
my lord.
No, not during the question. Please.
List, my lord. Mr. Kamlesh Bhattacharya mentioned this matter yesterday, my lord.
Item number?
45, my lord, tender matter, my lord.
For what?
Kindly take away 2 p.m.
No,
Tender matter,
no
my
further upgradation. Yes.
lord. My lord, tender matter, my lord.
Yes. I said no. Next.
Granting leave, my lord, for vacation, before the vacation.
What is the
because
urgency?
has been- After direction by your lordship for affidavit and final hearing.
No
of this
urgency.
matter, final hearing of this sale notice has been.
Very
published
well.
tomorrow, my lord.
No
Sale
vacation. No,
notice has been published, my lord.
no leave. Yes.
My lordship,
Item number 1.
Last day I won't take so many mentionings. Please don't mention if it's unless it's extremely urgent. Why didn't you mention yesterday?
my
Let me take up matters today. I'm fixing so many matters, not taking up matters.
To move this matter before the.
No, refused.
But if I
Yes.
cannot
No, I refused you already.
my
Yes.
lordship,
If I do not move it.
No.
No.
Ask for the leave before the vacation bench. No. Yes.
with your kindly, I'd like to mention a matter, my lordship. The facts of the case is very simple.
What is your urgency, ma'am?
My lordship, the urgency is there's a company petition filed against the petitioner, my lordship. The matter has been
Why
reserved.
are you mentioning today? Not,
My
did not
lordship,
mention-
the matter has been filed on Monday, my lordship. My lordship,
That's your problem.
my lordship, please consider the urgency. The
Refuse.
amount has been,
No, refused.
my
Yes.
lordship, please, 6 crores has been
Don't repeat.
my lordship.
Yes, call on the list.
Also covered by a lordship order in a identical
We
manner.
mention
My
item
lord-
number 1
my
for
lordship-
correction.
One who is appearing.
My lordship, I'm also led by Kishore
What is
Datta
the
in this
correction?
matter. I'm also led by Mr.
Please
Kishore.
move. Yes.
My lord, in item number 42, my lord, matter has come up, my lord, correction will be the counsel's name appearing for respondent number 11, my lord. It has gone down as different as Mr. Tanmay Chakraborty, my lord. My lord, Tanmay Chakraborty.
The name of counsel for respondent number 11 in the order dated October 17, 2023 be stand corrected to read Mr. Tanmay Chakraborty instead of Mr. Tanmay Chakraborty.
My lord, just the opposite. Instead of Tanmay Chakraborty, as Tanmay.
I've said that.
Great.
You didn't follow.
Sorry.
To be mention item number 2.
I am appearing on behalf of the state.
Yes. What you mentioned?
The report needs
report to be filed, the direction for filing a report.
বাস ওইটুকু তারপরে রিপোর্ট
কি কি জন্য?
হ্যাঁ দিয়ে দে
From the office of the court.
Yes, what was the matter, Mr. Bas?
My lord, your lordship, see your lordship's order. I prayed for, my lord, considering my application for shifting the line so that this industry can be saved. Your lordship directed to file a report.
So report, a copy has been given to you. Why didn't you give it previously? It was directed to appear today on I passed the direction on 4th of October. Today we are on the last date, 19th of October. Why didn't you give a copy to Mr. Basu Junior?
Yesterday.
This is a peculiar practice, Mr. Pade. Why do you do it?
I'm very sorry.
I mean, you
Yes,
should have
I have
given
no
it
answer.
just a copy to the other side. Doesn't harm you.
I have no answer, my lord. Answer.
Mr. Pade, what is the report?
Well, the report is saying that they ask for
Drawing.
minimal shifting. Well, the three lands they shown. But I have explained why it is not possible because 3% land it cannot be shifted.
Mr. Basu, please go through the report, user rejoinder if possible. What can be done? What else can be done? A report filed today be kept on record, full stop. A report filed today by the WBACTCL be kept on record, full stop. A copy thereof is served here and now on the learned advocate for the, on learned senior counsel for the petitioner, full stop. Next para, in order to take appropriate instructions and to enable the petitioner to furnish rejoinder to the report, comma, if so deemed fit, comma, the matter is adjourned till after the oncoming puja vacation and shall be listed. Give me a date, Mr. Basu.
I need a source, my lord. I am here.
Pardon?
I need a source, my lord. One or two following.
Very
well.
well. Be listed on November 20, 2023 under the upgraded matters list.
You know, one request may I make?
Yes, Mr. Baja.
This is my fault. I have not served. I have accepted. My lord, I have to accept. Now, my lord, restrain us not to charge the line.
If you charge, my lord, everything goes.
May I, please, Mr. Not to charge the line. My lord, project is completed. Entire Dokhin Dinajpur is waiting for the voltage during puja. This puja.
Learned counsel appearing for the WBSCTCL seeks a vacating of the order whereby the WBSCTCL was restrained from charging the line in question, full stop. However, comma, the predicament could have been entirely solved if the WBSCTCL was alert enough to hand over a copy of the report filed today previously to the petitioner. Full stop. In fact, comma, the matter had been kept under the heading to be mentioned in order to facilitate early disposal, but such attempt was frustrated due to no report of the WBSCTCL being handed over to the petitioner previously. Thank you. Next.
Top matter, item 3.
Yes.
Now, shall I for the petitioner, my lord? Lordship was pleased to grant me the leave to supplementary
What
affidavit.
is the matter, Mr. Chatterjee?
My lord, I have disclosed that fact that regarding granting of passport, my lord, to the grandson of the petitioner, my lord, who was initially not granted due to the fact that his father and mother needed to be present before at the time of hearing.
No, son of the petitioner?
The
Passport
petitioner's
was-
grandson is a karate champion, my lord.
Yes.
He wants to represent before the Bangladesh going to be scheduled.
What happened to his parents?
Parents, my lord, the father is alcoholic, that document I have annexed, and the mother has left, and we have that also proceedings also annexed, my lord. So, my lord, if your lordship.
Are you
wishes-
appointed as a guardian of the child?
Yes.
You have been appointed?
No. I have not been appointed. The passport authority asking for bring my either father or mother. So I can bring the father, my lord. Though he is admitted, my lord, that I have disclosed, man, in the
You
document.
were the grandfather?
And the grandfather.
Paternal grandfather?
Paternal.
Yes, Mr. Chakravarti, can anything be done? He's a karate kid.
It is also a case that they have made a representation.
Yes.
And now, my lord, my instruction is that Annexure C form has to be filled in by the father for grant of a passport to the minor.
I have applied
is-
on, applied.
No, let
online.
him complete. Please.
Sorry, I'm sorry.
Yes,
Annexure
Mr.
C, kindly see, my lord, once in the list that this application has to be filled up by the father in terms of the Passport Act. This provision has been made for grant of passport to the minor. I have no objection, whatever your lordship will
No, I
say.
understand, Mr. Chakravarti, because you are bound by the rules also.
Yes. And let the representation be considered and for upon
Sympathetic
concurrence of all
perspective,
formalities.
I'll put that in my order. Thank you, Mr. Chakravarti. Fair enough.
My lord, one more submission, subject to kind sanction. My lord, I have been instructed that father can be bring to the authority and he can sign. Father, though he has
His
been.
requirements cannot be met by the authorities in the office.
Lordship?
His requirements cannot be met in the office by the authorities.
No, my lord,
Probably
now
cannot
he's
be made by
better.
Mr.
Now-
Chakravarti's client. It will be difficult for them.
That's true, my lord.
But then alcoholic, he is always
No,
dependent on
no,
alcohol.
Not that, but now is a
So very
better
difficult for the
condition.
authorities to do that.
But the regulation is also the father has to affirm an affidavit for the minor.
Very well, then I'll direct him to be brought also. Learned counsel for the petitioner contends that the petitioner is the grandfather. What is the name of the child, Mr. Chatterjee?
Devankur Das.
Name of a minor, Devankur Das. Full stop. The said minor is proficient in karate and seeks to participate in a competition abroad. Full stop. For such purpose, comma, the petitioner seeks a passport in order to take his grandson abroad to participate in the competition. Full stop. The difficulty faced by the petitioner is that the petitioner's father is a confirmed alcoholic and the minor's mother has deserted the minor. Full stop. Next para. Hence, comma, it is left for the petitioner, comma, as the grandfather of the child, comma, to take him to participate in such competition. Full stop. Next para. Learned ASG contends that as per the provisions and procedure, comma, the father of the either of the parents of the child have to comply with certain formalities. Full stop. Next para. However, comma, learned ASG submits, comma, in his usual fairness, comma, that the representation given by the petitioner in that regard shall be considered by the respondent authorities. Full stop. Next para. It transpires that in the circumstances as indicated above, comma, it is the petitioner, comma, who is the grandfather, comma, who is the only person able to take the child to participate in such competition. Full stop. Next para. In order to ensure that the budding youth is not deprived of such opportunity, comma, WP 822209 of 2023 is disposed of by directing the respondent authorities to consider the representation of the petitioner in sympathetic light, comma, keeping in view the above alleviating circumstances. Full stop. Next para. However, comma, the petitioner shall ensure the presence of the father of the minor at the juncture when the petitioner's representation is considered, comma, so that the said father is able to execute the due documents as required by the authorities for such purpose. Full stop. Should I fix a date here and now, or you will give a date and do it?
Well, he is to participate on 27 December.
So should I direct him to go tomorrow at a particular time for such purpose, comma, the petitioner and passport,
Instead of tomorrow, after
then it will be after
Lakshmi Puja, I think that will be better.
This program is on from 27th of December.
20th December.
December.
Very well. The petitioner shall, for such purpose, comma, the petitioner shall be present along with the father of the minor, comma, on. So should I keep it on October 30th? On October 30, 2023, at 12 noon, before the concerned office of the respondent number. Which respondent? Two. Respondent number 2. No address to cost service. Thank you, Mr.
Gratefully,
Chakravarti.
Lots of happy vacation.
And same to you. Thank you so much, and same to all of you. Thank you. Bolo.
Sir, thank you, sir.
একটা জায়গায় বলেছি
আমি নিয়েছি স্যার।
ও আচ্ছা গ্র্যান্ডফাদার অফ নেম অফ বলিনি নেম ওকে জিজ্ঞেস করেছিল অফ আ মাইনর বাই দ্য নেম অফ a minor by the name of
Madam Clerk.
Thank you.
When initially I could not follow the requirement which has to be.
Yes, I understand. Mr. Chakravarti followed.
Item 4.
Yes. Yes, Mr. Bhattacharya, what is your requirement?
Not with the exercise department.
Yes.
No, this is not exactly the same matter like yesterday's, but it is related to the same place and the same act. Now, here also, my lord, what happened? The writ petitioner before your lordship, my lord, traveled to your lordship's court, and my lord, your lordship's court relegated him to the appeal, to the appellate forum. Now, admittedly, my lord, that was then order made by the SDO and collector. Now,
This is under which act?
that 1962 Act.
Oh, that. No, I was thinking about your other matter
Hmm.
regarding which you were vociferous. I mean, the association. That's why I couldn't understand at first. Yes, 62 Act, yes.
1962
SDO
Act.
considered appellate authority.
SDO's order was under challenge. Your lordship's court relegated him to the appellate forum. You know, the previous matter which I did yesterday, my lord, he carried an appeal from your lord, from the trial court's order, and my lord, the appellate court modified it, relegating him back to the first forum. Here, my lord, he preferred an appeal. The appeal was heard on a particular day on notice. Then, my lord, nothing done. Again, my lord, a fresh notice served on him, calling upon him to attend the first authority. He writes to them, bringing it to their notice two things.
First authority, how can?
The first authority is the SDO's authority.
No, no, appeal was pending.
Appeal was pending. Appeal not decided till date.
SDO called him again.
Once again, in
Why?
the month of August.
Yes.
First is me not kindly.
No, SDO called him for what purpose? What was the disclosed purpose?
The
Hearing.
hearing.
Acha, then?
And now, my lord, he writes to the
So
SDO.
SDO had finally decided first.
No, no. SDO had initially decided that order was set aside. Just to show your lordship.
Please repeat once again. No. Need not show say anything. Yes.
Lord,
SDO passed an order
I
of
come to
demolition.
your lordship's court in the month of December 2022, assailing an order of SDO whereby I was asked to vacate and not remove the.
You are sent to appellate court.
I am sent to the appellate forum.
Appellate forum, you prefer an appeal that is pending. In the meantime,
And the
SDO called
appeal
you
was
again.
heard on a particular day
Then
on notice. My lord, I appeared, I entered appearance, gave my submissions. Thereafter, no decision till date. In the meantime, during the interregnum, the first authority, that is the SDO.
what was the occasion of the SDO? Anyway, then what happened? You went
Lord,
there.
I initially I write to them, bringing it to their notice that the appeal is pending. Second is this collector point also I took. My lord, without any decision, he has now passed an order. Now, my lord, the immediate urgency to keep. Follow?
SDO had passed an order.
Yes.
Again.
My lord, I am copy দিয়েছো এটা কোথায় এখন কোথায় মানে my lord, now on the 10th of October 2023 he has now passed an order. The subdivisional officer, collector and subdivisional officer Kontai has passed an order.
So what did you challenge in the writ petition?
My lord, in the writ petition, initially the challenge is the SDO's initial order. Initial order means post appeal.
The calling you for hearing.
Calling you for hearing and passing certain directions, relying on reports not disclosed.
What directions were passed? What is the nature of the direction?
Kindly, my lord, may I just invite your lordship's kind attention to the first order. My lord, 13th October 2022, that is at page 48. Kindly sees who is passing this order. Apart from anything else, collector and SG. My lord, all these persons are, we are concerned with Polash Babu, proprietor Chuti. Serial number 4 at page 48.
Right.
The Lakhon Mundal. Shushanto Mundal. Then, now, my lord, I come to your lordship's court, my lord, by filing this writ petition at page 53. The writ petition was disposed of. My lord, at page 54.
Yes.
The district magistrate appellate authority is directed to hear and consider the appeal filed by the petitioners within a period of 4 weeks, subject to the petitioners filing an appeal within a week from date.
Yes.
My lord, I filed the appeal, page 55. Then, my lord, at page, my lord, 69, my lord, 12th December 2022, the district magistrate and collector. So, my lord, SDO and collector, appellate authority is now becoming district magistrate and collector. He calls me for a hearing in the appeal, my lord, on 11th of January 2023. I appear on the 11th of January
Who is
2023.
Lokhikanto Mondol? Someone else.
My lord, Lokhikanto Mondol is, my lord, we are concerned with serial number 6. Shushanto Mondol. My lord, we are concerned with Shushanto Mondol. First one, first name. first name in that list.
Who is Palash Babu then?
Palash Babu is, Milord, the person who is apparently, Milord, entered into an arrangement with Sushanto Mondol and running the homestay.
Who is the petitioner? Sushant or
Sushanto
Palash?
Mondol.
Anyway, then, so I don't understand. This was against Palash, not against Sushanto, the first one.
Yes, but Milord,
Sushanto is in no way concerned.
kindly, Milord, kindly sees the averment.
The resort is the same.
Yes, yes, yes. It's the same place. Everything is same. Now, Milord, after your this notice, Milord, I entered appearance. Nothing is done. Again, Milord, I am called for a fresh, Milord, hearing at page 70. Milord, we are concerned with one measures Chuti, serial number 3. 4th August 2023. Now the subdivisional officer Kontai, Milord, undersigned is fixed the hearing on 16th of August 2023 at 12:30 hours in the office in connection with the enquiry report submitted by the BL and LRO, Milord, Ramnagar 2. This enquiry report not disclosed. Be that as it may, Milord, I immediately write to him, on the 14th of August 2023.
Chuti is separately a company.
No, no.
What is Chuti?
It's a
It's a juristic entity.
no. Technical, but I would not.
Chuti is the name of the resort
Yes,
only.
yes. No,
You are
it's
the
not a resort, Milord, it's a homestay. Milord, it is not a resort. Kindly.
Whatever, homestay resort doesn't
Homestay.
no qualitative
homestay.
difference. No, who I mean, who is Palash and who is Sushanto vis-a-vis Chuti?
Sushanto Mondol is and Palash. Milord, Sushanto Mondol is the patta holder, and Milord Palash Babu is looking after the homestay. He is the manager of that place. And in
The
possession.
entire setup is illegal, basically.
Wait, I can't say it is legal. But I will not, Milord, appearing for the petitioners even for a second, Milord, say. But this show is going on since 1981.
Hearing notice was given by
Now,
subdivision.
now, Milord, I write to them the second, apropos the second notice, Milord, I write to them at page 72. Pointing out all these facts, Milord, all on a sudden by a notice dated this, our client was called for a hearing before the collector SDO in connection with the proceedings under the Act. At the time of hearing, it was informed by the collector that a report of Executive Officer Digha Shankarpur Development Authority dated such and such has been placed before them, alleging that some plots are being illegally occupied by attendees.
This is which page?
Milord, this is page 72.
72, right, yes.
Milord,
This is your letter.
yes, my letter. And thereafter, Milord, I have averred everything, including the writ petition. Milord, please see page 74. 73 bottom. Being aggrieved by the actions of the authorities, my above clients moved a writ petition such and such after hearing all parties. His Lordship, Honorable Justice Moshumi Bhattacharya, inter alia to the effect considering this. Subsequently, in compliance with the order, page 74 kindly comes. Memo dated such and such, a notice of hearing was served upon my clients, directing them to appear before the district magistrate and collector.
So pursuant to his Lordship Justice Moshumi Bhattacharya's order, you went to the appellate authority.
Yes, that was the direction. That was the order also. Basically, Milord, that is the intent of, that is what the purport of the order.
So then what happened?
Then, Milord, accordingly, my client participated in the proceedings after notice, submitted their grievances and made their submissions. Accordingly, the matter was heard without passing any order on that day. Until date, no order has been passed or no communication has been received from the DM and collector regarding any final order. Surprisingly, when my clients are eagerly waiting for the order of the hearing, on 10th August 2023, my clients received a further notice dated 4th August.
So Bhattacharya, let us not be on your representation. Let us see what happened after that.
Milord, thereafter, Milord, they, despite receipt of this representation, they say that, Milord, page 77.
Yes, 77. Yes.
The manager of the following establishments, third line, fourth line rather,
Hmm.
were found absent in spite of receiving notice, Milord, which includes Chuti. Milord, we have already communicated to them that this is the position factually. Then, Milord, he relies on a report of the BL and LRO, which is again not disclosed. Ultimately, Milord, reviewing the, Milord, page 78, reviewing the documents submitted by the above noted establishments, the report and the report of the BL and LRO, the, Milord, directions are made The BL and LRO is directed to demarcate the land under possession of these hotels, etc., to ascertain quantum of vested or patta lands falls under these establishments, and also ascertain the ownership. Start proceedings for annulment of patta, and Milord, B is submit reports whether these establishments are situated within 500 meters of high tide. Now, Milord, again, I write to them at page 79, bringing the entire facts to his notice, including, Milord, the facts regarding this district magistrate and collector. These points are taken.
This is a different proceeding, Mr. Bhattacharya. This is regarding Patta WBLR Act. This is an entirely different proceeding.
Then,
That
Milord,
this has no nexus with
let
your appeal.
me answer you, Lordship. Then, Milord, please come to page 83 once again. All these hotels, Milord, at one go, including Chuti, Milord, was communicated the order and inquiry report for compliance. Milord, what is the order? 29th August. Milord, again, the report of the BL and LRO, Milord, is taken into consideration, and Milord, these directions are passed. Ultimately, Milord, I come to your Lordship's court. The directions are page 86.
Yes.
Page 86. Then,
At last, an honest officer has come there as SDO. Who is taking some steps against these. Is your illegal occupation? Patta has been, these
now,
directions
Milord,
have been
then,
given. What are you challenging, Mr. Bhattacharya?
Milord, I am challenging, ultimately, Milord, they have now served on me this order, Milord, which
Yes, what is that order?
which is this order, Milord, on the 17th of August, October 2023, all these persons, Milord, have been served this order. Milord, I have not filed an affidavit,
No,
but
not.
Milord, I intend to use an affidavit, Milord. They
Yes.
have been. Milord, please see page 9.
9, yes.
All the respondents, that is, including Chuti,
8 in my copy, yes. Chuti.
including Chuti, are directed to evict the suit vested plots in such and such under Mauda such and such within 15 days from the date of the order and restored possession of the plots to its original status. Now, this is what we are aggrieved by at the present moment. Milord, this 15 days is ending, Milord, sometime on the 25th. Now, Milord, they have relied on reports not disclosed to me. They have relied on, Milord, various documents, and most fundamentally, Milord, starting from day one, SDO and collector and the appeal before DM and collector not decides, Milord, doesn't decide it, the appeal pending, and Milord, again, SDO and collector serves on me a notice and initiates this proceeding, which culminates in this particular order, which I have shown your Lordship just now, Milord, order dated, Milord.
This proceeding has nothing to do with that. This is not under 62 Act.
Yes, Milord, with respect, it is under the 60.
Why do you say that?
Milord, kindly come.
This is regarding cancellation of Patta
No,
under 49.
ancillary part. Cancellation of Patta is an ancillary part. Milord, please come back. Kindly comes.
Yes.
Milord, this is. Milord, please see page 48.
But it's a double proceeding.
Yes, I'm sorry, page 47. Please see
It's
page
a double proceeding. Then the same for under the same act, twice proceedings.
47. 62 Act is a separate thing. Land Reforms Act, cancellation of Patta is a separate thing.
Yes, obviously they are.
100%. I will not trouble you.
Yes, they are separate things.
Page 47, kindly.
That was 62 Act.
Yes, that proceedings, 62 Act. Then, Milord, please call back to
Page 86, something is there.
Milord, I just show your Lordship.
Page
Just
86,
show your Lordship.
he refers to the 62 Act again.
Yes. Milord, please see page 69. This is again, Milord, falling back to the Honorable Court's order.
No, the previous proceeding was under 62 Act. There is no doubt on that.
Yes.
SDO passed an order that
Yes.
appeal is pending. There is no
Yes.
doubt on that.
Yes.
What about the present proceeding?
The present proceedings, Milord,
This is superfluous. Page 86 is
proceedings,
superfluous.
Milord, was initiated by 4th August 2023, page 70.
Yes. Please come to the order dated 29th August.
My Lord,
84.
my Lord.
The proceeding is entirely on 49(1)(a) of WBLRA. But at page 86, the SDO erroneously says that such and such manager owner of these hotels, which does not include your hotel actually. Failing to submit requisite documents, proceedings under section 4 of the 62 Act will start. So this does not cover your hotel. As far as your hotel is concerned, the only thing, or your homestay is concerned, the only proceeding is 49(1)(a).
Now, my lord, please see page 85.
Why shouldn't you approach the Land
please see
Reforms and
page-
Tenancy Tribunal, Mr. Bhattacharya?
Can
Page
you-
80,
85.
85, yes.
There is a finding regarding 6, my lord, serial number 6.
Mhm. Patta land distributed,
Yes.
right?
And then, my lord, ultimately, my lord, this culminates in that order, which I have just now shown your lordship, my lord, at page 7.
Page?
7. My lord, please, my lord,
Page
stop
7?
that affidavit.
Ah,
my lord,
this,
that-
yes.
Please come, fall back, my lord, 10th October 2023. My lord, please see the first order, first page. After getting information and reports of BLLRO and the undersigned suo motu proceedings under 4(1) of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1962.
Hmm.
This notice was issued to the parties under this, the private respondents, etc. This is how it has proceeded. And
That was
ultimately,
only regarding two of them. This has to be read with page 86.
with 9, 9, with 9,
I have no page 9.
8, 8. Underneath.
এই তো 8 শেষ 8 শেষ
হ্যাঁ? এই তো ওটাই আর। এই 8, এই 8।
This is under Patta for Patta annulment. So even if you win that appeal, this remains.
With respect, Milord, with respect. Now, please see page 8. I'm grateful to your lordship. All the respondents, including Chuti, are directed to evict the vested Milord within such and such time. And this proceedings, Milord, was under the 62 Act. Milord, it begins from page 6. The proceedings initiated under 62 Act. But there is no two views, Milord, with the deepest of respect to your lordship, Milord, there is possibly, Milord, no quarrel with this.
Yes, what do you
Under
say?
62.
What do you say? Two proceedings under 62, one appeal is pending.
My lord, one appeal is pending. My lord, kindly come to the appeal filed by them. My lord.
That is against 62 Act order,
My lord,
whatever may be in that appeal.
who my lord, kindly BC, my lord, who have filed the appeal and against whom the order has been passed. My lord.
Which page?
Appeal is page 55. After the order passed by this honorable court, my lord, they preferred the salutary appeal. Sushanto Mondal, Josna, Lakshmikanto, and Sumati. These are the appellants. And now, my lord, the order which they are showing your to lordship is page 83. The notice issued by the SDO.
Hmm.
My lord, to them, the notice has not been issued. They are not the parties.
Mr. Chuti is one of the recipients.
Chuti is not the appellant, my lord. Kindly see. Chuti is not the appellant.
Yes, I have explained.
Chuti is a partnership firm, probably.
Chuti, my lord, I'm putting question to myself, my lord. If the Chuti is a partnership firm, he ought to have filed the appeal, my lord. But
No, the previous appeal was, see, there are two partners of this.
my lord,
Mr. Bhattacharya did not point out though, but their appeal says, page 56, that there are two partners. One is this Sushanto, the other is Polash. These two are the partners. If these two are the partners, Chuti is their resort. So one proceeding is, one order is passed against Chuti through Polash.
my lord.
Polash prefers an appeal. Sushanto prefers an appeal. Now, again, the second proceeding are under the same act. Come to page 6 of this supplementary.
My lord.
You begin with the expression that after getting information, report such and such, undersigned started suo motu proceedings under section.
Well, there are two proceedings. Well, admittedly, there are two proceedings. One is under
No, not admittedly. I was under that impression, but please read out page 6.
after getting the information, report BLR at Ramnagar 2, undersigned stated suo motu proceeding under West Bengal Public.
It starts with that I suo motu initiated a proceeding under 62 Act.
62 Act. Thereafter, my lord, against 1950 Act, 55 Act, my lord.
It does not say so,
Well,
as if this proceeding is under 62 Act.
This proceeding has 62 Act, but the order under challenge, my lord, in the writ petition,
File your affidavits, they are entitled to a stay at least. There is some doubt.
my lord, in page 86, my lord, kindly see.
The
for a second, my lord.
petitioner initially challenged an order whereby a notice was issued to the petitioner by the concerned SDO, apparently pertaining to the patta granted in favor of the property, on which the petitioner is running a beach resort in partnership. Full stop, next para. Subsequently, during pendency of the writ petition, comma, an order has been passed directing the petitioner to be evicted from the property. Full stop, it is contended that on a previous occasion, comma, a proceeding was initiated under the Public Land Eviction of Unauthorized Occupants Act 1962, and an order was passed against the beach resort in the name of one Polash, comma, who is one of the partners. Full stop. Subsequently, an appeal was preferred against the same pursuant to leave granted by a writ court. Full stop. Such appeal is pending. Full stop. During pendency of the same, comma, the second proceeding has been initiated against the same entity, comma, this time apparently under section 49(1)(a) of the WBLR Act 1955.
Right.
Full stop. However, comma, learned counsel for the petitioner points out from the supplemented affidavit that vide order dated October 10, 2023, comma, the SDO starts with the sentence that after getting information and reports as referred to therein, comma, the SDO started suo motu proceedings under section 4 within bracket 1 of the 1962 Act, comma, thereby giving an indication that the second proceeding also has components of the 1962 Act. Full stop. Although otherwise, learned counsel for the respondent authorities submits that the second proceeding is under the West Bengal Land Reforms Act and not a repetition of the 1962 Act procedure. For sub next para, the submission of the respondents could have been accepted if in the order dated October 10, 2023, comma, the SDO had not started with the sentence that the proceeding was initiated under the 1962 Act, full stop. As such, comma, even if there is a component of grant of patta coming within the purview of the West Bengal Land Reforms Act 1955 in the second proceeding, comma, since ingredients of the 1962 Act are also prima facie involved as per the order dated October 10, 2023, comma, it is palpable that under the same Act, comma, particularly during pendency of an appeal in connection with the first proceeding, comma, a second proceeding cannot be initiated by the same authorities. Full stop. Hence, comma, the respondent shall, the petition is directed to be heard on merits and shall be listed for such purpose in the monthly list of December 2023. Full stop. The respondents shall file their affidavit in opposition by November 24, 2023. Reply, if any, shall be filed by December 1, 2023. Full stop. There shall be stay of operation of the order dated October 10, 2023 till January 15, 2023 or until further order, whichever is earlier. Full stop. Next para.
January 15, 2024.
24. Yes. But you have to approach the appellate court for the for operation of the stay of operation of the other order, Mr. Bhatt. You have not done that.
Only another thing.
That's why I have said.
Kindly, your lordship will kindly indicate that your lordship will not sign the order unless the supplementary affidavit is brought on record in course of half an hour. This is not affirmed. Your lordship has been pleased to stay the order, I will not affirm it and give it.
On the prayer of learned counsel for the petitioner, comma, the petitioner is directed to file the supplementary affidavit after proper affirmation of the same during the course of the day.
Yes. Yes.
Next.
Your lordship.
Item 5. 5, yes.
Your lordship, I appear on virtually. I'm very sorry. I apologize, your lordship. I couldn't come to court. I have taken.
No, Mr. Sinha, yes. What is it?
I have to take. Your lordship, what has happened here is, I'll just take you to two documents. I have been declared, the bank is proposing to declare me as a willful defaulter. And that will obviously hamper my entire business throughout because of that. Your lordship, what has happened is I was a guarantor for 1 year for a company which has gone into liquidation. Thereafter, and it was a consortium agreement, 3 banks were involved, to which I gave a guarantee, but that was limited for 1 year. Irrespective of anything, the deed of guarantee which is annexed also indicates that it was for the period 2013. Now the willful guarantor guideline says that any guarantee which is given not a group company, but otherwise guarantee which is given prior to 2014, there's a date, June 2014 or something, cannot be brought within the understanding of willful defaulters. So that is a clear benchmark within from which that's a deadline. Now I fall beyond that. I fall beyond that. So there cannot be a proceeding against willful defaulter on me. Your Lordship, just I'll take you the trouble to take to page 100. Page 100, that is a sanction letter. Page 100.
Yes.
Your Lordship, that is the sanction letter which has been given to Eastern Gases Limited. I am not Eastern Gases otherwise. Now, this Eastern Gases has gone into liquidation or something is going on in NCLT. They cannot recover it. Coextensive, I agree. Guarantor is coextensive. There, I have no dispute to that. But your Lordship will come to page 110, continuation of the same document. The sanction letter.
Yes.
Now, you will see at the absolutely at the top, it says the limit will be valid for 1 year and subject to renewal based on performance. So it was when I gave a guarantee, the limit was for 1 year. Your Lordship, thereafter, there the renewal or otherwise, I have never renewed or signed any document which says it's renewed. My guarantee is renewed. Now, I'm indicating this because it's a larger point which will perhaps come up in at the course of the full hearing. But your Lordship, for the purpose of interim stay, please come to page 111.
No, the limit does not limit the guarantee, Mr. Sinha. Does it?
Your Lordship, if the loan itself is coextensive, if my liability is coextensive with the person, with the borrower, if the borrower's loan is for 1 year and then it has to be renewed, then if I have to be made liable for that, I still have to.
If the borrower's loan is for 1 year, but the borrower defaults in payment, the default
It is not defaulted in 1 year. It is defaulted much later.
Even then, the loan is relating to that period. The
No,
loan
it is
for a
not.
particular period, Mr. Sinha.
Lordship, the thing is that
Guarantee your liability is not limited to that period. Liability is still the repayment.
Absolutely. For that loan, not a continuation later on.
Oh.
What has happened is that they have gone on increasing the limit and then now they are catching hold of me. And that also the consortium was of 3 banks. One bank is doing this to me. The other 2 are there. The other 2 have not approached me as willful defaulter. Now, leaving that aside, I'm not even going in that point.
Clarity, Mr. Sinha, I can direct the other banks also to initiate proceedings.
Yeah, absolutely. That is fine. Your Lordship can absolutely do that. But your Lordship will just come to page 111.
11, yes, 111. I'm there.
Your Lordship just looks at the date. Deed of guarantee is made at Kolkata this 5th day, 2013.
Right.
Now, your Lordship, my juniors are there. They will hand over a copy of the willful defaulter guidelines.
Circular, yes. Yes, Mrs. Sinha.
Now, yes, your Lordship, it will be 2.6 in page 7.
2.6 is guaranteed. Yes.
Guarantees furnished by individuals, group companies, and non-group companies. We fall under the non-group company.
Right.
The last line, I will not trouble you with the entire thing, last line of that page.
Yes.
The treatment of non-group corporate and individual guarantors was made applicable with effect from September 9, 2014 and not to cases where guarantees
I'm not getting it. I'm sorry. I'm not getting it. Yes. This is
page 7. At the bottom, the page number is there at the bottom.
yes, page number I've seen, but that is not clause 2.6.
2.6.
That is 2.2. In my copy, this is the master circular of July 1st, 2014, 1st July.
Oh, your Lordship, okay. Yes, actually, I have a 2015, which is the update. I'm sorry. Your Lordship will just trouble me.
This is updated up to January 7, 2015.
Yes, your Lordship will come to 2.6. I'm just.
No, I'm 2.6 is here also.
Yes.
Oh, so this is separate. এটা ফেরত দিত। Very well, this is a different, I mean, the pagination.
Yes.
Yes, right.
Your
Last,
Lordship, the last sentence, Your Lordship. This
This-
treatment of non-group corporate and individual guarantors was made applicable with effect from September 9, 2014, and not to cases where guarantees were taken prior to this date.
very well, very well.
Now, the reason why is the next line. Your Lordship, why it is the next line. It
Mhm.
says banks and financial institutions may ensure that this position is made known to all guarantors at the time of accepting guarantees. So what now is the requirement under law is, if you are giving a guarantee and you are taking a guarantee, the guarantor has to be made aware that unless you pay, then you will be made a defaulter. You can be declared as a willful defaulter.
Now, what is the treatment referred to? I'll look into that. This treatment of non-group companies,
Yes,
applicable with such rate. What is the treatment? I'll have to see the previous portions of that paragraph.
very well, Your Lordship. In connection, the first one is with regard to group companies. The first paragraph is with regard
Right.
to
Not, not.
non-group companies. Your Lordship will see in connection with the guarantors in terms of section 128 of the Contract Act, the liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. No dispute with regard to this position of law, Your Lordship.
No.
Therefore, when a default is made in making repayment by the principal debtor, the banker will be able to proceed against the guarantor, surety, even without existing the remedies against the principal debtor. That is also basic contract law, Your Lordship.
Right.
As such, where a banker has made a claim on the guarantor on account of the default made by the principal debtor, the liability of the guarantor is immediate. Again, same, it's a contract act.
Yes.
In case the said guarantor refuses to comply with the demand made by the creditor, banker, despite having sufficient means to make payment of the dues, such guarantor would also be treated as a willful defaulter. This is what it says, that if you don't, then I will treat you. But then it says it will only apply to, because they're making a penal law, Your Lordship. This is a penal sanction which is being made, that I will declare you as a willful defaulter. That is why, because this comes in 2014, comes in application in 2014. That's why guarantees which were already given, guarantors were already given. So a penal law, Your Lordship, cannot be retrospective. On that principle, this is made that you will not treat those guarantors, cannot be made willful defaulters.
Mr. Sinha, the treatment apparently refers to this additional layer of protection given to the guarantors, which says in case the guarantor refuses to comply with the demand, despite having sufficient means to make payment of the dues.
That is, Your Lordship, that part is fine.
Protection.
I'm not into that. I am only on the last part, which is the date from when
No,
guarantor.
the treatment which is spoken of in the last sentence, which you are referring to, that may refer to this additional cloak of protection. That treatment would be applicable after this September 9, 2014.
Your Lordship, may I just submit
Works
this?
for you. Yes.
Your Lordship, for me, it works for me. It works for me.
No, it makes it worse for you. If
Your
the,
Lordship,
if the treatment refers to the cloak of protection given to you.
no, Your Lordship, may I just submit this? It's
Yes.
if Your Lordship now then says this treatment is not only of that part, the entire thing about guarantors being declared as a willful defaulter, this treatment of non-group corporate and individual guarantors was made applicable it comes into application with effect from September 9, 2014.
Very well. I get your point. Very well.
And not to, and then the qualification, and not to cases where guarantees were taken prior to this date. The reason why they are saying this, Your Lordship, is in the next line, the next very line. What happens now is when I give a guarantee to somebody, the bank has to make me aware, and that is a clause now it is added, that if the principal debtor does not pay, then you can also be declared as a willful defaulter.
No, Mr. Sinha, you have a point there. If it is required to be made known to the guarantors now after this cutoff date, then they are suffering the rigor. It's obvious. I mean, very well. Get your point. Right.
Worship, that is my point immediate. And the second, there is other thing which have to gone into facts that if Your Lordship will come to 3C, that 3C is Your Lordship in
yes, got it. Page
Yes,
10.
page 10, yes.
Yes.
Your Lordship, what happens is, the first, there is an order of a committee. The
Hmm.
order of a committee that yes, this is a person should be declared a willful defaulter.
What stage are you in now?
They are telling me that I will be declared as a defaulter without going into the second review.
They're telling you.
Your Lordship, I'll go to the documents later.
Premature, this is not premature.
No, it's not premature at all, Your Lordship. May I just come to that? Your Lordship will come to the documents, page 195.
195, yes.
Yes.
195, right.
Yes. Your Lordship, that is the letter from them, from the principal respondent, Central Bank.
Yes.
Thereafter, Your Lordship comes to page 196. Thereafter, at the bottom, says reason justification for reporting as willful defaulters. That's what they say.
Page 195 is relevant, Mr. Sinha.
Lord, these pages are missing in my brief.
195 is a letter of authority to you, to Ms. Usha Doshi. That is page 195. So that's why I'm asking whether this.
Not 196, Your Lordship, 196. Your Lordship, 196 without prejudice. That's a letter 16th April 2022. They write to me.
Yes, Mr. Doshi.
203
Let me hear Mr. Sinha. Yes.
pages are missing.
Pages are missing, Mr. Sinha. What are you doing?
From
Their documents, 196, 204 is she saying? I'm referring to 196.
202.
188 to 202 are missing.
Are missing.
So what is
In
left?
my service copy.
Anyway, what is there in 196? Yes, let us
Your
see.
Lordship, if Your Lordship just looks at the bottom portion, the reason for justification for reporting. Now, this comes, Your Lordship, as per 3.3c, this entire thing comes after two stages are gone. One, the committee refers, and then there is a review committee which takes care of that. Thereafter, they send me this letter. Now,
No, this is the first committee is giving you a right of hearing.
Your Lordship, thereafter, I give them a letter in 198.
Yes, 198, right? This page is
That is 198 to 199.
Yes, your reply then?
And their reply in 200, page 200.
Right. Yes. Have you been declared to be a willful defaulter, Mr. Sinha?
No. They are proposing to. That is why I want to stay, because it does not apply. This regulation does not apply to me. If I am declared, then my entire banking system will go for a toss.
Where you took this point in your reply?
Your Lordship, Your Lordship, I have said. Your Lordship will come to page 199.
199, right?
Right, and he comes to the fourth paragraph.
Yes.
Says further, willful defaulter has been defined in RBI regulation and the criteria under which you are trying and attempting to declare our name as willful, but you have failed to agree that we are the alleged guarantor having no linkage, so and so. That criteria, Your Lordship, is the one which I was talking to you about. They should have perhaps put in 2B. 2.6, they should have been categorically stated, categorically not stated, but
No, Mr. Sinha, you have right of here. Because you have given your reply, let them do whatever. This is premature.
Your Lordship, my only thing is they should not declare me as I'm only submitting to this much. Let them do a hearing if they want a hearing, but they should not hold me a willful defaulter prior to a hearing.
Mr. Sinha, I'll not interfere now, but I'll record your submission and I'll say that this point has to be considered by them while taking the decision.
May I just
Yeah. Okay.
Mr. Sinha, no interference now. I'll dispose of the writ petition, not interfere. I should have dismissed it, but I'll put it as disposed of because that may have a bearing. I'll direct them to consider this objection raised by you also while taking the
decision. Only indulge me with going to page 201 once.
201, yes.
It is what they say after I give a reply.
Yes, Mr. Sinha, yes.
Last paragraph. Here we say that the willful default notice issued to you is well within the corners of law, and the same is issued to you as per the guidelines by the Reserve Bank of India. So they have already decided these points that they are not going to decide again. we say that in the said so-called notice, we have rightfully called for explanation from here to why it should not be treated as willful. They have taken a decision, your lordship. They
But we have not taken this objection specifically at all, that you have to factually say that I was a guarantor for this
And
period.
now it is your obligation to give. Very well, your lordship will at least give me an opportunity to represent one more time for them to consider my case on 2.6.
Do that within a week, Mr. Sinha, I'll give you that liberty.
Yes, I will do that. I will
Within
say,
a week, we'll do it, then after that, give them the hearing. Learned counsel.
Here in this writ petition, kindly look at the prayer. An order quashing letter dated 5/8/23. My learned friend has shown all letters of 22. They, after this letter dated 22, they were given personal hearing, and matter is still at stage 1. They have not been declared as willful defaulter, and he is in a category of the director of the company and not a guarantor. He has shown all document of guarantors, but he has been called upon. Your lordship will kindly look into this, totally misguided, because it is against your
He's also one of the guarantors, the directors.
Pansali.
I am a company. I am a company. I'm a company which is approached.
Not allow. I am not interfered. Now your lordship will look into cost title. Genco Automotive is coming before your lordship.
Yes, right. Mr. Sinha, you
Yeah.
are the company has come. I didn't even look to the cost title. You are the company. You are the borrower.
I am the company. I am not the borrower.
Basis of your arguments is
No,
guaranteed.
I am not the I am not the borrower. Your lordship. One company has given guarantee to another company.
Oh, achha, the company itself.
Yes, I am I'm a separate company. I'm a legal enterprise altogether.
You are
My
entitled.
lord, I'm drawing attention of 3 points on. First is a corporator guarantor has come before your lordship. He has produced guarantee deed, guarantee dated 5th February 2000.
May I
Since
just
I'm not deciding on the willful default at all, I cannot do that.
Your lordship, may I just submit only one thing? Page 220.
Order now.
Your lordship, with one thing. Your lordship will only see one document. After that, I will go with your honor. Your lordship with 220.
Counsel for the petitioner contends that the petitioner is a corporate guarantor. Full stop. Since the guarantee was given to the borrowing company prior to the cutoff date of September 9, 2014, as contemplated in clause 2.6 of the RBI Master Circular dated July 1, 2015, it is contended that the impugned proceeding for declaration of the petitioner as a willful defaulter is itself without authority and vitiated by the circular itself. Full stop. Next para. Learned counsel for the respondent bank controverts such submissions and argues that the petitioner has been given ample hearing by the before the willful defaulter committee, and as such, the premature writ petition ought to be dismissed, since no final decision has been taken on such count. Full stop. Next para. A perusal of clause 2.6 of the updated circular dated July 1, 2015 indicates that the treatment envisaged therein of non-group corporate and individual guarantors was made applicable with effect from September 9, 2014 and not to cases where guarantees were taken prior to this date. Full stop. Next para. The said issue is an arguable question, which is also required to be decided by the willful defaulter committee. Full stop. Next para. Although the petitioner was given ample opportunity to give a reply, and this point was not taken specifically in its reply, for the ends of justice, the willful defaulter committee ought to look into such issue as well while considering the declaration of the petitioner as willful defaulter or otherwise. Full stop. Next para. Hence, for the ends of justice, the petitioner is given another opportunity to file a further rejoinder reply to the previous reply filed by the petitioner in answer to the show cause. Full stop. Such rejoinder shall be filed positively within 1 week from date. Full stop. If the same is filed within the said timeline, the willful defaulter committee shall consider the same and take its decision on declaration of the petitioner as willful defaulter thereafter. Full stop, next para. It is, however, made clear that such rejoinders shall be confined to the point as indicated above as to whether the petitioner factually falls within the exception clause of exception contemplated in clause 2.6 pertaining to individual and non-group corporate guarantors prior to September 9, 2014. Full stop, next para. No further interference is called for at this stage. Full stop. WPA 22968 of 2023 is disposed of in the light of the above observations. No rest to cause certain. Thank you.
Milord, one small submission. Your Lordship will be pleased to record that I had submitted that he has executed another guarantee dated 21st January.
It is made clear that
2016.
it is made clear that the merits of the questions raised by the parties against each other have not been gone into, and it is deemed that none of the allegations made in the writ petition are admitted by the respondents. All questions are open. Yes, next. Item 6. Cemetery. Yes, Mr. Bhattacharya.
Happy holidays, Your Lordship.
The same thing. Only difference is, I have never come to your Lordship's court. They have relied on reports not disclosed and have proceeded to pass an order.
Where is that order?
I'm seeking your Lordship's leave to file the supplementary affidavit. The order is page 7. It begins from page 7.
Exactly similar.
The same order.
Similar proceedings.
Same proceedings. Please see page 7. After getting information and reports of the BL and LRO, the undersigned started suo motu proceedings under this
Despite
act.
service none appears for the respondent authorities. Full stop. Leave is granted to the petitioner to file a supplementary affidavit. Full stop. Pursuant to such leave,
Just for your Lordship's assistance, please see page 7. As per the last report of BL and LRO Ramnagar 2, why is office memo dated 3rd October 2023 not disclosed to me till date?
কি বললাম? Sentence কোথায় ছাড়লাম? A supplementary affidavit is filed today and be kept on record. Full stop. Next para. It transpires from the materials annexed to the writ petition and the supplementary affidavit that there was a previous order passed against the petitioner under the Public Land Eviction of Unauthorized Constructions Act, Occupants Act 1962. Full stop. An appeal has been preferred against the same by the petitioner. Which
No. Here it is not the same case. Here, I challenge the first order. The proceedings initiated.
You said exactly same as the other, except from
Exactly same as the other, apart from not traveling to the High Court or not traveling anywhere. 57 is the first order made in the proceedings 29th August 2023. Enclosing this.
no previous 62 section 1962.
This is the first proceeding.
Then
This is the first proceeding.
no interference. Satisfy me on merits.
First, notice served on me at page 47 by order notice dated 4th August 2023, calling upon me to attend the hearing on the 16th of August. I attend the hearing. Thereafter, 16th of August order, page 48. Again, reference to a report received from the BL and LRO not disclosed. I seek a copy of the report, paragraph 17, page 8. Then, 24th August, a fresh notice served on me indicating that on 29th, a fresh hearing is stated. Again, I seek a copy of the report at page 51. At page 51.
Why don't you go for the land reforms and the tenancy?
It is not a,
Land
this is a
Reforms Act?
62 Act, 62 Act proceeding.
No.
Yes.
Where is the reference to 60?
Last. Please fall back, to page 47. This is, the subdivisional officer collector. No reference to this. Now, please see the last order, page 7 of the supplementary affidavit which I seek to affirm. This is the third order made in the proceedings. First order is page 48. Second order is page 57. Page 57. And this is order number 3, page 7. Now, please see the second paragraph of page 7. On all these 3 occasions, reports relied on, not disclosed. In the second order, they disclose the report. I seek a better copy of the report, be that as it may. In the third order, they rely on a 3rd October report, which is not disclosed again. Here we are concerned with the remaining.
Inter proceeding is, nothing is there under 62 Act. Inter proceeding under 49(1).
No,
Go before
7,
the land reform.
7, page 7, please return.
7, yes.
Page 7 of the supplementary of the affidavit.
Yes.
But after getting information and reports of BL and LRO,
So
the underside started proceedings under section 4(1) of this act.
Learned counsel for the petitioner takes
I
prima
am
facie.
seeking leave to file the affidavit. Supplementary. It is an order of 10th,
Leave
served
is-
on 17th.
Leave is granted to the petitioner to file a supplementary affidavit during the course of the day. Full stop. It transpires that in the present proceedings, the concerned subdivisional officer passed an order of eviction, apparently referring to section 4 within bracket 1 of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1962, whereas also relying on section 49(1) capital A of the West Bengal Land Reforms Act 1955. Full stop. Next para. It is alleged that the SDO, without serving copies of the documents and reports relied on by the SDO for the purpose of passing such order to the petitioner, undertook the hearing and passed the impugned order. Full stop. Next para. During pendency of the writ petition, video order dated October 10, 2023, an order of eviction has been passed against the petitioner as well. Full stop. In view of such prima facie case having been made out, the writ petition is required to be heard on merits. Full stop. Accordingly, the respondent shall file their affidavits in opposition within November 30, 2023. Reply, if any, by December 7, 2023. The matter be listed on December 8, 2023 for hearing. Full stop. There shall be stay of operation of the order dated October 10, 2023 till January 15, 2024 or until further order, whichever is earlier.
Great.
What is this, Mr.?
This is the notice, indicating that I have mentioned the matter.
The a printout,
No, this is the affidavit of service.
a printout of the email,
Yeah. এটা আগের নোটিশটা প্রথম নোটিশটা
a printout of the email notice served on the respondents today be kept on record along with the supplementary, along with the affidavit of service.
Great.
Thank you. Please ensure that this is filed during the course of it.
ভাই এক্ষুনি করো।
Next.
7.
I am for the petitioner, but led by Devashish Roy and Mr. Firozji, but they could not come. This is the last day. The petitioner is 66 years old, ailing lady. Lookout circular was issued against the petitioner along with the family.
For the authorities.
Along with the family members. Along with the family members of the petitioners, and the it relates to her younger son and 2 daughter-in-laws. The lookout circle has been quashed by this honorable court, and 2 orders from your lordships. My lord, kindly see page 31. That is the one daughter-in-law.
Whose lookout circles have been quashed? Daughter-in-law?
Daughter-in-law, son, and 1 son and 2 daughter-in-laws. Son,
1 son and 2 daughters?
son, younger daughter-in-law, and older daughter-in-law.
Yeah, elder son was not, no lookout circle was issued.
No.
Yes, very well.
My lord,
So you are on a different footing. You may be on a
no, no,
different.
I'm on the same footing, my lord. I am also the guarantor. They were also the guarantors.
You don't return the money and you go to foreign countries and all.
My lord,
We are
for
actually
the-
helpless. I'm telling you because of the nature of the riders put in those circulars. Otherwise, these are fit cases for taking action against your clients.
But that-
At least action. I don't say you are guilty.
That-
But
that
the
I understand,
difficulty is
but-
lookout circular is not a substitute for recovery proceedings. That's the difficulty.
Yes.
I mean, not that we do it happily.
No.
Yes, show us their request. Have you got a copy of the
The representation, my lord.
No, the request on the basis of which lookout circular was issued?
Yes, yes, yes. My lord, page 57. No, the first letter is page 62, letter dated 16/12/2020.
No. Oh, that.
Yes.
Yes.
And before that, my lord, the format
What is
format is starting from
Show me the
page
reason
49.
for issuance. That clause.
Yes, 49. From 49, the formats. And the Might kindly come then page 57, they're annexures of that format.
No, where is the relevant clause regarding?
My lord, that is that is page 61, my lord. We apprehend that measure so and so group may leave the country. LOC help to prevent the traveling abroad. LOC may put him under the pressure since his name is disclosed to the public as defaulter. He may be under pressure because his image will be tarnished.
We apprehend that Messrs. RPRLL group may leave the country.
The group, there is no any formal information available. The last line, my lord. My lord, there is a reply, my lord, kindly see.
Reply
on
is
the-
not relevant. This is unrelevant.
and my lord,
Oh, this
kindly
is absolutely
59.
not done.
My lord, if I,
You are admitting that this is to put pressure on her.
my lord, if I may, kindly.
Definitely, yes.
My lord, the writ petitioner's name is in the willful defaulters list of the bank, the latest one, which is there on the website. I have a copy of it. My lord, I would place it before my lord.
So
However, the
she is a willful defaulter, declared willful defaulter.
declared willful defaulter.
Right.
The list of willful defaulters is available on the bank's website. Second, my lord, would like to place the Ministry of Finance's letter to all PSBs, public sector banks, I being one of them, dated 8th of April 2022, which clearly states and strictly directs the heads of all the PSBs to issue LOCs against willful defaulters, fraudsters, and money launderers who take the money and want to evade the law by escaping.
Can you please
the
give a
country.
copy to your learned friend?
My lord, I shall. I don't have an extra copy. And one more thing, my lord, the third thing, that they have placed reliance on the orders from DRTs, and they have taken the ground that proceedings are going on before the DRT. However, my lord, if my lord sees the orders at page starting from page 70, my lord, none of the defendants are appearing before the DRT. The matter has been filed. The OS, both the OS have been filed in the year 2014. None of them are appearing before the DRT.
That is not a criminal proceeding.
My lord, they are not. However, my lord, they are escaping the law as we speak. They are not. They are willful. They are a willful defaulter. They don't intend to appear before the bank. The money is not secured, and they want to travel abroad. I have no issues, objections to that. You can secure the money, and then you can travel abroad. But however, I am also bound by the Ministry of Finance's directions upon me. I'll give you a copy of that. And I have issued the LOC in accordance with this direction. They are a willful director, my lord. They have neither secured the money, they are not appearing before the DRT. I am not left with any other remedy, my lord. How will I proceed? On top of that, each and every member, all the guarantors and directors of this particular company is traveling abroad, my lord, very frequently.
Yes, what does the What does the center say? The union government.
We have nothing to say. We have issued at the instance of the bank authority.
This does not satisfy the circular. Sorry.
My lord, may I be allowed to file my opposition?
No, definitely. I'll record why I'm not permitting you. Learned counsel for the respondent bank at the outset seeks to file an affidavit in opposition. Full stop. However, comma, this will be the first ground of your appeal. Please listen carefully. However, comma, such prayer is refused, comma, since the bank does not seek to furnish any further documents which are not already annexed to the writ petition. Full stop. The question involved in the writ petition hinges on the veracity of a lookout circular issued on the petitioner, comma, which can be decided on the materials annexed. Full stop. Next para. The petitioner alleges that a lookout circular was issued against her at the behest of the respondent bank, that is the Bank of Baroda, by the respondent authorities. Full stop. Next para. It is contended that the request of the bank, which was the genesis of the same, does not satisfy the concerned circular of the Government of India. Full stop. Next parallel counsel for the bank places specific reliance on a communication dated April 8, 2022, issued by the Government of India, comma, Ministry of Finance, comma, Department of Financial Services to all public sector banks. Full stop. Next para. It is pointed out that in paragraph number 2 of the same comma, willful defaulters have also been included within the parameters of issuance of lookout circulars within bracket LOCs. Bracket close. Full stop. Since the bank, comma, being a public sector bank, comma, falls within the aegis of the Government of India, Ministry of Finance, comma, the bank duly complied with such communication by issuance of a request for lookout circular. Full stop. Next para. A perusal of the format of request by the respondent bank for the purpose of issuance of lookout circular is interesting. Full stop. Next para. In serial number 31, comma, which pertains to justifications to stroke reasons for opening of LOC, comma, the bank wrote that they apprehend that Messrs. R. PRLal Group may leave the country. Full stop. LOC may help to prevent the double inverted মধ্যে করুন. LOC may help to prevent his traveling abroad. Double inverted close. Full stop. It was further admitted by the bank, comma, which openly disclosed that the LOC may put the entity under pressure since his name is disclosed to the public as defaulter. Full stop. He may be under pressure, according to the bank, because his image will be tarnished before his business groups. Full stop. The bank went on to say that it apprehends that the entity may defraud other banks. Full stop. The bank also observed that the LOC may create fear in the mind of the concerned person and helps to find out an absconded person. Full stop. It is further recorded at the end of such request that there is no formal information available. Full stop. Next para. It is utterly surprising and disgusting as to how such apprehension and premise of the bank could find its place in a formal request for an LOC. Full stop. The purpose and reason for opening of LOC given by the bank is a case study in what it should not be in terms of the concerned circular. Full stop. The bank openly admits in its request that the purpose of the LOC is inter alia to put the person concerned under pressure, comma, by way of disclosure to the public as defaulter, and for the purpose of tarnishing the image of the person before his business groups. Full stop. The bank has the further gumption to say that it apprehends that the petitioner will defraud other banks Full stop. Not only that, comma, the LOC, comma, as per the bank, comma, may create fear in the mind of the concerned person and helps to find out an absconded person. Full stop. Next para. The cream dealer cream DELACREME dealer cream of the request is the last sentence which says that there is no formal information available. Full stop. Next para. No criminal proceeding against the petitioner is disclosed in the entire purview of the request. Full stop. Although learned counsel for the bank has contended that the petitioner has been declared to be a willful defaulter, comma, unfortunately for the bank, comma, declaration of a willful defaulter does not find place in the grounds for issuance of LOC as disclosed in the concerned office memoranda of the government. First up, the Ministry of Finance, Government of India, in its circulation among public sector banks dated April 8, 2022, cannot override the circular or put in additional grounds to the concerned circular of the Government of India itself, comma, which is the only authority which could issue any circular regarding the issuance of LOCs. First up, next para, moreover, comma, paragraph 2 of the letter dated April 8, 2022 does not say that mere declaration of willful defaulter makes it a valid ground for issuance of LOC. Push up. What it does is that merely by way of example, comma, it refers to all persons who are covered under the guidelines, comma, double inverted tarpar, including fraudsters and persons who wish to take loans and willfully default or launder money and then escape to foreign jurisdictions to avoid paying back, double inverted close. Full stop. Next para. However, comma, the circular itself, comma, at best, comma, provides that in the event the escape of a person is a threat to the sovereignty or security or integrity of India or is detrimental to the bilateral relations with any country or to the strategic and stroke or economic interests of India, or if such person is allowed to leave, comma, he may potentially indulge in an act of terrorism or offense against the state and stroke or that such departure ought not to be permitted in the larger public interest at any given point of time. Full stop. Next para. The bank has failed to establish that there is any serious fraud committed by the petitioner which tantamounts to adversely affecting the economic interest of the country if the petitioner leaves India, or may affect larger public interest, comma, which is on a much higher pedestal than the mere allegation of the bank that the petitioner has defaulted in payment of a loan. Full stop. Next para. In any event, comma, the remedy of the bank on such score lies in a recovery proceeding which has been duly initiated by the bank. Full stop. Next para. Clarification might be put in here to the effect that several banks, comma, it is noticed, comma, are proceeding on the premise that a declaration of willful defaulter itself is sufficient to request issuance of an LOC, comma, which is not sanctioned by the concerned office memoranda of the government. Full stop. Declaration of willful defaulter operates in a particular field, comma, to give a warning to other persons in the commercial community of the country before having transactions with a declared willful defaulter. Full stop. However, comma, such declaration does not replace a recovery proceeding or provide sufficient ground for taking a high step of issuance of a lookout circular. Full stop. In such view of the matter, comma, WPA 24837 of 2023 is allowed on contest, comma, thereby setting aside and quashing the lookout circular issued against the petitioner by the respondent authorities. Full stop. The respondent authorities shall ensure that the petitioner is not restricted from leaving the country on the basis of the said quashed LOC any further. Full stop. The respondents shall also ensure that proper and due communications are made reversing the issuance of the lookout circular to all authorities which might have been intimated by the respondents about the issuance of the lookout circular in the first place. The parties shall act on a server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy. No address to cause urgency.
My lord, kindly adds my submission to that part where my lord stated that recovery proceedings have been issued. Kindly.
No, I've said that recovery procedure which has been initiated.
My lord, kindly records my submissions that they are willfully not appearing before the DRT. In fact, the service
Right.
was done through public communication. Service was being done on
That
them
is-
by
that is
postal
not-
service, but they are not appearing.
That is,
Kindly records my submissions
that-
that they are.
Anyway, that is also not a ground for willful
Yes.
default. That is also not a ground for
No,
declaration.
deep level.
Yes, yes.
Deep level.
8. Petitioner.
My lord,
My lord, for item number 8, I am for the petitioner. My lord, I took a loan from 2 different accounts in the year 2017. I could not pay the loan since 2020, my lord, since the breakout of the COVID-19. Thereafter, the
Have you
account,
served the financial,
my lord,
all the respondents have been served?
my lord, all the respondent could not be served, my lord. I made a hand service, my lord, in the PP. I mentioned yesterday, there also I made the mention
What
in.
is the relief you are seeking?
My lord, all I'm seeking is the learned CJM passed an order for taking my physical possession of the property.
Section 14.
Yes, my lord.
Go before the tribunal.
My lord, I went before the tribunal, but the tribunal is not in session. We got the diary number. There,
Bench 2, second
my
bench.
lord, we got the diary number. We didn't got the essay number. My lord, thereafter, I filed a writ before my lord only. And there was my lord's order dated 5th September, my lord. 5th September, there was my lord's order. My lord did not interfere in the merits of the cases because the application was already pending. My lord given me a extension of 22nd September till 22nd September 2023. My lord, I duly communicated that and
Where is my order? Please show me that.
Page 40, man.
40.
in the writ petition.
So you moved the tribunal. What happened after that?
My lord, I moved before the tribunal. My lord, the court is not in session. My lord, I obtained the diary number. I could not obtain the essay number so that I can file a stay or anything there. My part could not be heard out yet. My lord, the order of the CJM is still on motion. I filed a writ. My lord,
When did you file the section 17? Give me the date. You are wanting a further extension of that stay.
my lord, kindly, my lord.
But service has not been affected on the bank.
My lord, yes, it not be, my lord.
When
no.
did you send?
My lord, we sent before filing of this writ petition. My lord, my lord, day before yesterday, my lord granted me a leave to file this.
A
writ
leave
petition.
is granted under Rule 26 of the writ rules insofar as the other respondents than the state is concerned. Full stop. Since the state is represented through learned counsel, comma, further service is not directed on the state. Full stop. The grievance of the petitioner is limited. Full stop. The petitioner had approached this court previously due to non-availability of a forum. Full stop. An order was passed by this court in WPA 21634 of 2023 on September 5, 2023, whereby a limited stay till September 22, 2023 was granted in respect of the order passed by the Chief Judicial Magistrate Barashat under Section 14 of the Surface Act 2002, comma, to enable the petitioner to approach the concerned debts recovery tribunal. Full stop. Next para. Learned counsel for the petitioner submits that till date, comma, the debts recovery tribunal is not functional. Full stop. Keeping in view such exigent circumstance, comma, WPA 25088 of 2023 is disposed
My
of
lord,
by
kindly, my lord, kindly don't dispose of my. Again, I-
extending the interim order by granting a further stay of operation of the order passed by the Chief Judicial Magistrate Barashat against the petitioner under Section 14 of the Surface Act 2002, till January 31, 2024, or until further
My-
order,
my
comma,
lord, the
whichever is
dates-
earlier, full stop. Leave is granted to the petitioner to approach the concerned tribunal in the meantime for allocation of work. Full stop. Next para. In the event the bench remains non-functional for a considerable period, even after this order, comma, the petitioner will be at further liberty to approach the appellate tribunal under the appropriate provisions of the Debts Recovery Act for allocation of the work, allocation of the petitioner's application from the bench in question to some other bench for the purpose of expeditious disposal of the same. Full stop. No orders to cause certain step.
My lord, grateful, my lord.
Your proceeding section 17 capital A was shown to me yesterday by one of the financial companies under the RDB Act. So go there and ask for an allocation.
Fine, fine.
Next matter. Yes.
9.
Yes.
Item number 9, I appear for the petitioner.
What is that? Service proper?
Yes.
Yes.
Lordship, the petitioners have been compelled to invoke this high prerogative writ jurisdiction challenging and sale notice since the DRT2 is not functioning, Your Lordship. That is why we have
What is
preferred.
the best ground for challenge?
Yes. Now, in 2022, Your Lordship, or not 2018, there was a possession notice. Now, the petitioners preferred an application under section 17 of the SABYASACHI Act. Now, while that essay was pending, sale notice was issued sometimes in May 2022. So the petitioners took out an interim interlocutory application. The order, Your Lordship, will find at page 28, 16 June 2022 order, page 28. The instant application being such and such filed on 14 June 2022 has been filed for putting up the case record for hearing. Another IA being such and such filed on 14 June arising out of that. Now, Your Lordship, kindly see the next paragraph. Learned counsel representing the defendant bank submits that under instruction that no bids have been received in respect of the said notice. In view of such submission made, the sale notice has become infructuous. Accordingly, the IAs are disposed. Learned counsel for the SABYASACHI applicant submits that the applicants are ready and keen to settle the loan account. In view of such submission made, the applicants are directed to approach the defendant bank along with an upfront amount of Rs 5 lakhs with a concrete compromise proposal within 15 days from the date of this order. The defendant bank is directed to consider such proposal in accordance with their settlement policy guideline. For status of settlement, the matter is posted to such and such. The earlier date, that is 26 June, stand cancelled. Now let's do the next page. Upon compliance of this order, the defendant bank shall not take any coercive measure. However, failing to comply, the defendant bank will be at liberty to take appropriate steps. Now, pursuant to this order, I submitted one proposal. Now, Your Lordship will find the proposal.
You deposited the 5 lakh also.
Yes, I deposited the 5 lakhs. The first proposal, Your Lordship will find at page 30. Your Lordship did not go through the entire proposal. I shall indicate to Your Lordship the amount. Your Lordship will find it at page 33.
Tell me what happened. You're not going to
Now,
the paper.
I
I won't
first-
adjudicate on merits.
Now, the first proposal was for an amount of 2 crore 15 lakh. Now, the bank said, no, the amount is very less. We will not consider. Subsequently, we gave another proposal for 2
What
crore.
happened ultimately? Proposal was accepted or failed?
No, the second proposal was 2 crore 95 lakhs. The bank sat tight over the proposal, did not communicate anything, did not pass any order. In the meantime, on 29th September, they issued this sale notice. Now, only thing I want to show to Your Lordship is a sale notice. Your Lordship will find at page 42. What is the reserve price? What the price that the bank has quoted is 2 crore 30 lakhs. 230.65 lakh. This is the reserve price quoted by the bank. On earlier occasion, there were attempts to sell off the property, but bank could not since the bank did not get any buyer, the prices started coming down. So the last price that the bank is offering on 29th September 2023 is 2 crore 30 lakhs. I am offering 2 crore 95 lakhs. The bank says the amount is too low. I am offering more than this amount, and the bank said I will not consider your proposal.
Then counsel submits that the petitioners after that interlocutory application, that was a conditional order. After that, what happened? That 17 is pending.
Yes, that section 17 application is still pending, and now this 29th March 2023, I brought it to the notice of the DRT by filing an IA. But since the DRT is not functioning, I just have been able to got the
Learned
DRT
counsel for
number.
the petitioner submits that the petitioner had preferred a challenge under section 17 of the SABYASACHI Act 2002 before the concerned tribunal, that is the Kolkata Debts Recovery Tribunal, bench 2, full stop. Next para. Initially, an interim order of protection was passed subject to the petitioner depositing an upfront amount of Rs 5 lakh and giving a compromise proposal, which was duly done by the petitioner, full stop. However, ultimately, during the pendency of the second compromise proposal of the petitioner, without considering the same finally, a further sale notice has been issued by the respondent bank. Full stop. Next para. It is pointed out by learned counsel for the parties that the petitioner is agreeable to pay a higher amount than the reserve price of Rs 230.65 lakh as depicted in the sale notice itself, comma, which is not being accepted by the bank unreasonably. Full stop, next para. Keeping in view such prima facie case of the petitioner and the bona fides of the petitioner as well, comma, apart from the fact that the petitioner does not have any forum to move its matter due to the second bench of the Kolkata Debts Recovery Tribunal being vacant, comma, WPA 25129 of 2023 is disposed of by granting an order of stay of operation of the impugned sale notice dated, what is the date? I'm sorry, I missed it.
29th September 2023. Your lordship
Dated
will find it at page 42.
September 29, 2023 till January 31, 2023 or until further order of the tribunal, comma, whichever is earlier, full stop. The petitioner shall approach the concerned tribunal in the meantime, comma, disclosing its offer with regard to the purchase of the secured assets. Full stop, next para. The petitioner will also be at liberty to approach the appropriate superior forum for allocation of its matter before a different bench for the purpose of hearing out of the same expeditiously in the meantime. No arrest to cause urgency.
Great.
Thank you. Sorry, I'm adding a line. It is made clear that the merits have not been conclusively determined by this court, and it will be open to the concerned bench of the Debts Recovery Tribunal taking up the petitioner's matter to decide the same independently and in accordance with law, and for such purpose, comma, if necessary, comma, to rescind, vary, modify, vacate, and or extend the interim order granted herein.
One thing, Your lordship, I have already taken out a
You have already taken out in
Yes.
IA.
I
I
have
mean,
already-
ask for that allocation of that application and also specifically give your offer.
Yes.
Thank
Lordship.
Yes.
10, item 10.
Item appearing for the petitioner.
Yes.
Paragraph number 2, the petitioner is a prisoner presently undergoing imprisonment in Baripur Central Correctional Home. In connection with judgment and order of additional sessions court, sessions judge second court, Alipur in sessions trial 1605 corresponds to sessions case number 65/1/2003.
Period of custody?
Years of custody.
Your lordship, parole has already been granted, your lordship.
Parole has been granted.
Yes, your lordship.
But
He is seeking parole for the marriage of his daughter. A parole has been granted for the same, your lordship. This is
Just for 5 days and
your
at the-
lordship,
with security.
Absolutely, your lordship.
But the thing is that he availed a security in the year 2000, this payroll in the year 2013 without security. And he returned before the scheduled date. I draw kind conclusion in annexer.
Without
security, 10 years back. Page, annexer P1, page 15.
It has been granted under strong police guard.
Yes.
In 2013, he went without police security. Serial number, page.
No
15.
right of yours is violated with police security, without police security.
Without.
That's their discretion. No.
Without police.
So what are you challenging here?
The thing is that if there's a police security, it will be a shame for him because there's a marriage in the family. All this, the persons will they won't come to the.
Show me the previous occasion when it was granted.
Page 15, paragraph 15, serial number 20. Details of behavior of the conduct during availing payroll. Page 15, 1-5. It is mentioned on his history ticket that he was granted payroll for 15 days.
Which clause? Which serial number?
Serial number 20, last. 20.
Yes.
Details of behavior of the convict during availing payroll. It is mentioned on his history ticket that he was granted payroll for 15 days, 1-5, and scheduled to return on 23rd of August 2013. But he returned to Alipur Central Correctional Home on 21st August 2013.
You said now you're in Baripur.
In Baripur. Now Alipur has closed.
Where is your home?
In Haryana.
You want to travel to Haryana? And
Haryana. As per the order of Superintendent, Alipur Central Correctional Home.
Yes, what do you say?
Your lordship, the period he is talking about.
Yes.
Your lordship, that was during the period supposedly when the trial was on, your lordship. Your lordship, thereafter he was in Tihar. He had been transferred from Tihar to here, and here he's claiming for this parole for the first time, your lordship. In this writ petition, he is relying on a parole of a co-accused as well, your lordship. The orders have been annexed where the co-accused has also sought for parole for 30 days, but the division bench, considering the issue concerned, had also directed them to them a parole of 7 days, Your Lordship. Furthermore, Your Lordship, the
That is
act
parole
he
is
is relying on, clause section 62(3) specifically mentions that during the notwithstanding anything contained in subsection 1 or subsection 2, the Inspector General such and such may grant release of any person for a period not exceeding 5 days in case of any emergency such as serious illness, funeral, marriage of son or daughter, Your Lordship. Lordship, a copy of this act. This has been considered and granted, Your Lordship. Thereafter, Your Lordship pleases. Your Lordship.
This is the second time parole he is appealing, not the first time.
Your Lordship,
10 years back, he was very good in his behavior. He
That
returned
was
back
during
without
his-
security, police security.
that was during
2013.
Your Lordship, the order and judgment and order passed was in 2014, where he was convicted. And he
What is
was,
the difference now? I mean, he has
no, Your
grown
Lordship, no
stronger in
difference,
the.
Your Lordship. Your Lordship, whatever Your
If
Lordship.
he could get that parole at that point of time without security, I mean, why not now? That parole was granted from the Alipur correctional home.
Correctional.
Alipur
Now it's in
correction.
Baruipur,
No, it's in
few
Baruipur.
miles apart.
Absolutely, Your Lordship.
Learned counsel for the petitioner contents. Eta ছেড়ে দাও. The issue involved in the present writ petition is more on a sensitive note than an assertion of a statutory right. Full stop, next para. The petitioner is a convict who seeks parole. Full stop. Although learned counsel for the state hands over a copy of an order dated October 12, 2023, which indicates that parole has been granted to the petitioner for 5 days to attend his daughter's wedding on November 5, 2023, the remark column thereof indicates that such parole has been granted under strong police guard. Full stop, next para. Learned counsel for the petitioner submits that if the petitioner goes to visit his daughter on the occasion of her wedding and attends the same under strong police protection, the same would not only cast a stigma on the petitioner, but also jeopardize the goodwill and the reputation of his daughter at the location of the marriage and to her in-laws. Full stop, next para. It is submitted that, as such, since on a previous occasion the petitioner was granted 15 days parole, but he returned duly to the Alipur Central Correctional Home after the said period, without any police security, the same order should be passed in the present instance as well. For sub next para, learned counsel for the state submits that there is a time lapse between the prior occasion when parole was granted to the petitioner, which was in 2014, and the present occasion. For sub next para, it is submitted that at that juncture, the trial was going on, whereas the petitioner has been convicted now. For sub learned counsel places reliance on section 62 within bracket 3 of the West Bengal Correctional Services Act 1992 and argues that that within the contemplation of the said provision, the prisoner can be released for a period not exceeding 5 days only in case of any emergency such as serious illness of his near relative or friend or marriage of his son, daughter, etc. Next para. There is no doubt in the present case that parole has been granted to the petitioner, which in any event cannot be reopened. Next para. As such, the provisions of the 1992 Act have already been exhausted. Next para. The consideration here is whether, in view of the petitioner being previously released under similar circumstances for 15 days, without any security, the same favor can be sought by the petitioner. Next para. The violation here is not of any statutory right of the petitioner, but of the fundamental right of the petitioner to live with dignity as assured by Article 21 of the Constitution of India. the petitioner is justified in submitting that if the petitioner goes to attend his daughter's wedding with strong police guard, the same would undoubtedly jeopardize the petitioner's daughter, apostrophes, family prospects in the eye of her in-laws and the invitees. Full stop. Next para. As such, looking into the circumstances of the case, there cannot be any reason why the favor extended to the petitioner on the last occasion of parole in the year 2013, which was for a longer period of 15 days and was without any strong security, which ended in the petitioner returning duly to the Alipur Central Correctional Home, the same favor should not be granted to the petitioner now. Full stop. Next para. Accordingly, WPA 25391 of 2023 is disposed of by modifying the parole granted to the petitioner with the order dated October 12, 2023, to the extent that the petitioner shall be on parole for the 5 days stipulated therein, however, not under strong police guard as mentioned in the said order. Full stop. Next para. The petitioner shall be accompanied by minimal police personnel, who will not be in uniform during the entire period and shall be stationed immediately outside the venue of the marriage during the entire period of the marriage. Full stop. Next para. The said securities shall not intervene in any manner with the performance of the due rituals by the petitioner during the entire period of marriage and shall only escort the petitioner from the correctional home concerned to the venue of the marriage and remain in the vicinity of such venue during the entire period, and at the time of return, accompany the petitioner back to the Baripur correctional home. Full stop. Parties shall act on the server copy of this order without insisting upon
7 days, excluding 7 days travel, because to Haryana it requires up and down, they require 7 days travel to
It's
Haryana.
already there,
5
excluding
days
traveling
যেখানে
time.
বলেছি না, সেখানে যেখানটা 5 days একটা বলেছি excluding travel time, that is already
It's
there.
already mentioned.
I am modifying only the last remark portion.
Great.
Great.
Thank you very much.
11.
Yes.
For the petitioner.
Yes.
Yeah, for the state respondents, my lord.
Puja permission, Durga Puja.
I'll give you leave to hold puja in 2024.
No, my lord. All formalities complied with, my lord. All formalities complied, only OTP,
Private puja, this is private puja.
Barwadi private.
Barwadi.
Barwadi
Barwadi doesn't mean private. Have you got the permissions they require?
My lord,
No, my lord.
electricity bill is already and all other formalities, pollution control board, all are made, my lord.
Which authority has to consider now?
My lord, the SDO and police authority, my lord.
My lord, I
Direction
got the
to give to
instruction
That
from the police authority, my lord.
My lord, just to
what is the instruction?
for a
Yes.
stepmother treatment being done, my lord. All puja committees near vicinity got their permission.
Well, stepmotherly treatment is actually obsolete now. Stepmothers are often better than own mothers. We are seeing so many litigations. I mean, stepmothers may be better than your original. Yes. What is the objection?
My lord, kindly see last paragraph, Roman 5, my lord.
Please give a copy to him. Without a copy, I cannot take up the. Give a copy to him. See paragraph 5.
And 6 also, my lord.
5 and 6, yes. It cannot be held at a bus stand. No.
My lord, by the side of the bus stand, no obstruction is being made, my lord. The clear picture was there.
After this, even if I direct them, they'll refuse.
No, my lord.
What no?
Already the
Some discretion has to be left to the authority.
secretary of the Puja Committee, being the practicing advocate of this honorable court, he has
Can
been
I release on
acted-
personal ground?
My
Can I
lord,
release on personal
No,
ground?
my lord, come on.
You're showing the advocate and
No, my lord. As an advocate,
No,
Not made. the
cannot get any
application.
permission after
My
5.
lord, not made the application, but as a advocate, as a private person, he made the application.
I've never seen him practice here.
My lord, he is mainly in Alipur, just got membership in Honorable Court. Just
He has better business to do during puja. Prepare
No.
for the next matters which
Sir.
will be taken up. His
No,
litigations which will be
my
taken
lord, please,
instead of
confirm
going into this puja
for
affair.
holding the puja, my lord. Please
No.
confirm.
No,
My lord, all formalities.
you are holding it in a bus stand adjacent to a bank.
Just beside there was no
Not
obstruction.
only that,
is
without
being made,
permission, you have constructed already. Probably because you are an advocate showing
my
that.
my lord,
Apparently so.
no obstruction being made, my lord.
Authorities are saying obstruction.
No,
Who am I to say no?
It's a congested
clear
area, my lord.
picture.
And you are coming in the last day before the puja.
Bus terminus.
We need to file the application.
My lord, all application being filed, my lord. In all authorities, the
No, my
application
lord,
is being-
17th October, you file the application.
Yes.
Why did you wait for so long?
My lord, pandals are being erected and that is being
After
Still, my
arranging everything, they are now.
Anyway,
Yes,
reject
for
with
your lordship.
appropriate reason. Give this as a reason. I'll direct you to consider within 24 hours and give them a reason. Same reason.
my lord, please grant the permission.
Learned counsel for the petitioner
No, already
submits that
idol
the
has come.
petitioner seeks to hold a puja.
My lord, idol has come, my lord. Already idol has come, my lord.
Nothing doing.
No, please, in the
Nothing
name of
doing.
Durga, my lord.
What? Definitely not in a secular court. Definitely not. Definitely not.
No, not in the
What is that?
canal side, my lord.
Show it to Mr. Probal Mukherjee. I'm appointing him as amicus curiae.
Yes, sir.
He will decide. Whatever he decides, I'll do.
Not in Boston, my lord, by the side of the canal.
No, no.
The Goria station road, my lord.
Okay, বাধববাবু কোনখানটা ছাড়লাম বলুন একটু সেন্টেন্সটা। That the petitioner wants to organize, seeks to hold a puja. However, the application for such purpose is not being considered by the respondent authorities. Next para, learned counsel for the state hands over written instruction authored by the inspector of police of the Narendrapur police station, which is the local police station of the area, which indicates that the puja pandal is being built by the petitioners at the 45 AB bus stand adjacent to the Allahabad Bank, Goria, without obtaining permission from the concerned authority. It is further submitted that the petitioners did not ask for permission under the banner of Sonarpur Uttor Bidhan Sabha Sharadutsav Committee at the said bus stand. Next para. As such, it is contended that there was no occasion to grant any permission to the petitioner. Learned counsel for the petitioner controverts such allegations. Next para, be that as it may, since the petitioner has duly applied for permission to organize a puja, keeping in view the sentiments involved, the WPA 25465 of 2023 is disposed of by directing the respondent authorities to consider the petitioner's representation for holding a puja within 24 hours from now, that is by 12:30 p.m. On October 20, 2023, and convey the outcome of the same to the petitioner. No rest to cause urgency. After line add report file to be kept on. Next.
Item 12.
Yes. Dekech? 12. Yes. Mr. Mukherjee, 12. Yes.
Yes,
Hearing
Lord,
better.
no, Lord, will not, Lord,
Well,
bothering your
they have
lordship
fi-
this side of the vacation. Your
They
lordship
have filed
extended,
their
Lord.
opposition, we have to file our reply. Their
Excellent.
factual
Yes. File a voluminous reply. I'll give you 2 months for that.
No, 1 week after vacation.
And the
It is
affidavit.
within time, Lord. Your lordship extended on 16th. We have filed this.
Thank you. The affidavit in opposition filed by respondent numbers 2 and 3 today be kept on record. Full stop. On the prayer of learned counsel for the petitioners, the time for filing reply is extended till November 24, 2023. Full stop. The matter be listed in the monthly list of December 2023 for final hearing.
Lord.
Interim order is already there.
Yes.
But
The-
application,
this is on the application.
Well,
Lord.
this is, well,
This is an application, there is no
come under the heading application.
ঠিক আছে, যেটা বললাম ওটাই থাকবে, appear on such and such date under the heading application.
Agreed.
Thank you.
13.
Item number 13, my lord, Mr. Shubhendu Bandyopadhyay is for the petitioner, my lord, kindly make it, my lord, after vacation.
On the prayer of the petitioner, the matter is adjourned till after the oncoming puja vacation and shall now be listed under the regular heading.
My lord, on item 52 also, my lord, same.
When it is called on. Yes. If it is called on, unless it is called on, why should you pray? I mean, it will automatically go up. Yes.
14.
14, my lord, I appear for the private respondent. It's a hearing matter. I am being led by Mr. Pratik Dhar. He is, my lord, personal difficulty. He is not today in court. My lord, kindly take it up.
You are enjoying an interim order?
No, there is no, nothing is there. My lord,
Take it up
hearing
after
matter.
I'll take it up after the vacation. You are for which respondent?
Private respondent.
On behalf of the petitioner, lordship.
You are also praying for time.
Nah, on behalf of the petitioner, lord.
Move the matter.
No, lordship, I'm praying for adjournment today.
On the prayer of land council for the parties, the matter is adjourned till after the oncoming puja vacation. Full stop. Then it has to appear under the normal heading.
Heading, hearing.
Full stop. The matter shall be listed next under the regular heading. Or true? Regular heading kintu khel. Thank you.
15.
15, my lord, I am for the petitioner in this matter.
Yes.
In this matter, my lord,
Right.
affidavit and opposition has been filed. Affidavit and reply 15. Reply was supposed. My lord, the fact is this, in short, my lord, the petitioners are the paternal aunts of a child who is residing in a home, my lord. Actually, at their instance only, the child was taken to the home.
Once an opposition has been filed.
Yes, my lord, already filed.
Opposition is not on record.
My lord, it was filed.
দেখো ভালো
It
করে।
was filed.
Please check up. এটা opposition? না তো এটা। I'll just check up. Give me half a minute, please. Yes. এটা application. এটা opposition. Application.
Lord, kindly see the last. My lord, actually, they have printed it as application, but it is the opposition.
Oh, acha. Very good.
On the
Please
cover
move that.
page, yes, my lord.
You are the maternal aunts.
Paternal aunts.
Paternal aunts. Right. Pishi.
My lord, the father of the child has already expired. Actually, my lord, the gist of the story is this. My lord, the child is a 10 years old child. His father was totally detached from the family. The child belongs to a well-educated family, but father has certain bad habits, my lord. He was alcoholic. He had certain criminal associates and all. So he was totally detached from the family. Later on, when they came back, the
Mother, what did you have?
mother is alive.
Alive, yes.
But still, she at this moment, she is also very reluctant to take care of the child for two reasons, my lord. My lord, kindly see my annexure 1, P1.
What is the relief you are asking?
Relief the child. Initially, the petitioners used to visit the child at home. In the concerned home where the child was staying. But on and after 2019, my lord, they had a telephonic communications because since due to the COVID.
Child is a she.
He, boy.
He is residing with his parents now.
No, in the home. He is still residing in the home. Parent is not parent. The
How
mother.
did he reach the home? I mean, why was he placed in the home?
He was placed in the home with because of this.
By the CWC?
Yes.
Child Welfare Committee.
Child Welfare Committee.
Now you want a visitation to the child?
Yes, my lord. But because they used to visit the child occasionally, but after the emergence of COVID, my lord, they had only telephonic communication. And after August 2021, my lord, there has been certain changes in the CWC committee, my lord. And from then onwards, the home did not have any objection in the visitation. But they are always telling the CWC is not permitting. The ground of not permitting by the CWC is that the petitioners are neither the biological parents nor the foster parents, so they will not allow. But my lord, there are certain evidences that the home or board of the home also informed the petitioners that only because of the petitioners, the child had a family feeling, my lord. He came to know that he has a family, he has some aunts, he has some uncles and everything. And he had developed some positive changes also because they are occasionally taken to the psychological.
Is that reflected somewhere?
I have stated it, but there is no document over here, my lord.
Obviously.
And even the CWC knows very well.
Let us hear the CWC because they are objecting.
appearing on
CW.
behalf of the state as well as CAWC.
Yes, yes.
Now, my lord, the concern for the petitioner for the child is appreciated. Now, the difficulty is this, as per statute, save and except biological parents, the CWC cannot permit anybody to visit the child at this stage.
Please just
Now, my lord, kindly appreciate this, my lord. The mother is there, so my lord, without the petition, the child presently is placed at a home. So, my lord, subject to, my lord, it may be an order of this honorable court, or
No,
my lord, otherwise, my lord, she is not the
Miss
biological
also, I am
parent.
just
My lord.
wanting to know what
lord.
is the frequency in which the mother visits the child. I want to know that. If the frequency is very little, then I'll give them.
My lord, regarding that, I have to,
Visits
my
her
lord,
when she is called for.
Please wait till after the vacation. I'll put it at the top after the
Kindly
vacation.
give me
No,
my lord,
I'll
kindly,
take a report. I'll dispose it
my
off.
Since 2021.
If I give you a right, I'll give you a right so that I'll make an arrangement so that you can visit regularly.
Presently, and my lord, one thing, the child actually due to the graduation, due to the change of age, my lord, they are shifted from home to home. Presently, the child is residing in Center for Crisis
So I'll keep
Intervention
the matter
Center.
pending because they'll have to disclose where the child is now.
Yes, ma'am.
Yes, my lord, the child is
I'll
at,
not dispose of the writ petition now. I'll keep it pending.
so my lord,
The petitioners are paternal aunts of a minor child who is placed in a home. Full stop. Next para. It is submitted by learned counsel for the petitioners that the mother of the child is reluctant to visit the child. Full stop. The father of the child, on the other hand, comma, has criminal antecedents. Full stop. Next para. It is argued that the petitioners are the only persons with whom the child feels comfortable and had the taste of a family life prior to being placed in the home. Full stop. Next para. The petitioners seek a visitation right to the child, but contend that the CWC, that is the Child Welfare Committee, is objecting to the same, comma, although the home does not have any issue as such. Full stop. Next para. Learned counsel appearing for the state stroke CWC submits that under the provisions of the concerned statute, comma, it is the biological parents, comma, who, if available, are the persons who are permitted to meet a minor child placed in a home. Full stop. Next para. The petitioners do not otherwise have any locus standi to visit the child. Full stop. Next para. Since the case involves a minor, comma, the matter is required to be handled sensitively. Full stop. It remains to be considered as to whether the minor child is actually facing neglect from its parents, comma, prior to finally deciding this issue. Full stop. Next para. For such purpose, comma, the CWC is a party.
my lord, yes, CWC
Respondent
is a
number
party.
2.
Hence, comma, the respondent number 2, that is the Child Welfare Committee, shall file a report on the next returnable date, comma, with an advance copy to the learned advocate for the petitioner, indicating as to the frequency and dates of the visits to the child by the child's parents.
My lord,
No, my lord, the father
already
is not
expired.
there.
Child's mother,
My lord.
during the entire period of the custody of the said minor child in its present home. That is respondent number 4, Ashirwad Boys Home.
No, not presently at Ashirwad Boys Home,
Then?
my lord. Now, at present, he is at Crisis Intervention Center for Male. It is at Rusha Road, my lord. He was in Ashirwad Boys Home.
Present কথাটা
Under
বাদ দিয়ে
the
দেবেন।
Foundation, my lord.
আচ্ছা, during the entire period of the child's custody না করে child's stay in various homes under the respondent number 3, that is the Hope Kolkata Foundation. Full stop. The matter shall next be listed. When should I keep it?
My lord, kindly make it 2 weeks after vacation. And my lord, my humble prayer, subject to correction, will your lordship be kind enough to direct the writ petitioner to make a mother a party to the writ petition? Because my lord, her presence is required. Lordship, she has made allegations. My lord, she is concerned about the child, but she has made
Cannot
reckless
bypass the mother.
allegations. Yes. So my lord, mother may be included as a party. My lord.
Foundation, my lord, the mother is repeatedly touch with the home, my lord.
Yes.
Report, my lord.
So my lord, mother may be
My lord,
incorporated as a
kindly
party.
come to annexure P2, my lord.
So next para, the matter shall next be listed fairly at the top of the list on December 1, 2023
My lord.
for passing further orders. Full
My
stop.
lord.
Next para, learned counsel for the respondent number 3 files a report, comma, which indicates that the mother of the child is in touch with the child
My
all along. Full stop. Next para, a copy of the report be served on the learned advocate for the petitioner during the course of the day.
My lord.
Full stop. The petitioner will be at liberty to use a rejoinder thereto if necessary, comma, on the next returnable date, comma, also with advance copy to the respondents.
Right.
Full stop. Next para. Since
Right.
certain aspersions have been
Right.
cast on the mother of the petitioner of the minor child as well, comma,
Right.
the petitioner shall implead the mother of the minor child as a party to the writ petition. Full stop. Necessary consequential corrections in that regard shall be carried out to the cause title of the writ petition by the learned advocate on record for the petitioner during the course of the day, and a copy of the writ petition be served on the added respondent. In the meantime, full stop, an affidavit of service to that effect shall be filed on the next returnable day.
Grateful to your lordship.
My-
My lord, if your lordship kindly note one thing, the father of the child expired in 2020.
Expired.
Yes, my lord.
My lord,
আচ্ছা,
That is the main.
সেকেন্ড না থার্ড লাইনে লিখেছি দেখবেন সেন্টেন্সে ফাদার হ্যাজ ক্রিমিনাল অ্যান্টিসিডেন্টস
হ্যাঁ।
ক্রিমিনাল অ্যান্টিসিডেন্ট কেটে দিন মারা গেছে
My-
হ্যাজ এক্সপায়ার্ড হ্যাজ সিন্স
Expired in
এক্সপায়ার্ড
July 2020.
হ্যাজ
My
সিন্স
lord.
এক্সপায়ার্ড
Grateful to your lordship.
থ্যাংক ইউ
My-
Correction address and in other and
16.
yes
May please, your lordship. I am for the, this is not electricity.
not electricity you don't have any locus standi
Before that, my lord,
Yes.
petitioner deposited 1,40,000 as mutation fee wrongly.
Hmm.
For that, petitioner made representation, that is the next annexure, to refund the money. Thereafter to higher authority, legal notice, but they have not refunded the money. That is, my lord, annexure P1 is the
which authority should refund Mr. Haldar
that is the land and land reforms refugee and relief authority is, my lord, respondent number 2 is the
yes
17.
both are
So
same.
16, I am appearing for the.
Same cause of action. Two writs has been filed.
first I'll dismiss 16 then I'll dismiss 17
17. I am
Both the matter I am
No,
petitioning.
it has to be
I am
inquired
appearing
because my lord, kindly.
different petitioners why two matters
Same petition.
Same petition,
Same cause of
So
action.
একই করেছো পরের
1,40,000.
no, no, দুটো amount.
No, because in item
One
number
is-
16, man, I do not know about 17, page 9.
yes Mr. Haldar you know about both
Both I know, but one is 1,40,000, other is
2
2
lakhs.
lakhs.
প্রথমটা 2 lakhs. যেটা 16
there were
No,
two
no.
separate deeds which were sought to be there two properties which are sought to be mutated
Yes, and for that we paid
My lord,
wrongly.
my lord, kindly allow us to
Then-
take instruction on this because my lord, he's
you are appearing for you are his counterpart in 17
1,40,000.
in my case 2 lakhs, man, according to and whether
and different
17 টা পড়ে দেখি তো।
আচ্ছা 16 17 দুটোতে কমন একটা অর্ডার হবে
and
in
my lord,
both the writ petitions comma similar reliefs has been sought by the petitioner for sub allegedly the petitioner deposited excess mutation fees for sub subsequently upon the petitioner's representation for refund of the same comma the same has not been granted by the respondent authorities for sub next para to enable learned counsel for the respondents to file a report on the next returnable date with regard to the stand of the respondents as to the actual amount to be refunded to the petitioner, comma, if any, comma, the matter be placed for hearing under the heading upgraded matters on December 1, 2023, full stop. On the said date, comma, the respondent shall file respective reports in that regard with advance copies being circulated to the learned advocate on record
may
for
I
the
make
petition.
one more submission. my lord, kindly keep the point of maintainability open, because if it is under the specified act, under the West Bengal Land Reforms Act, possibly the tribunal would be the appropriate.
Very
forum.
well. Since a question of maintainability has also been raised, comma, the same is also kept open to be decided at the final hearing of the writ
My lord,
petition.
I request my learned friend to give notice of this upgradation. This, my lord, today, yesterday, from yesterday, my lord, the government departments are closed. My lord, we could not get any instruction. No, no.
আবার টাইম পেলে তো
Well,
18.
May please, Lords.
yes,
Is a tender floated.
yes.
My grievance is it has not been finalized.
I filed an application.
This
for
is regarding
addition of
uncooked diet or cooked diet?
Cooked.
I
Cooked
filed an
that,
application for
kindly
addition of
allow
party
it.
which is pending. Now, no notice has been served. It was mentioned before Justice
Kindly allow it.
Bharat without serving any notice. I served my application for addition of party.
What is the relief you are wanting?
I am asking for a relief that let them finalize the tender, because time of the quotation is 180 days. So that will lapse. So rate which has been quoted by all the parties, including his client, will be.
You are also a participant.
I have participated.
I'll add you, I'll dispose of the writ petition
Dispose it
directly
up
to do this.
on the basis of our representation.
No,
let
then
them
I
file.
have some objection, my lord,
What is
because
the objection? Yes.
the objection is, my lord, this is not a simple representation. Your lordship kindly consider no copy has been
When
served.
does the 180-day expire?
There are several allegations.
When does it expire?
11 November.
My lord's allegations were leveled against 21 bidders,
Let-
including my client.
Consider it.
Now, my
What
lord,
is harm
my
is
learned
considered.
senior friend's client cannot dictate the tender authority, my lord, how they will process, how they will proceed. Now, the question is, my lord.
The Ganguly is for the tendering authority.
My lord, we have to state. Tendering authority.
Yes, tendering authority. Now, my lord, this is your lordship. Kindly consider the representation once, my
Kindly
lord.
consider.
Several allegations were leveled, frivolous. Now, if my lord, your lordship direct the authority, my lord, to consider the representation, my lord, kindly give us also an opportunity
Yes.
so that we can, my lord, make
Yes.
submission. Because my learned senior friends, clients, my lord, in my submission, my lord, they have violated the
So
clauses.
they'll have to close the tender process within 180 days. That is what
No,
they're saying.
Rate quoted by the parties is 180 days.
180, that's why you are asking them to wind up the tender process
At
within.
that time, upon consideration, my represent after hearing the parties, I have
There
no
is no
problem.
such provision, my lord, to make representation.
What is the representation
I
about?
have a representation
Why
because
a
I
bidder
say
will,
the some bidders have does not having the bid qualification.
that the committee will decide.
Let them decide.
But
I'm
why
asking
the
for that.
representation, my lord? Why representation? Why they will, my lord?
No, they can give a representation if they point out
There is
irregularity.
no provision, my lord. In
No,
the
not
tender,
necessary.
there is no
Not
such
provision.
term. Why, my lord, they will, my lord, in a particular manner, my lord, brief the tender evaluation committee.
Where is the representation, Mr.
Page 37, 39.
Allegations against 21 bidders.
Yes. Whatever there, let them consider it.
And none of them are party.
right has not accrued.
তুই কি ভয় পাচ্ছিস রিভিশন করলে তোরা পাবি না
না না এই মানে যে সমস্ত এলিগেশন ওয়াইল্ড এলিগেশন
আর ওয়াইল্ড হোক আর যাই হোক ক্রিয়েট হয়ে যাবে
You obviously, if they decide it, they'll have to give you a right of hearing. Learned counsel, learned senior counsel appearing for the petitioner contends that the quotations issued were in terms,
tender issue
sorry, the quotations issued, the quotations given by the participants in the concerned tender process were for current rates, full stop. It is submitted that the outer limit of the tender was
out of the validity of the quotation.
Was required to be 180 days, comma, since the same coincides with the validity of the quoted rates. Full stop, next para. It is also argued that since a representation regarding certain irregularities in the tender process have been given by the petitioner, comma, the same be considered by the tender issuing authorities. Full stop, next para. Learned counsel, have you filed an application?
Yes, yes. Can 1 of 20.
Learned that is appearing today also.
I do not know.
Appearing
Yes, 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 yes. Yes.
Acha. Next para. The applicant in Can 1 of 2023 is one of the other participants in the tender process and seeks to be added as a party. Full stop, next para. Since the said applicant is a necessary party, comma, Can 1 of 2023 is allowed, comma, thereby impleading the proposed added respondent as a party to the writ petition. Full stop, next para. Learned counsel for the added party submits that since the writ petition seeks a representation to be considered by the authorities, the persons stroke entities against whom allegations were leveled in the representation were required to be impleaded as parties to the writ petition, which has not been done. Full of that apart, it is argued that there is no provision in the tender document for such representation being considered by the authorities. Full of next para. Heard learned counsel for all the parties. Full of next para. The petitioner has raised certain grievances in its representation. Full stop. Even if there is no specific provision in the tender document to consider any representation, instead of a post-mortem after the tender process is over, the petitioner has sought a biopsy rather than an autopsy by pointing out certain perceived irregularities. Full stop. It is not in doubt that in the event any order is passed or the representation is considered, the respondent authorities are definitely required to give an opportunity of representation stroke hearing to all the persons against whom allegations have been leveled in the said representation. Full stop. However, for the ends of justice and to ensure transparency in the tender process floated by the state authorities, it would be appropriate if the representation of the petitioner is duly considered by the authorities. Full stop. As far as the other aspect of the matter is concerned, there is justification in the petitioner's contention that since the quotations given by the participants were for a period of 180 days, the tender process ought to be concluded before that period in order to ensure that the tender does not become infructuous. Full stop. Next para. Hence, WPA 19281 of 2023 is disposed of by directing the respondent authorities to consider the representation of the petitioner within 3 weeks because of the pujan, 3 weeks from date, by giving an opportunity of representation stroke hearing to the petitioner as well as all the entities against whom allegations have been made against the representation.
Who are all bidders?
Pardon?
Who are all bidders?
Full stop. Next para. The outcome of the said consideration shall be intimated to the participants therein. Full stop. Next para. That apart, the respondent authorities shall also ensure that the tender process is concluded by Mr. Basu. Both cannot be done together. If they have to consider your representation, how can they conclude it within November 11th? That would be too early.
They given 3 weeks time.
2 weeks. Even
Now,
then.
my lord has
Today
said-
on 19th, 3 weeks.
Can you make it 2 weeks then?
No, it's
Very difficult to give notice to all of
No, when the tender will be when the tender will be opened, all bidders is to participate. And allegation, whatever there is against.
What
all
is the
bidders.
last date for opening of the tender?
10 finalize 10 November.
Cannot be finalized by that.
My lord, kindly extend for 1 week, or your lordships can.
Shall be concluded বলে ছেড়েছি? Shall be concluded as expeditiously as possible thereafter, positively by November 17, 2023. Full stop. No less to cause charges.
Because they are all bidders, so they have to be.
Shall be finalized. Shall be finalized by concluded.
Grateful.
Tender process shall be finalized. Thank you.
Wish you a happy puja.
Thank you and same to you, all of you.
My application has been allowed.
Allowed.
Grateful.
We started with by allowing your application.
Great.
19.
My lord, I'm for the petitioner.
What is the matter?
Affidavit of service.
Good service?
My lord.
Yes. Please move the matter.
Lord, private respondent makes unauthorized construction in front of the PWD land. And my lord, learned advocate of the petitioner makes a complaint before the several authorities, and they does not take any initiative.
Private respondent has been served.
My lord.
Usual order, Mr. Ganguly, consider, inquire,
Yes,
consider, take steps.
That is there in the statute, whatever it is.
The petitioner contends that unauthorized encroachments and constructions have been made by the private respondent on public property. Full stop. Next para, a representation was made by the petitioner, which has not been considered according to the petitioner. Full stop. Next para, heard learned counsel for the parties, full stop. Since the private respondent is not represented despite service, comma, further notice on the said respondents is not directed. Affidavit of service filed to be kept on record. Full stop. Next para. In view of the above observations, comma, WPA 20191 of 2023 is disposed of by directing. Who should be directed, Mr. Ganguly? Who is be the appropriate?
Respondent number
2 and 3.
no, no. একজন করবে executive engineer is good. Respondent number 2. He is
I'll direct both, but directing respondent numbers 2 and 3 to act on the representation of the petitioners and hold an inquiry within 4 weeks from date, comma, if necessary.
Kindly make it 6 weeks, my lord, but because 6 weeks will be, oh, this is, my lord, nothing will happen.
That's
Whatever
very
it is,
well.
it has to be
Within
decided.
six weeks from date, comma, if necessary, by holding appropriate inspection and looking into relevant documents. Full stop. Upon such inquiry, comma, if the said respondents are of the prima facie opinion that illegal encroachment stroke construction has been made on public property belonging to the PWD, full stop, the said respondents shall take immediate steps thereafter to ensure that due proceedings are initiated under the appropriate provisions of law governing such encroachment at the earliest. Full stop. It is expected that such proceedings shall be initiated in such case within a further period of 4 weeks from the date of completion of such inquiry by the respondent numbers 2 and 3. Full stop. Next para. WPA 20191 of 2023 is disposed of accordingly. No rest to consult.
Grateful.
20.
Right, my lord, I am appearing, but due
Yes,
to my
yes.
eye trouble, I am giving lip to my.
Oh, yes, yes, absolutely. He's
Keep
competent enough. Have you served on the other side? That is
Yes,
the main
yes, my
question.
lord. I have.
Appearing, yes. Mr. Bhattacharya, please take your seat. Please take your seat. Yes. Thank you.
My lord, I am a honors graduate in economics and a qualified chartered accountant. I started my career from Pricewaterhouse, and it is one of the global audit firm. And thereafter, I had worked in different reputed multinational companies. I had worked as assistant finance manager of CSC, then Tata Timken. I had worked as finance and accounts head, and as financial controller of I had worked as general manager of Reliance Industries Limited, Jamnagar. I had worked as financial controller of Cummins India, and thereafter I had worked as general manager business finance of Hindalco, and thereafter I had come back to West Bengal to give my expertise in the field of accountancy. So here I had been absorbed by the respondent number 10 company on a consultant basis. My appointment letter is given in page number 45, annexed P1 by Westinghouse Saxby Pharma Limited, a government company. And my duties and responsibilities were long. I had been as a chief financial officer, my appointment, but it is a contractual, and I had been paid 1/10 what I used to receive as a professional fees of rupees 55,000.
What is your present grievance?
My present grievance is when I joined here, my lord, I have given the explanations in page number 9, 10, 11. There was a huge backlog work, and prior to my joining, the audit report has several qualifications, as because the books of accounts did not reveal the correct state of affairs. So when I joined, at that time, this company was under the administrative control of the Public Enterprise Department, and it was in the transition phase from Public Enterprise to Public Works Department. So the board of directors in the Public Enterprise Department specifically asked me to clear the backlog. I joined on 2nd April 2014, but I had to do the finalization of the balance sheet as at 31st March 2013. Forget about 13 and 14, my accounting work and the other works given to me in my appointment. So in page number 10, 11, 12, and 13, I have specifically mentioned that more than rupees 1,000 lakhs had adjustment entry has been done.
and other doubtful debts had been written off. I have given the explanation, and all total, the ultimate effect in the profit and loss account came to 2,309 lakhs of rupees. So after doing this duty, the subsequent year's balance sheet, once it was audited, the auditor did not give any qualifications. But ultimately, I selected to end my service after about 17 months. Reason being because I had to give full-time time, but my remuneration was 1/10. So when I left, they requested me to work for another 3 months, because at that time there was an implementation of the ERP software called IN. So I worked there 3 months. Then after 17 months, all of a sudden I have come to know that certain inquiry.
You resigned from that?
I resigned from that. That was accepted. Yes. And after resignation, I worked for 3 months again to serve the company. And that was also over satisfactorily. Now, thereafter, much later, I have come to know that immediately after my end of my service over there, as a consultant, certain allegations were made against the managing director then. He is the respondent number 13. So after that, the inquiry started, but not a single notice, no hearing, nothing. Gross violation of natural justice happened to me. And moreover, the inquiry committee was appointed by the respondent number 2 by those persons who were in the board of directors during my tenure. So if there is any allegations, then they are also equally involved in those allegations, if it is true at all, even though I'm not admitting it. So the formation of the inquiry committee was wrong. The methodology followed by the inquiry committee, they did not follow any method at all. There was no show cause, no reply. Then when the matter, they handed over to the respondent number 2, and thereafter complaint was filed before the anti-corruption branch, and anti-corruption branch issued me a summon notice. Only for few hours inquiry took place, but thereafter the FIR was registered. And I had not been.
What sort of interference are you wanting now? If an FIR has been registered, you have to thrash that out.
Yes, my lordship, I'm ready to face it. I have no issues with that.
FIR means, I mean, what is the stage of the, charge sheet has been filed.
Charge sheet has been filed, but no,
your remedy lies before the criminal court, sir.
No, my lord, my humble submission is the inquiry report has a civil consequence. And I had never knew about the inquiry committee that I would have come before this court much before. The documents had been
So what is the relief you have sought here?
My lord, my relief is given in page number.
To quash the inquiry report, why should the court quash the inquiry report at this stage?
My lord, the
investigation is over, charge sheet has been filed. You fight out the criminal.
I have come to know only recently about the inquiry. Now the point is, this inquiry has a direct civil consequence. I have nothing to do with the FIR. I'm not asking to quash the FIR. At least the inquiry should have been done correctly by giving a proper opportunity. And there has been a gross violation of natural justice.
Did you come to know about the inquiry report?
My lord, I have come to know about the inquiry about 11 September 2018, but nothing was given to me. The documents were not provided to me.
When did you prefer this challenge?
I had to come before this Honorable High Court for.
Why did you wait for 5 years?
No, yes, my lord, because I did not have the I do not know what is the allegations against me. So I had to
only come to interfere so that I can interfere with the trial, criminal trial.
Only one point, my lord. If you look at page 151, I had come before this Honorable High Court to give directions to provide me the documents, page number 151.
Yes. That also you came in 2022 only.
Yes, my lord, because I don't have any document. How will I know what has happened against me, what wrong I have done? So by virtue of this order, they started giving me the documents, that too in a pen drive, which are not legible. So after getting some of those documents, I have come to this conclusion.
At best, I can say, I can observe one line that the veracity of that inquiry report, you will be entitled to challenge the veracity of the inquiry report in the criminal trial as well, which you have a right in any event. Veracity of the inquiry report, you can challenge in the criminal trial as well.
My lord, I want to challenge it at the earliest opportunity, because
earliest opportunity, it does not like me out.
For me, because
2018 you came to know of it, you should have challenged.
But no documents. What will I know what has happened against me? On what point will I speak before this honorable court? I had come to know in 2022 after the direction of the Honorable High Court.
After this direction, the copies were given to you.
Yes. Some documents were given before, but those were not, I could not come to a conclusion because the documents which were provided were all illegible.
Where is the inquiry report which you have annexed,
Yes,
which you have challenged?
Annexure P1 and P2. This is on page number. Just kindly give me a moment. Page number 50.
This inquiry report castigates you.
Yes, yes. And another background of the case is during this
The
transition,
inquiry report is only a piece of evidence in the criminal trial, nothing else.
my lord, but I have missed my opportunity to speak something before the inquiry committee, and that to the committee members are those members who were in the board of directors.
All right, let me hear them on this. Yes, Mr. Samanto. Primarily two questions. One is that the same board of directors are part of the committee. How can you do it first? Secondly, inquiry, he ought to have an opportunity of at least representation. Why didn't he have it?
My lord, the two things, my lord. My lord, what happened, my lord? My learned friend's client, the petitioner, received the documents in 2018. Thereafter, what followed?
Receive the documents.
Received the document, the information regarding the
Information is different from documents.
No, no, my lord. I stand corrected, my lord. The
Without the document, Mr. Samant, he won't be able to challenge his right on that.
no, my lord, he ought to have made application before the court below. When he appeared in the court below and took bail.
When he appeared, he made the application.
In 2018. In 2018, he appeared.
No, when was the charge sheet filed?
In 2018?
itself.
My lord. Page 25, para 33.
Oh, trial started in 2018 itself.
2018 itself, my lord.
Very well.
My lord, now it's a belated challenge. Before that, my lord, they came before this court, honorable court, for supply of documents. That was done. Even after that, they have not came to this. And what your lordship is looking at page 50, it is the sole basis of lodging of an FIR. If it goes, my lord, my humble submission, if it goes, the FIR goes, and your lordship will have to decide the entire trial upon on that document, my lord. The trial will be perhaps it will be vitiated, my lord.
I'll give you liberty to take these points before the criminal trial.
My lord, only one submission. Kindly see from page paragraph 25. I have given paragraph wise explanation that repeatedly before the court below, I had been asking for the documents, and since they were not giving me those relevant, pertinent documents, all documents which were provided were not sufficient, I had to move a petition before the Honorable High Court by virtue of the direction in page 151.
When was the first application you made before the trial court for the documents?
My lord, kindly look at page number 20, paragraph 26, page 22. I have given explanation where I have come to know.
When did you make the first application before the trial court?
First application was made, that is referred to, my lord, prior to that, the anti-corruption branch has called me. I have given explanation, nothing has been provided to me in page number 12, paragraph 28, page 23, and thereafter my application started from after receiving notice.
Trial was going on from 2018. After that,
Yes.
February 2018.
Yes, my lord.
That's submitted.
My lord, paragraph 30T, the aforesaid matter was fixed for hearing before the additional district and session judge, Judge Bench 2, City Sessions Court, and the petitioner was provided the copy of the charge sheet and other documents, and the next date was fixed on 4th May, 22nd March 2018, paragraph 33. And thereafter, on scrutiny of the charge sheet and other documents, it appeared that several pages were missing, several were repeated, and several documents were illegible, and some documents were unpaginated. Consequently, the petitioner was not able to understand the nature of the complaint.
Yes, you made an application on 4th of May itself.
Yes, on 4th of May 2018. And it continued on paragraph 35. Again, the matter was fixed on hearing on 15 June 2018. And after hearing the learned advocates appearing on behalf of the respective parties, the learned additional district and session judge directed the inspecting officer to supply
I'll not
the
pass
copy.
any interim order. I'll direct affidavits, but not pass any interim order at this stage. I'll direct them to file affidavits, and I'll keep the writ petition pending. Request to be heard.
Yes, my lord.
My lord, one second. My lord.
Yes.
Kindly come to page 116.
What is it?
116. My lord, in 2017, they were informed that they were informed. The petitioner was informed. with
Learned
regard to
counsel
offence.
for the petitioner has raised certain certain questions which raise a prima facie case for the writ petition to be heard on trial. Full stop. It is contended that the petitioner has been castigated on the basis of an inquiry report, comma, upon which a criminal investigation has started, comma, without giving any prior hearing or opportunity to show cause. Full stop. Next para, that apart, comma, the inquiry committee which apparently authored the report was comprised of directors of the concerned company, comma, who might have, who ought to have been equally castigated, comma, since they were at the helm of affairs of the company during the relevant period, and the petitioner was merely a functionary in the company in his professional capacity as a chartered accountant. Full stop. Next para. Learned counsel for the respondent authorities raises an issue as to why the petitioner did not challenge the non-furnishing of documents to the petitioner during the entire period of trial, comma, since the charge sheet has been filed at as long back as in the month of February 2018. Full stop. Next para. However, comma, learned counsel for the petitioner places reliance on the relevant paragraphs of the writ petition, which give sufficient explanation to the effect that the petitioner, comma, after participating in the trial, comma, coming to know of the charge sheet, comma, sought for copies of the relevant documents as long back as in the month of May 2018, has been trying thereafter, comma, running from pillar to post to get such copies, which ultimately culminated in an application before a coordinate bench, which directed such copies to be furnished. Full stop. Next para. Hence, comma, the matter is required to be heard on merits on the veracity of the inquiry report filed against the petitioners. Full stop. Next para. The respondent shall file their affidavit in opposition by December 1, 2023. Full stop. Reply, if any, shall be filed by December 8, 2023. The matter shall be listed for hearing in December on December 11, 2023. Full stop. It is made clear that nothing in this order shall preclude the jurisdictional criminal court to proceed with the criminal trial in the meantime. Full stop. However, comma, at the same time, comma, the petitioner will also be at liberty to raise the issues raised in the present writ petition before the said criminal court to assail the veracity of the inquiry report, which is the premise of the allegations against the petitioner.
Much obliged.
Thank you so much.
Before your lordship,
Very well argued. Yes.
and my lord, I also wish you are happy.
Thank you, Mr. Bhattacharya, and same to all of you. Thank you. Yes, you.
Before your lordship rise, my lord, item number 66, if your lordship permit me to move before the vacation, when
Why?
there is some urgency.
No.
If your lordship, my urgency is that, but they are admitted, my lord, there is, I worked as per the contract, my lord, tender, work completed.
No, no, sir.
My kindly, my lord.
No, no. Yes.
Kindly leave to move an urgent unlisted motion before the vacation.
What is the urgency?
My urgency is that on my land, the Panchayat has taken over the position and started the making of the pathway, but without giving any native notice.
Leave is granted. Yes. Leave the other.
Lord, I have submission that I am respondent number 13 in this case. Hearing here. And what he said that I have.
You are not representing him.
I am private
respondent. Managing director.
I was the managing director of this.
Achha, you are appearing in person.
In person. And I have a submission that we had appealed in the court for these copies. Till now, we have not obtained all the copies.
I'll consider, please disclose that in your affidavit in opposition. I've directed all the respondents to file their affidavits. Please do that at the time of when if I've given a time for filing affidavits, do that within that period. When I finally hear the matter, please remind me. I'll take that into consideration also.
One submission can I make?
Yes, Mr. Mukherjee.
But because, my lord, I took the loan and work. Now, my lord, bank has filed a case, my lord, that is, my lord, in compliant national.
It is on in the list. It will be taken up after the vacation, Mr. No, no, you can wait for some.
Item number 11, my lord, urgent website copy needed, my lord. Let the parties react to the website copy.
In all matters, that's a matter by default. Urgent website copies are given.
My lord, leave is granted, my lord, 100.
Yes, my lord, may I?
Server copy, about.
No, leave is granted, my lord, to 107, my lord, before the vacation bench, my lord.
Why?
New connection of electricity.
No,
my
no.
lord.
একটা এসছে
এই কোনটা আগে রে সুমনটা না
আছে কিনা দেখো
Supplementary list, item number 1, WPA 25654 of 2023.
So Dr. You're for the petitioner?
24. Well, I have the 2 points in that matter. Well, 2 points in the matter. Well, section 3, subsection 1 of the unauthorized occupancy Act 1962 notice was issued. That notice I will show to your lordship at page 34. Page 34. But this notice was issued on 3rd October 2023. This notice was received by the petitioner on 9th October 2023. Date of hearing was fixed on 10th October 2000. But kindly, the date is very material. Well, kindly, section 3, subsection 1 of the Act, there is a mandatory requirement of 15 days time to issue notice. This is a mandatory requirement. But the notice was issued, kindly see this date, 3rd October 2023, and from the date of issuance of the notice and the date was fixed on 7 days notice was given. Section 3, well, I am reading that section. If in respect of any public land, the collector is of opinion upon application made by an officer of the owner of the public land authorized in this behalf by such owner or upon information received otherwise that the public land is in the unauthorized occupation of any person or persons, the collector shall issue a notice in such a form. Kindly note that in such a form and containing such particulars as may be prescribed, calling upon all the persons to so cause before such date, not being less than 15 days after the date of the notice has been prescribed. You kindly see this section.
You are challenging this notice?
First of all, this notice is challenged.
What is the other point?
Now, Lord, second point, this notice was issued in a formal notice, not in a prescribed format. But a rule provides that a prescribed format has to be given by issuing a notice. But the notice, kindly see, this is a plain formal notice, not in a prescribed format. Section provides the notice has to be issued in a prescribed format. Kindly section 3. Section 4 বই একটাই নিয়ে আসবে
আমার বই নিয়ে এসেছে আর কেউ কিছু নিয়ে আসে
তো বই তো লাইব্রেরি থেকে নিবে
Yes.
My lord. Second, my lord, বই একটু বইটা দেন
এটা দেখো বইটা আছে 62 Act.
The demolition order and the notice was issued by the SDO as a collector. Now, the section 2, the definition of the collector has been given. The definition 2, my lord, the collector means in Calcutta, the land acquisition collector, Calcutta, and elsewhere out of Calcutta, the chief officer in charge of the revenue administration of the district and includes an additional district magistrate, a subdivisional magistrate, and an executive magistrate specially appointed by the state government to perform all any other function of collector under this act. My specific submission that the SDO here has not been specially appointed by the state government to function under the specified act. Therefore, this is a lack of jurisdiction. There is no documents to that effect that specifically the SDO has been appointed by the state government to act under this specified act, to function under specified act. Therefore, the lack of jurisdiction of the order of demolition is also illegal. Can you see section 2?
1962 এটা premises জায়গায় land.
Man, can you say, I am giving that.
আগের পরে তো একটা ম্যাটার এলো একই এক
বই একটা এক্সট্রা
এরকম কোন বই আছে আর বইটা আনিয়ে নাও
Kindly see section 2, the definition of the collector.
Yes, yes.
Therefore, the SDO as a collector has issued this
So you're challenging the notice on these three.
notice and demolition order.
Order has been passed.
Yes, demolition order. 25th October is the date fixed for demolition.
As per the notice.
As per the notice.
Look, where do I get that? Which page?
My lord, order is one of page 38.
You have participated in that?
But this petitioner did raise this objection. Because, first of all, when the notice was issued on 3rd October, I have received the notice on 9th October. I went to this office, I did not participate in the hearing. I raised this objection. You look, this is 15 days time is mandatory.
this notice is illegal.
For an appeal against that before the commercial.
But the DM is not, office is closed.
What office is closed?
On account of puja.
When was the order passed?
When the order was passed on 10th October, I have received the order yesterday. I have received the order yesterday. And DM office is closed from today. 30th November, it will be open.
Once you participate, you cannot.
I've stated that I didn't participate. I raised this objection. That objection was issued by hand. I did not make any submission at the time of hearing because I raised this objection on the ground that your time limit is mandatory, but you have issued this notice by giving.
Which of the resorts is yours?
Well,
which of the resorts is yours?
Which of?
Which of these beach resorts is yours?
Here, my lord.
This morning, Chuti has moved to. Mr. Chuti has moved to this morning.
I'm giving that. Ruposhi Bangla.
Ruposhi Bangla, yes. So today we are on 19th, you got 9 days in between. Why didn't you prefer a challenge?
Well, I have received the order yesterday.
Yesterday?
Yes. I have stated that. I'll see the forwarding letter. 17th October is a forwarding letter. Page 41. Can you see? 17th October forwarding letter. Page 41.
You did not participate in the hearing.
I did not participate. I raised this objection. The objection was.
Where is that objection reflected? Which?
Yes. The objection, my lord, page 18. Sorry,
No,
page
no,
36.
in the order itself.
Hello?
In the order, where is it reflected that you took this objection?
There is no whisper. I raised this objection. Can you page 36? They have received the objection. Page 36. Can you see? And after receiving this objection, they don't whisper about that.
Yes, Mr. Chakravarti.
Now, kindly see paragraph 1 and 2 of the writ petition. Who is he? Who is he? My lord, what is his locus to move this writ petition? Kindly see. Paragraph 2. The petitioner being the original occupier of the land bearing plots supporting Ruposhi Bangla. Well, Ruposhi Bangla participated in the proceedings. He has not come before, my lord. Kindly see page 38, third paragraph. Learned advocates on appear respondent number so and so and Ruposhi Bangla. He appeared. But subject to correction, what is his locus? But supporting Ruposhi.
Supporting Mohanman or East Bengal.
It's like
that's actually misleading. Actually, he's running the hotel.
Kindly see now his objection.
Ruposhi Bangla participated.
Yeah,
participated, lost.
Ruposhi Bangla did not
participate. Please see third paragraph, third or fourth.
The manager of the hotel Emerald.
No, Ruposhi Bangla.
You are missing out, Mr. Dattu. Oversight.
The private respondent Jalishwar and the other and the resort Ruposhi Bangla respectively submitted.
And never took this point.
Some militant vocabulary which are kept on record. That's why, my lord, I
should not have been kept on record.
No, I told
I
raised this. I'm stated
Mr. Dattu, you did not take the Ruposhi Bangla did not take. What are you supporting Ruposhi Bangla?
Supporting, my lord. That was
Ruposhi Bangla participated. Then who participated? Your ghost.
No, I tell you, Ruposhi Bangla, he is running the hotel of Ruposhi Bangla. Now, my lord, I went there, I raised this objection. Page 36. Can you see? Page 36.
Ruposhi Bangla filed its Vakalatnama, did not take this point. Who are you to take a point?
Well, can you see the objection? Can you first of all see this objection? Who raised this objection? Can you see?
Where?
Page 36. Objection to
Subhash Samantu, that is, you are not Subhash Samantu.
Well, some other hotel. Kindly see manager of hotel Emerald something.
There are two.
The next one is of the other hotels.
Yes. There are two hotels. Annexure has been misplaced.
Check the other annexure whether that's there. Anyway, you don't have any locus standi, Mr. Dutt.
No, because when I told Lordship, if this lack of jurisdiction, due to lack of jurisdiction, even the order is passed, undoubtedly writ is maintainable, first of all. Secondly, my lord, I raised this point regarding the jurisdiction. I raised this point regarding the notice that the specified time of 15 days has to be given. This is a mandatory provision. You cannot issue a notice in violation of a mandatory provision. This is a specified act. And secondly, my lord, you have got no jurisdiction to pass this order.
I know what you have argued, but
Yep.
where is your letter? Show me the letter of this person. Yasin Sheikh. Mr. Dotto, I'm rejecting your application.
No, only one,
Petition has been-
only one. I objection, I'm giving the
No, I'm not allowing your application.
Only one.
Learned counsel for the
Only one
petitioner
thing, one-
contents, no, nothing else.
Only one thing, but if this order suffers from a lack of jurisdiction, can I not maintain the repetition?
Learned counsel for the petitioner contents that
No objection.
the petitioner was given a short notice, comma, which is derogates the provisions of the Public Land Eviction of Unauthorized Occupants Act 1962. Or it's a patara bar kore do. Ekta bar kore do. So next paragraph. Learned counsel for the petitioner contends that apart from the fact that the notice was issued on October 3, 2023, comma, disclosing hearing date of October 10, 2023, comma, which is much short of the mandatory 15 days contemplated in the in sections 3 within bracket 1 of the act, comma, the same was not informed. Full stop. Next para, that apart, comma, the issuing authority did not have jurisdiction to send such notice in terms of the act. Full stop. Next para. Learned counsel contends that as such, comma, the consequential order of eviction passed under the said act against the petitioner is bad in law. Full stop. It is argued that despite such objection being taken, comma, the same was not adverted to by the concerned subdivisional officer stroke collector. Which of next parallel counsel for the respondents at the outset, comma, challenges the locus standi of the petitioner to maintain the present writ petition. It is submitted that in paragraph numbers 1 and 2, comma, the petitioner has stated that he is the original occupier of the land, original occupier double inverted of the land in question, comma, our double inverted supporting double inverted clause Messrs. Ruposhi Bangla to run its hotel on the particular plot of land. Next para. That apart, comma, it is contended that if the petitioner is aggrieved by the order of demolition, order of eviction, comma, the petitioner is at liberty to approach before the appellate authority under the said act. Next para. A perusal of the impugned order dated October 10, 2023 clearly shows that Ruposhi Bangla, comma, which is purported to be represented by the petitioner, comma, was represented by a learned advocate, comma, who had filed his wakalatnama, which was kept on the record. Next para. Nothing in the order indicates that the objection as to short service of notice was taken by before the said authority by Ruposhi Bangla. Next para. The petitioner, comma, even in terms of the averments made in the writ petition, comma, is a mere busybody, comma, who does not have any locus standi to challenge the impugned order. Moreover, comma, since the objection raised herein was never taken in connection with the notice before the first authority, comma, the same cannot be opened up for the first time in the writ jurisdiction of this code. Next para. That apart, comma, the alleged objection raised by the petitioner in writing, comma, annexed at page 36 of the writ petition, comma, is authored by someone else and not the petitioner and cannot be a basis of the arguments of the petitioner in any event. In such view of the matter, comma, WPA 25654 of 2023 is dismissed on contest without any orders to cause. For এসে গেছে?
Same order is under challenge.
পরের মামলাটা ডাকবো।
Supplementary. Item 1, WPA 25655 of 2023.
Appearing for the state.
অবজেকশনটা কোথায়? মোটামুটি এরকম করে বন্ধ থাকে, সব প্রয়োজন।
Which hotel is this? Emerald?
Same
No,
order.
no, the objection, my lord, here.
Ruposhi Bangla again?
No, no. This is my Emerald paying.
Emerald, that's why my guess. That was the other
No, no,
hotel here.
here the objection was placed by the manager. My kindly see page.
You are the owner of the hotel at least.
Yes.
But page 40 is the same.
No, order no, the objection will kindly see.
No, object, their ground may be different. That's why Mr. Datta has mentioned all the matters. Even if one succeeds, then the order goes. Yes, Mr. Datta.
This objection, my lord.
Emerald was not represented? Yes, represented. Oh, you are found absent despite service.
Yeah.
So you can take this point.
Yes, that's why.
No, they have got a better case here. State, you have to explain.
Well,
All
first
the
thing-
points regarding short service. No, notice here also short service of notice.
Yes.
Where is the notice?
The notice, my lord,
36.
is 36.
30?
6.
Hearing notice, my lord.
Yes.
Yes, hearing notice.
উনি দুটোর সময় যদি আমার হাতে যদি ব্রিফ দেওয়া হয় ওরকমই হবে। আর তৈরি করছেন ফিজ নিয়েছেন কিভাবে করবো?
There is a provision of statutory appeal.
No statutory appeal. There is a provision of statutory appeal, but that becomes illusory because he did not appear because there was a short service. The initiation of the proceeding against this person is bad.
Look, so far as
You'll have to give a proper notice and give and do it. If it is not
I
proceeded
have
with,
got this 5 minutes back. So it's not even
so
allotted.
your service is still shorter.
It is shorter, my lord. The shortest service, that too in a festive day, my lord.
No, this is not a festivity.
It is Panchami already.
Anyway. So the Emerald gets an order. Emerald remains. Ruposhi goes. You operate your business, Ruposhi's business from Emerald for a few days. I can give a protective order to that effect. Learned counsel for the petitioner has raised a valid question as to whether. Acha, can you tell me for the state, please, can you tell me whether should I allow the writ petition set aside, direct you to give a new notice?
Issued to the parties, my lord. It is not that
No, issued to the parties, no doubt on that.
the 3 notices.
You were not there probably when the matter was called on. The first point is that there is a short service. 15 days is the mandate. Short service. Second point is not in form. Third point is wrong authority. These are the 3 points regarding the notice. And if they don't appear, then the notice points are validated.
My lord.
Would you like to use an opposition? I'll give you that. I'll formally give you that option.
That will allow us to file a report, short report, my lord, on affidavit.
No, then I'll direct you to file affidavit in opposition because today is the closing date. Either I can set it aside, ask you to initiate a new proceeding against them, or I'll direct affidavits. That will be better. Otherwise, you will be at risk because you don't have instruction on it.
But I don't have instruction.
Learned counsel for the petitioner has thrown a threefold challenge to the notice of hearing issued to the petitioner purportedly under section 3 within bracket 1 of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1962. Full first, it is contended that the notice gave only 7 days before the hearing, which is in contravention of the mandatory 15 days required under the said section. Secondly, the notice is not in appropriate format as per the requirement of the Act. Thirdly, the author of the notice did not have locus standi to jurisdiction to issue the same under the Act. Next para. It is pointed out by learned counsel for these respondent authorities that in the meantime, an order of eviction has been passed under the said Act against the petitioner. Hence, the appropriate remedy of the petitioner lies before the appellate authority under the Act. Next para. However, the petitioner has challenged the very root of the initiation of the proceedings, which culminated in the eviction order. In the event the notice prior to initiation of the proceeding, which is a mandatory requirement under the statute, was not was rehearse the law, comma, the initiation of the proceeding itself is bad, comma, thereby rendering the order of eviction bad in law as well. Full stop. Secondly, comma, a question of jurisdiction of the concerned officer to issue the notice itself has been raised, full stop. If the said point succeeds, comma, the only option remaining before the court is to quash and set aside the notice, comma, which would also negate the eviction order passed consequentially. Full stop. In any event, comma, the petitioner did not attend the hearing, full stop, having challenged the notice of hearing itself, comma, the petitioner may very well argue that the remedy of appeal available under the statute would merely be illusory, comma, since the petitioner's version was never placed before the concerned authority passing the order. Full stop. Hence, comma,
I will just interrupt.
the
one.
point of
Milord,
maintainability is
Page 41.
yes.
Milord, there are continuation of proceedings, Milord. I find that here, Milord, apart from the issuing of notice, the private respondents, that is the Jharshar Shamol and three others,
ওই সেন্টেন্সটা কমপ্লিট করানোর is turned down. Yes.
Milord, filed Hajira, the learned advocates for the respondent numbers 1 and 4, that is Ankita Beach and Ruposhi Bangla respectively.
Those are different entities.
Milord, here, Milord, the application has been filed by Pradeep Pradhan, Milord. I do not find, Milord, that
He is the owner of one of the
Milord,
hotels.
Milord will kindly see there is a mix of pages, Milord. In the next page, all the respondents, that is, which mentions all of them, including the Emerald, Milord, is directed to evict the suit. That is the directions, Milord.
No, no, this, my order will be relating to only this, the emerald.
Emerald.
Obviously,
Milord, Milord,
cannot affect the others. How can it?
Milord, thanks.
Next para. Accordingly, an arguable question has been raised by the petitioner for final hearing of the writ petition. The respondent shall file their affidavit in opposition by November 30, 2023. Reply, if any, shall be filed by December 8, 2023. The matter be listed on December 13, 2023 for hearing. Full stop. There shall be a stay of operation of the impugned order dated October 10, 2023 only to the extent insofar as it relates to
Hotel Emerald.
Hotel
Bay Inn.
Emerald Bay Inn, comma, which is represented by the petitioner as its owner. Full stop. It is made clear that nothing in this order shall operate as a stay of operation of the said order insofar as relates to the other entities which have also been directed to be evicted along with the petitioner. Full stop. Such stay in this matter shall operate till disposal of the writ petition. Mr. Dotto, your book is probably lying with my officer.
Item 46 fixed at 2 p.m.
Yes, Mr. Chatterjee, what is the
But
matter?
for the petitioner, my lord, this is a
I am for the distribution license.
My lord, is a Golden Apple Restaurant. Final assessment bill at page 21, annexure P4. 16 lakh 311, my lord. And my lord, I did not prefer any appeal, my lord. I would like to defer, submit any amount subject to your lordship's sanction, my lord.
There's an allegation of pilferage.
Yes,
Unauthorized
Pilferage,
use.
yes,
Pilferage by bypassing the meter.
Then you have to prefer an appeal.
Yes, man, I have to, but regarding the restoration, then,
Restoration, you have to pay the entire amount. Then. No, that is the statute.
but if your lordship kind enough to say hear me for a moment. My lord, this is a restaurant which I have running, my lord, for since a long time. It is not that, my lord, there are some.
It's a commercial establishment.
Yes, it's commercial.
You cannot
establishment.
get an additional advantage above the statute.
I'm ready to deposit the 50%.
No, 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 definitely not. That is the
two installment, my lord. I'm not saying that I'm not.
No.
I have to, my lord.
No.
But otherwise, my lord,
The
the
petitioner
staffs are
runs-
suffering, my lord.
The petitioner runs a commercial establishment stroke restaurant at the concerned premises, full stop. The present challenge has been preferred against an assessment, against a final assessment
Finalist.
within the contemplation of section 126 of the Electricity Act 2003. on an allegation of unauthorized use of electricity by the petitioner. Full stop. Next para. Learned counsel for the petitioner submits that since the petitioner is running a commercial establishment which will suffer a huge loss due to disconnection of electricity in the festive season, the petitioner's connection be restored upon deposit of 50% of the assessed amount for the time being. Full stop. Next para. Heard learned counsel for the parties. Full stop. The provisions of section 126, read in conjunction with section 135 of the said act clearly stipulate that for getting a restoration of electricity connection, if disconnected on the allegation of pilferage stroke unauthorized use, the consumer has to deposit the entire assessed amount. Full stop. Next para. In section 127 of the said act, a provision of appeal is available to an aggrieved consumer against the order of final assessment, subject to the consumer depositing 50% of the entire amount of assessed bill. Full stop. Since the precondition of preferring an appeal itself is 50% deposit of the amount assessed, the same cannot be equated with a larger relief, being a restoration of the electricity connection of the petitioner. Full stop. The scheme of the statute is clear in that regard, and there is no scope for deviation from the same, since the petitioner, being a commercial establishment, is not entitled to any special relief, which would be appropriate in case of an indigent or financially deprived person. Full stop. Hence, there is no scope of interference in the writ petition. Accordingly, WPA 25191 of 2023 is dismissed with liberty, however, to the petitioner to challenge the final order of assessment by way of a regular appeal under section 127 of the 2003 Act. Full stop. If so filed, the same will be considered by the appellate authority subject to the law of limitation and in accordance with law, subject to the petitioner depositing their prerequisite of 50% of the assessed amount. No address to cause urgency.
And my lord, instead of dismiss, my lord, can it be disposed
No,
of?
no, dismiss.
And my lord, if I pay the tomorrow the full amount, my lord, then my lord, it
Nothing-
will be restored. My lord.
Nothing in this order, however, shall also preclude the petitioner from depositing the entire assessed amount with the distribution licensee and the necessary reconnection charges, in which case the distribution licensee shall restore the electricity connection to the petitioner in accordance with law.
I'm grateful, your lord.
47.
Well, 47 is the recreation hall and at the same different.
Marriage halls on the same building.
Same building, the two different parts, my lord.
সব এক হবে, শুধু ওই ইয়েটা রেস্টুরেন্টটা রিক্রিয়েশন হল।
Yes, Golden Apple Recreation Hall.
Recreation and marriage.
And
Recreation hall come marriage hall.
রিক্রিয়েশন হল কাম ম্যারেজ হল, বুঝতে পারলে তো? যেখানটা রেস্টুরেন্ট বলেছি ওখানটা রিক্রিয়েশন হল কাম ম্যারেজ হল, বাকিটা সেম, সেম ড্রেস সেম, এক্স্যাক্টলি সেম।
Great.
Well, I'm grateful, your lord. And a happy puja vacation.
Yes.
Yes, my lord. Yeah. Even after 2, my lord, your lordship.
After the restoration, you can have your dinner in Golden Apple also.
Then I have to go to the Murshidabad.
This is Murshidabad.
But my lord, what about the marriage hall? That is also to be
No,
utilized.
there is an extension. That's the extension.
That governs personal law, so I don't have determination.
Great.
21.
21, yes.
I am for the petition, lordship.
Yes.
Affidavit of
The
service.
respondent CSC Limited.
Lordship,
Usual, Mr. Halder.
complied with all the formalities,
My lord,
lordship.
there are 3 private respondents,
I have
4 to 6, they are the landlords, lordship.
Of them.
I have served everyone. Good service,
My
lordship.
lord, we have attempted twice. First on 28th August, thereafter on 7th
Any
September.
civil suit pending?
No, no.
We attempted twice since the meter board position is under lock and key.
The petitioner contends that the petitioner is an occupier stroke tenant in respect of the disputed premises, which of the petitioner sought an electricity connection in his name, but the CSC Limited could not give the same due to resistance by the private respondents stroke landlords. Full stop. Next para, despite service, none appears for the private respondents. Full stop. Affidavit of service filed to be kept on record. Stop. Learned counsel for the CSC Limited argues that Due to the resistance of the private respondents, the CSC Limited could not even hold inspection.
Yes, Lordship.
Full stop.
Complied with all the
I
formalities.
could not give the connection to the
Yes.
petitioner. Could not give the connection to the petitioner. Full stop. Next pair. In view of the above circumstances, as the petitioner is entitled as an occupier to get a new electricity connection, WPA 22049 of 2023 is disposed of by directing the CSC Limited to give a new electricity connection to the petitioner at the premises in question
And
with-
from the existing meter board position.
within 48 hours from this date or from the date of compliance of all formalities by the petitioner, whichever is later. Full stop. Such connection shall be given from the existing meter board position at the premises. Full stop. In the event an obstruction is raised by the private respondents and or the main and agents, the CSC personnel will be at liberty to approach respondent number 3, the officer in charge of the Ekbalpur police station, to give adequate police assistance, which will be given by respondent number 3 by acting on a server copy of this order at the cost of the petitioner. Full stop. In the event any padlock or other hindrance is put up by the landlords, the officer in charge of the Ekbalpur police station will be at liberty to remove the same for the limited purpose of compliance with the above order. No rest to cost.
Grateful.
48 hours because the
Lordship.
puja is coming. Yes. Thank you.
22.
Madam, for the respond numbers 1 to 4, I'm led by Mr. Siddharthalai, who is appearing in the virtual mode, man.
Yes. Who is for the petitioner?
I am for the respondent number.
Upgraded. Although the respondents are represented through counsel, none appears for the petitioner at the time of call. Full stop. Accordingly, let the matter stand adjourned till after the oncoming puja vacation and shall now be placed under the regular heading in the list.
My lord.
Regular heading. Yes.
Happy pujas, my lord.
Yes, same to you. Right.
23.
23, my lord. Can this matter be taken up after vacation?
No,
Sir,
every
we will
matter of
propose,
yours.
my lord.
Every matter of yours. Why?
Hmm.
I am opposing. Why?
But this is not when there are.
Then it goes under the regular heading. That is what he'll have to suffer.
No, Lordship.
I've been consistent on that.
Difficulty that Mr. Dr. Madhusudan Sara is appearing.
You are there also. CSC Limited.
But there is no instruction in this. Otherwise, I wouldn't have paid. But kindly see there
I'll
is a
regularize
letter.
your appointment. Yes. What is it?
আরে আমি জানিই না কিছু।
আমি কি করব? Lordship, I have served CSC.
No private respondent is
No
there.
private respondent.
মানে it is in respect of
Petitioner is a tenant, Lordship, applied for new connection. The CSC authority, Lordship, kindly sees the annexure P2, page 10, Lordship.
I'll direct another inspection. Let that be done. I mean, you show the alternative place, they'll give a report. Saved?
Lordship, no alternative place is there. Petitioner is a tenant. He have to
we'll
keep
come back with the
connection.
No, if there's no alternative place, then
Only one existing service position. So
I will place the report on the reopening. my lord.
an adjournment is sought by the CSC Limited. Full stop. Accordingly, let the matter stand adjourned for the day. এটা কিন্তু আপগ্রেডই থাকবে।
I'm obliged, man.
get inspection দিল।
না, adjourn করবে। Inspection দেবে?
Inspection is not required. If you say there is no alternative, I'll directly
No.
direct.
Lordship,
24.
I am for the petition.
My lord, in this matter, Mr. Suman Ghosh is appearing.
So what? You were there also.
My lord, I don't have any instructions. And
What is the matter?
Lordship, in this matter, petitioner applied for an industrial connection with the CSC authority, but no steps has been taken till today. Lordship, I have annexed the trade license.
An adjournment is sought by the CSC Limited. Let the matter stand adjourned for the day.
Grateful.
Twenty-five.
I am for the petition. Lordship. 25.
Landlords,
Affidavit of service served.
usual order. You have completed inspection.
All formalities complied.
Complied.
Security deposit.
Despite compliance of all formalities by the petitioner, who is an occupier of the premises in question, The CSC Limited could not give the connection due to resistance by the private respondents stroke alleged landlords. Full stop. Next para, learned counsel for the CSC Limited corroborates such contention. Full stop. Since despite service, none appears for the private respondents, the matter is taken up for hearing in their absence by keeping on record the affidavit of service filed today. Full stop. In view of the above circumstances, comma, WPA 22765 of 2023 is allowed, directing the CSC Limited to give electricity connection to the petitioner within 48 hours from now. Full stop. In the event any obstruction is raised by the private respondents, comma, it will be open to the CSC Limited personnel to approach respondent 3, the officer in charge of the Topshia police station, for adequate police assistance, which will be given at the cost of the petitioner by acting on a server copy of this order, comma, if necessary, by removing any padlock or other hindrance put up to resist the CSC personnel in giving such connection. Full stop. The new connection shall be given from the existing meter board position at the premises.
Yes.
I'm for the petition, Lordship.
I appear for the licensee company. They have
Lordship,
applied for the new connection.
Lordship, the same as the previous matter, same premises, but Lordship, in this matter, there are 4 private respondents, 2 have been served, but other 2 has refused, returned as
They are saying
insufficient
that the
address.
promoters as well as the landlords are.
Returned as insufficient address to the developers. Landlords have been served, but
Who have
developers,
received? Who are the private?
landlords.
The landlords have been.
Who are resisting, bro? Developers?
No, mainly the landlords are resisting.
Because they have not been served. Insufficient address, what can be done? I'll pass an order. I'll dispose of it.
Lordship,
Yeah, they have complied with formalities.
Lordship,
Complied with the formalities from the
same
existing.
premises as the previous one.
Very well.
Existing meter board. unit.
Affidavit of service filed today be kept on record. Full stop. Although 2 of the respondents stroke developers have not been served adequately, comma, since the envelopes have returned with the endorsement insufficient address, comma, the substantive resistance to the connection being given to the petitioner is being raised by the other 2 respondents who have been duly served. Full stop. Hence, the matter is taken up for hearing, comma, particularly since the grievance of the petitioner pertains to an essential service. Full stop. Next para. Despite compliance with all formalities, comma, the petitioner stroke occupant of the premises is not being given electricity connection by the CSC Limited due to resistance of the private respondents. Full stop. Next para. As the petitioner is entitled in law and particularly under section 43 of the 2003 Electricity Act 2003 to get electricity connection at the premises, comma, there cannot be any impediment in the CSC Limited giving such connection. Full stop. Accordingly, WPA 22769 of 2023 is allowed, directing the CSC Limited to give electricity connection to the petitioner in the petitioner's name within 48 hours from now, subject to compliance of all formalities by the petitioner from the existing meter board position. Full stop. If any obstruction is raised by the private respondents and other men and agents, the CSC Limited personnel shall be free to approach respondent number 3, the officer in charge of the Topshia police station, who will grant adequate police assistance in such case at the cost of the petitioner, comma, if necessary, removing any padlock or other hindrance put up to resist the CSC personnel in that regard. No rest to cause.
It was given 48 hours.
Before puja 48 hours. That is the statutory rule also.
No,
Under the
but
statute, you have to give within 48 hours.
difficulty is because of the pujas, there might be difficulty for to approach the.
Which is no difficulty. Give them the connection.
27.
Yes.
Please, Lordship, I am for the.
No, not every ground. It means every matter on the ground of
My lord, I am
somebody
filing-
else has to be there. You are for whom? The CSC Limited.
My lord, yes. I'm
Then
not-
somebody else must be there. From the panel, there is only Mr. Shuman Ghosh in the panel.
My lord, this has been assigned to Mr. Shuman. I'm not empaneled to move the matter, my lord, and I don't have solution.
Yes, with the Haldar.
My lord,
Electricity connection.
yeah, no, Malay, yeah. From petitioner electric line the private respondent drawing the electricity by hooking from one premises to other both the separate premises.
Oh, then
So-
he is required to be heard.
My lord,
Required to be heard.
Yes.
Affidavit of service filed to be kept on record. Full stop. An adjournment is sought on behalf of the CSC Limited. Let the matter stand adjourned for the day. It will
Fine.
retain its position under the same
fine,
heading.
fine.
Twenty-eight.
Yes, Mr. Banerjee.
My lord, I am the petitioner.
Yes.
Lordship,
But,
I am
uh,
appearing on behalf of Union of
Perhaps,
India.
my lord, this requires a hearing. My lord, I'll tell my lord what is, my lord, this relates to a challenge to my lord, the IBC. Insofar as my lord, it will apply or it will not apply to my lord, a section 8 company, which my lord knows section.
Challenge to the IBC provisions.
Yes, my lord.
After next year.
No, my lord, only to the extent I'll tell my lord. My lord knows under the companies are section 8 companies are my lord, the
Yes.
ones my lord, which has a special status. So my lord, whether my lord IBC, and there are several exemptions, several my lord ways my lord in which section 8 companies has to be managed.
Yes.
Whether IBC proceedings will apply or not, whether it comes in definition of section 3.7. And that's why my lord, I said not this side of the vacation. My lord, we have my lord, first my lord as an interpretation with regard to the act itself. Otherwise, my lord, we have challenged that. My lord, I don't know, my lord. I think my lord, notice also has to be given, my lord, if we challenge to the office of the additional
Solicitor.
solicitor, additional solicitor. My lord.
Since the virus of the Insolvency and Bankruptcy Code, insofar as its application in a limited context has been challenged in the present writ petition, a notice of the writ petition be given to the office of the learned additional solicitor general, indicating that the matter shall be listed. When will it be a suitable date for you, Mr. Banerjee? After vacation?
After my lord, first week of December or my lord, end of November, whatever is convenient, my lord. to the
Very
court.
good. Indicating that the matter shall next be listed on December 5, 2023 for under the same heading. Full stop. An affidavit of service in that regard shall be filed on the next date.
I'm grateful.
Thanks.
My lord, this is the affidavit of service. We have served on the union and
Very well. The
I am
affidavit
appearing
of
for
service filed today be kept on record.
I'm grateful. my lord.
Thank you, sir.
Twenty-nine.
I'm for the petition, Lordship.
Yes.
Filed the affidavit of service previous day, Lordship.
Lord, I appear on behalf of the
Lordship,
CSC.
petitioner is owner of the premises, applied for new service connection to the premises, complied with all the formalities, Lordship, including payment of the security deposit. But due to the objection of the private respondents, the CSC.
What the private respondents?
The neighbors of the petitioner.
Neighbor.
Neighbors.
Yes. What is your objection? Mr. Mukherjee, you agree to that? I mean, yes. What is your?
That is the only application I have objected to the CSC office.
মিটার বোর্ডটা দেখি কি দিয়েছো?
Is there any other way you locate a position? You show a position, they'll give that connection through that. No, there is no other connection going over the private passage. You are taking connection from a different place.
এটা তো কোনো ইনস্ট্রাকশন নেই তুমি বলছো।
Oh, private passage. Yes, what do you say to that? Private passage. Mr. Mukherjee, any instruction on that? Give a report. Private passage.
I will direct along with police help.
Learned counsel appearing for the petitioner contents that the petitioner has sought an electricity connection to be given at the premises in question. However, such connection has not yet been given by the CSC due to obstruction by the private respondents. For sub next para, learned counsel for the private respondent submits that the electricity connection sought to be taken is through the private passage of the private respondents. Full stop.
I have also given objection to the
Full stop. Such objection, yes, hand it over. Such objection has also been given to the CSC authorities. Full stop. Next para. In view of the nature of the objection raised by the private respondents, it would be appropriate if the CSC Limited holds an inspection and files a report in that regard. Full stop. Accordingly, the CSC Limited is directed to hold an inspection upon prior notice to the petitioner as well as the private respondents to ascertain whether the electricity connection, to be given to the petitioner at the location applied for, has to be taken through the private passage of the private respondents. Full stop. In the event the outcome of such query comes out in the positive, comma, the CAC Limited shall also ascertain whether there is any alternative route to give electricity connection to the petitioner. Full stop. Such report shall be filed upon furnishing prior copies thereof to the learned advocates for the petitioner and the private respondents on the next returnable date. Full stop. The matter shall next be listed on November 30, 2023, fairly at the top of the list.
Great, my lord. Instead of November 30, can it be on the first day of the December or second day?
December 1, November 30 না করে December 1 করে দিন।
I will seek for police help.
আচ্ছা, in the event any obstruction is raised to the CSC personnel holding such inspection, comma, it will be open to the CSC to approach the officer in charge of the Iqbalpur police station, that is respondent number 3, to provide adequate police assistance, which will be given by the respondent number 3 at the cost of the petitioner upon such approach being made, comma, if necessary, removing any hindrance which comes in the way of complying with such direction. The written complaint filed by the private respondents, comma, a copy of which is handed over in court today, comma, be kept on record.
Grateful, obliged.
Thank you.
I'm appealing for the state respondent.
Yes, right.
For the
Filing my officers.
Private response. Private.
But I am the tenant in respect of the
Mr. Mukherjee, please take your seat, all of you. Yes.
premises in question, Milord.
Tenant, yes.
And I have applied for new connection, Milord. The private respondent obstructed, Milord. That's why the CSC authority refused to.
CSC agrees to that?
My lord, CSC authority issued the offer letter and
Don't say whatever you have got by heart. Only answer my question.
Yeah.
You held an inspection,
yes, my lord.
but cannot give the connection due to their resistance.
Great, thanks.
Let me hear Mr. Mukherjee. Yes.
My lord, kindly turn to page 18. My objection is he has used a forced receipt. Fortunately, all the parties, I have sold the house to respondent number 4 and 5. I am 6. For 3 years, no payment of rent. Now they have used a forced document showing January 10th February 2023 as if I have taken rent 400. I have got the copy of the document and if your lordship permit me, I can produce it.
Any suit is pending between no suit is pending.
No, but this, my lord, the court of justice is being used by this. Either he will have to withdraw it and file a affairs without this. Otherwise, my lord, I will have to do it because they are depositing controller previously and for last years nothing has been paid to me before my sale.
No, otherwise they're in occupation. They were your tenant.
Yes, but they are actually using the page 18. Kindly see, I have sold it 22 November. I am Krishna Sau. I have got a copy of the document which will parenthesis show that is a forged rent receipt. This is the matter. This is my specific inspection. I can file an affidavit to that effect.
Very well, Mr. Mukherjee, I'll direct you to file affidavit, but in the meantime, electricity connection shall be given without prejudice to subject to the outcome of this.
We have got because
otherwise you have no objection.
Statistically, they are entitled to that. But the court of justice
No,
the
definitely
platform cannot be utilized in this way by annexing a document which will naturally.
Yes, take instruction. What is this?
Milord, I shall take instruction on this, Milord.
Learned counsel for the petitioner contends that the petitioner is a tenant in respect of the premises and in occupation thereof. Full stop. When the petitioner sought electricity connection, you complied with formalities. And complied with formalities, comma, the CSC Limited held an inspection but could not give the connection due to resistance by the private respondent.
My lord, one thing, my lord, the petitioner has not installed the main switchboard yet.
Full stop. Learned counsel for the CSC Limited in principle, comma, corroborates such stand and adds that no meter board.
No main switchboard at the existing meter room, main switchboard.
That the petitioner is required to install a switchboard at the location desired by the CSC Limited for the connection to be given. Full stop. Next para. Learned counsel appearing for private respondent number 6 argues that the rent receipt on the strength of which the petitioner claims tenancy annexed at page 18 of the writ petition is a forged document. Full stop. It is contended that the respondent number 6 transferred the property in favor of respondent numbers 4 and 5 in the year 2022 and, comma, as such, comma, there arose no occasion for the respondent number 6 to issue any rent receipt to the petitioner on February 10, 2023 as alleged. Full stop. It is argued that the writ court is also a court of equity and one must come with clean hands to get an order from the writ court. Full stop. Next para. Since the veracity of the rent receipt is challenged by the private respondents, the respondents are directed to file their affidavits in opposition by November 30, 2023, taking all points therein. Reply, if any, shall be filed by December 8, 2023. Full the matter shall be listed for final hearing on December 11, 2023. Full next para. However, keeping in view that electricity is an essential service and it is undisputed that the petitioner is in occupation of the property, be such occupation lawful or unlawful, the petitioner is entitled under Section 43 of the Electricity Act 2003 to get an electricity connection. Full stop. Accordingly, the CSC Limited shall give a new electricity connection to the petitioner from the existing meter board position at the premises in question within 48 hours, subject to compliance of all formalities by the petitioner. Full stop. Next para. In the event any obstruction is raised from any quarter, in doing so, the CSC Limited personnel will be at liberty to approach the inspector in charge of the Metiaburis police station, that is
Lordship.
who will give adequate police assistance at the cost of the petitioner to enable the CSC to give such connection to the petitioner. Full stop. The respondent number 3 shall act on a server copy of this order for the purpose of compliance and, if necessary, will be at liberty to remove any hindrance or padlock if put up to resist the CSC personnel from giving such connection. Full stop. Such connection, as and when given, shall abide by the outcome of the writ petition and shall not create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have in law.
Lordship, one indulgence, Lordship, indulgence, Lordship, affidavit in opposition to be filed by the private respondent, Lordship.
If you don't desire, don't file. Yes.
My lord, one thing, my lord, the meter room is under lock and key. So if police officer.
So you will remove the padlock.
Remove the padlock.
Yes.
Great, my lord.
Mr. Mukherjee's client will help you.
No, right here. He help you.
Oh, yes, you are not reserved. You have already sold.
I've already given. Grateful, my
Lordship.
31.
31.
I am for the petition. In respect of service upon the private respondent, it appears from the text result that the private respondent is not located.
Come back after the.
Kindly consider one thing. I have sent the same in correct address as mentioned in his civil suit filed by the private respondent. I have a copy of the plate to justify the address.
Do you have an extra copy of the plate? You can file it in court.
But no extra copy.
I'll take it on record then.
Yes, your lordship.
But I am for the CSC authority.
Right.
The petitioner ought to have constructible or meter board said.
Meter board?
Said, meter board said.
Shed.
Instead of the meter.
I have already constructed.
There is a dispute between the parties, my lord. There is an order passed in writ court. Their municipality was directed to ascertain the certain disputes between the parties. That order is, I think, that has not been.
Deviation of construction, dispute regarding deviation of construction. That's
Notice has been given to whom?
The private respondent.
You should not have suppressed that.
That
To
order
disclose all facts. Why didn't you disclose all facts?
22nd September
And
2020.
number five.
That order passed by this.
Affidavit of service filed today be kept on record. Full learned counsel for the petitioner submits that although service was sought to be effected at the address of the private respondents as given in a plaint in connection with a suit filed by the private respondents, the service could not be effected apparently because the said respondents could not be located. Full stop. Next para. In view of such contention, upon a perusal of a copy of the plaint of the said suit, which is handed over in court and kept on record, this is not a plaint, this is a memorandum of appeal.
Yes, ma'am. This is sorry.
What are you submitting? Perusal of the plaint, যেখানে বললাম last upon perusal of a memorandum of an appeal arising from the said suit, This court is convinced that the private respondents are deliberately avoiding service, full stop. Accordingly, the hearing of the writ petition is taken up in the absence of the private respondents, full stop. Next para. Learned counsel for the petitioner argues that the petitioner has not been given electricity connection despite having applied for the same. Full stop. Learned counsel appearing for the WBACDCL CSC. Learned counsel appearing for the CSC Limited points out that there is a private dispute between the petitioner and the private respondents. Full stop. That apart, comma, it is submitted that the municipal authorities had issued a notice with regard to the property in question. Full stop. Learned counsel for the petitioner submits that the municipal authority issued a notice with regard to deviation from sanction plan in the construction of the house, which was given to the private respondents. Full stop. It is submitted that nothing hinges on such notice insofar as the present case is concerned. Full stop. Next para. Being satisfied with the submission of the petitioner with regard to the municipal notice having no direct bearing on the right of the petitioner to get electricity connection to the premises where the petitioner is in occupation, comma, the relief sought by the petitioner is required to be granted within the contemplation of Section 43 of the Electricity Act 2003. Accordingly, WPA 23551 of 2023 is allowed, directing the CSC Limited to give electricity connection to the petitioner, subject to the petitioner complying with all formalities, including construction of an meter shed.
Meter board shed.
Including construction of a meter board shed,
But there is a physical obstruction also by the private respondent.
comma, within a fortnight from the date of compliance of all such formalities by the petitioner. Full stop. Next para. In the event any obstruction is raised by the private respondents and not the men and agents, the CSC Limited personnel shall be at liberty to approach respondent number 4, the officer in charge of the Rabindranagar police station, who will grant adequate police assistance at the cost of the petitioner in such case, comma, if necessary, removing any padlock or other hindrance in the process. No rest to cost.
Well,
at
may
this
I
time.
submit the instruction of the state, my lord?
You are the state. You are for the written instruction filed by learned counsel for the state be kept on record. Thank you.
I had read this. 32.
My lord, I appear for the petitioner.
Yes, Mr. Otto.
My lord, I am challenging, my lord, an order passed by the respondent number 2, my lord, ombudsman, and rejecting my prayer.
Good
for
service.
Yes. Rejecting my prayer for return of, my lord, the title deeds, security documents, title deeds and pledged shares. Despite, my lord, there being, my lord, all the credit facilities having been
Banking
repaid.
ombudsman.
Yes, under the Reserve Bank.
Reserve Bank.
And there is no, my lord, appellate remedy available to me. The impugned order says that I have annexed the scheme also. My lord, refusing, my lord, to return the, my lord, security documents, which includes title deeds in respect of property and pledged shares, only on the ground that another company of which I am a subsidiary, my lord, they have some dues. And the impugned order itself, paragraph 2, my lord, records the contention of the bank, my lord, when this proceeding was there before the.
I'll have to direct affidavits in this.
My lord, there is possibly no scope because of the admission, my lord, by the respondent bank itself with regard to no dues. Kindly seize 2 documents. Or else, my lord, if lordship feels affidavits, I'll take a chance, my lord, give them notice again and come back and move. I can, my lord, take that risk. But I will show only 2 documents why I say that, my lord. My lord, kindly comes to, my lord, first, my lord, page 357.
Oh, my lord, I appear for the bank, my lord, Axis Bank, my lord, and I'm humbly praying for directions to file an affidavit in this matter. As Mr. Doctor has fairly submitted, there's no scope as such for interim relief.
No, I did not submit that there is no scope of interim order. I am saying I can come back if Mr.
Madura, I fairly said that affidavits are to be directed. Mr. Datta unfairly said that it is not required.
My lord,
Your lordship has always been the fairest of them all.
The fair person, he will understand. 2 documents.
Mr. Madura is?
He is, my lord, otherwise very fair.
You realize that now, Mr. Datta, whenever move. Timing is very.
Kindly, my lord, comes back to, my lord, 2 documents, page 357, my lord, and the impugned order, 357.
357, yes.
This is, my lord, from the bank. My lord, this is with reference to your email below. The no dues for your loan is still under consideration internally. So, my lord, the fact that there is, my lord, no dues from my lord the borrower is not in dispute.
No, the no dues for your loan is still
That
under
is my lord no
consideration.
due certificate, because I was praying for no due certificate. There are prior emails. I am not troubling your lordship with those emails immediately. I have, my lord, another document. Kindly seize, my lord, page 383A. 383A. This is what they write to the ombudsman. My lord, this is again from my lord Axis Bank. At the top, lordship will find. I'm sorry, my lord. Yes. My lord, 15 June 2023. My lord, because we had made the complaint under the ombudsman scheme, whatever the procedure is there prescribed. My lord, this is the, my lord, reply. First paragraph. ICNL is a subsidiary of City Networks Limited, and City holds 60.02% shareholding of ICNL. City is part of SL Group. ICNL is also engaged in the same business. So essentially, they try to say, I am a subsidiary of City Network. Kindly turn the page, para 5, clause 5.
Yes.
In the meantime, ICNL has repaid the amounts under the credit facilities.
You are ICNL.
I am ICNL. Granted, I'm sorry, ICNL has repaid the amounts under the credit facilities granted with a sanction letter. But I'm not reading the rest of it. Essentially, they admit that I have repaid the entirety of it. Now, kindly see one observation in the impugned order. Kindly comes to my lord the impugned order at page 394.
Yes.
14th of July, my lord, is the order date, lordship, at the right hand middle of the page. Kindly, this is closure intimation for complaint lodged by petitioner. Kindly comes to 395, my lord, clause 2.
Yes.
Bank submitted that Indian Cable, that is the petitioner, is a subsidiary of City Networks Limited. Both companies availed loans from bank. A total of 775 crore credit facilities was sanctioned to City. As security, City being the holding company as well as being intrinsically linked to the business of ICNCL, created a pledge of 22.99% of shares of ICNCL held by it. Further, as the entire amount under credit facilities granted to City has become due and payable, City account was declared NPA. In the meantime, ICNL cleared its loan dues and requested for release of security and NOC. Hence, bank requested City to extend security for credit facility as a sum of 193 crore is still to be paid by City to bank. But the company failed to extend security. Hence, bank has retained ICNL's shares placed by the company. So essentially, my lord, 193 crores is due on account of City's loan account. Now they requested, my lord, ICNL to extend the securities which were, or my lord, in the ordinary course given to secure ICNL facilities. Thereafter, once this was repaid, bank said, no, you continue with the securities to repay the dues of City as well. The sanction letter issued in my favor does not, my lord, cast any obligation of this nature. And bank is also aware of this. Now, the only ground on which they reject is I am a subsidiary. Despite, my lord, the borrower having repaid the entire dues, my lord, I have annexed the statement. It is zero balance.
Mr. Medora, how can you? Mr. Medora has gone.
No, he's there, my lord. Possibly.
No, I'm there, my lord. I'm there, my lord.
How can you justify this?
My lord, kindly take page 383B, my lord. Dr. My lord pointed out only up to paragraph 6, but paragraph 7, 8, and 9 are also equally relevant, my lord.
Right.
My lord, the reason as to why, my lord, I am still holding on to these shares, my lord.
Yes.
Kindly take paragraph 6 onwards. The bank has already ICNL via its email dated 31st March 2023 that no dues left for ICNL was under consideration. However, the bank had concerns over the account of City, as City was in breach of its payment obligations and had been an NPA with the bank since August 2019. Para 7 minute. The bank submits that the value of City is derived from its assets, investments, etc. City's shareholding in ICNL is an important asset of City. It is necessary that for resolution of City's account, its assets and investments are protected. Further, City and ICNL's business is intrinsically related. Moreover, as already stated, the bank is also authorized to call for additional security from City. Further, the EBITDA generated by City on a standalone is only inadequate to service the bank debts of City. If the 29.99% shares of ICNCL are released, there is a likelihood third-party rights will be created on the same, which would deteriorate value of City further. Similarly, to protect the value of the aforementioned shares, the charge over the assets of ICNCL has also not been released. The bank's aforesaid actions have been undertaken only with the intent to protect the value of City and are legal and valid. In fact, City's conduct in not resolving its account, which had been in default since August 2019, as well as the conduct of City in not providing additional security, should be viewed seriously. Paragraph 8, Madam. The bank further submits
that it is entitled to retain the shares provided by Citi as the entire amount under the credit facilities granted by the bank to Citi has become due and payable. Since Citi has failed to comply with its payment obligations, and therefore the bank has a right to retain the shares towards the amounts payable by Citi to the bank. Paragraph 9, however, without prejudice to the rights and entitlement of the bank, Axis Bank will be releasing the charge on ICNCL assets and issue no due certificate to ICNCL post satisfactory resolution of SNL. So, my humble submission was that I have a legal right, to hold on to these shares. Kindly permit me to file a short affidavit, I'll come back.
Only one thing. Citi
My lord.
has a shareholding in regard to certain shares in the IC, the petitioner. Now, Citi's shareholding does not make Citi an owner of the assets of the petitioner. So, Citi does not, shareholder of petitioner, Citi does not have any right to the assets of the the petitioner. So, the assets of the petitioner, you don't have a charge on the assets of the petitioner. You retain the shares. I'll hear Mr. Dotto on that. You retain the shares of Citi in the petitioner. But those are, in regard to those shares, Citi is only a shareholder. Petitioner is the owner of the company. So you retain those shares, but release the assets of petitioner. Citi
Can you permit me to take instructions from my client and come back? I'll come back on the first day of reopening.
No question of any instruction. Citi is only, according to you, Citi is only a shareholder relating to certain shares of the petitioner.
Yes.
As a shareholder of the petitioner company, Citi does not have any right on the assets of the petitioner. Now you are withholding the assets of the petitioner. It's well settled. Shareholder is not an owner of a company or does not have any right to the assets. That's settled. So how can you retain anything else? Petitioner's assets have to be released because they have cleared their loan. What is the
there are certain other documents also which I need to bring on record, from which I will be able to demonstrate to your lordship that I am entitled to hold on to these.
Let them file an
My lord, in that case, kindly keeps it on the reopening day in the same position. Let Mr. Medora come with whatever documents he wants. Just direct him to, my lord, give me a copy. My lord, affidavit, my lord, this is, my lord, an admitted. My lord, here is a borrower who has paid the entire dues and expects to, my lord, get back the title document.
No, I'll keep it soon, but not on the.
My lord, affidavit's lordship understands, my lord, the business of the court may not permit it to be taken up. My lord, I have been trying my luck, my lord.
Keep it under the upgraded matters list.
Very well.
Mr. Medora, please file your affidavit soon because there's very limited scope.
I will do that, my lord. No difficulty.
Admission, I am entitled to this
when
order,
can you file it?
I will kindly give me the shortest time possible on the date of reopening.
Only one prayer. My lord, kindly comes to 256 once. 256. This is the schedule of the, my lord, securities.
Yes.
My lord, kindly says one is a registered deed which is in my name.
Right.
This is a property, my lord, in, my lord, sector 5, an entire building. This was, my lord, given as mortgage. My lord, this is my property.
No, either you get the entire property or entire
no,
thing
what I am on is, my lord, the second security is, my lord, the share certificates which Citi has, my lord, the 29.99% in the petitioner. Now they say because Citi has defaulted in their Citi's account, they are entitled to withhold both. My lord, for the time being, even, my lord, I say the second one also they don't have any right because the sanction terms does not say so.
Second one, Mr. Dattu, I mean,
I'll show from, my lord, the sanction terms of
Citi's shares in you.
Citi holds 29.99% shares of ICNCL.
Yes.
Now these were also secured, or, my lord, pledge was created to, my lord, secure the repayment. Now, this was only in terms of my sanction letter. So, if my sanction terms are fulfilled and I repay, I am entitled to release of all securities.
No, Mr. Dattu, you produce these were the part of secured assets, your secured assets for your loan.
Yes, for my loan.
Citi's shares with you.
Citi, my lord, offered these shares were pledged with the bank to secure my credit facilities, which have been now repaid. Now, Mr. Medora says
then there's a link. Then there's a link.
There is, my lord. I will show, my lord.
If you pledge Citi's shares as a security of the loan, then there's a link.
My lord, if there are, I'll give a hypothetical
Then there's a
situation.
link.
My lord, there are A is the borrower, X, Y, Z are, my lord, persons who, my lord, secure the credit facilities by giving, my lord, shares.
Citi secured its loan with
no,
those
not
shares.
its loan.
Oh, then.
Citi secured, my lord, the credit facilities of ICNCL, and those credit facilities have been repaid. So naturally, as a consequence, my lord, securities should be released. This is so far as shares are concerned. So far as title deed, my lord, bank has no right to, my lord, retain these title deeds after the, my lord, the borrower has repaid.
Cannot be released piecemeal. The entire thing, all the things in the schedule are the secured assets. So it cannot be released
So,
piecemeal.
prima facie bank has to establish some right, pay my lord the petitioner borrower. If they
cannot be-
don't,
No, it cannot be segregated like this. The title deed will be released.
my
the
lord, I
rest of the-
understand, but
It is an entire
I
block.
understand. I'll come back on that. I realize, my lord, interim order may be difficult here.
Will be difficult.
But what I am on is, my lord, principally, my lord, if the borrower has repaid all dues and for the borrower, 3 other entities may have secured, my lord, if those, my lord, terms of the sanction are fulfilled, repay after, my lord, the entire repayment, my lord, the securities have to be released to those 3 persons and the borrower's own security. This is in principle what I would argue, my lord.
No,
Kindly-
you have a strong prima facie case still, but even then, the
only
petitioner,
claim, my lord, same position if it may
the
retain.
petitioner has made out a strong prima facie case for hearing the writ petition on merits, insofar as the respondents are refusing to release the securities provided for the mortgage, created upon the petitioner taking a loan from the respondents,
Respondent number 3, my lord.
respondent number 3, sorry, respondents and respondent number 3, on the ground that the non-repayment of the loan of a loan by City Cables,
City Networks
by
Limited.
the City Network, which is one of the subsidiaries,
It is holding company of ICS.
which is a holding company of the petitioner, has not yet, and creates a charge on the property and assets of the petitioner as well. First up, since the respondent number 3 seeks to use an affidavit in opposition, the respondents are directed to file their affidavits in opposition by November 24, 2023. Reply, if any, shall be filed by December 8, 2023. First up, the matters shall be listed under the heading upgraded matters on December 11, 2023.
Grateful, my lord. Lord, I take this opportunity to wish your lordship a very happy birthday.
Thank you, Mr. Datta. Same to all of you. Yes.
And I do the same as well, my lord.
Thank you, Mr. Madrana. Same applies to you too.
Prior to switch
Thank
over
you.
to
That was
origin,
great.
kindly grants leave me to mention that item 42, I am not troubling your lordship, it's urgent, or kindly grant us leave to move it before the.
Why? What is that?
vacation. My lord, the Administrator General and Official Trustee of West Bengal issued an order.
Nutshell.
Issued
urgently.
an order on 5th of October, my lord, removing me from the post of my Shebait without granting me any opportunity
No,
of hearing.
no leave to move during the vacation. No.
Lord, the property is being taken up by another person. I was there since 2019. No hearing, nothing, my lord.
No. Yes.
But this relates to tender. My lord, if you, my lord, but the last date is 3rd
Take
of
your leave
November.
from the
My lord,
vacation bench
3rd
itself. No.
My lord, 3rd of November 2023. Unless, my lord, the leave is granted, my lord, I cannot approach.
3rd of November, what will happen?
The closing date of submitting the tender. My lord, I have not allowed to fill up the form of submit the
Where your
tender.
leave is granted to you.
My-
Not to you.
For item number 45, my
45 to leave the vacation.
deeply on.
Thank
Lordship, as original side matters have been called on, happy puja vacation to your lordship.
Yes. Thank you very much, Mr. Halder. Thank you. Same to
Original
you.
side matters,
Yes.
court application, item number 1 and 2. Sanjay Prakash Bansal and another versus Reserve Bank of India.
We had concluded Mr. Nayak was addressing.
Yes. Mr. Naik is there. Yes.
I filed a written notes yesterday, my lord.
Right.
Lordship will only take up this one small correction, lordship. So Lordship will take up kindly take up page 3 of my written notes 1, so Lord. Lordship looks at the bottom half of the page, absolute last paragraph, my lord.
Yes.
On page 3,
right,
with the sentence that starts with petitioner was duly given notice. Lordship looks at the 3rd sentence, my lord, capacity of directors.
Yes.
That will be guarantors, my lord. That's a typographical error.
Only guarantors.
Only that'll not be directors. Yes, I would have given another page, my lord.
No,
not unnecessarily doing that. That is one, my lord. The other thing is there's one thing that I'd forgotten. Yesterday, I argued that the notices were served upon them and the proceedings were started in the capacity of director and guarantor. The director bit I'd already argued. With respect to the guarantor and the proceedings against the guarantor, my lord, lordship will kindly take up page 7 of my written notes once. There are 2 documents. I'd argued this on the first day. I've brought it to your lordship's notice. These are notices on the basis of page 7 and page 14 are two notices, my lord, dated on the same day, which have been issued to the petitioners for invocation of their personal guarantee. Page number 7 and 14. Lordship will look at the top of the page, my lord. Under Rule 7.1 of the Insolvency and Bankruptcy Application to Adjudicating Authority for Insolvency Resolution Process of Personal Guarantors to Corporate Debtors. I'd argued this, my lord, that under 2.6, there is a requirement for serving a notice. And these notices have already been served upon them because this is a prerequisite for the initiation of the proceeding under the IBC section 95, that is personal guarantee. I'd argued this on the first day, that qua the fulfillment of the requirements under 2.6, I have fulfilled this as long back as 18th of December 2020. Now, lordship will kindly come to, these are orders of courts. I don't have a difficulty showing them. Page 21, my lord. This is one of the orders, my lord. This is not a relevant order, but the reason I'm showing this to your lordship is that my lord will know that there is a pendency of a proceeding under section 95. Page 21. This proceeding is against the petitioner number 1. Lordship will look at the top of the page, my lord. I'm sorry, my lord. Under section 95, subsection 1. This proceeding which was initiated against them was for enforcement of the personal guarantee, prerequisite whereof was the issuance of the notice for demand. This is against the petitioner number 1, and they have entered appearance. They are aware of this proceeding. Lordship will look at this, the two names of two counsel, my lord, for the respondent, who is the petitioner number 1 in this instant proceeding.
This was in connection with the NCLT proceeding.
No, this is a fresh proceeding we started against the petitioners for enforcement of their personal guarantee. So there was a
recovery proceeding.
This was technically, my lord, for personal guarantee. So if they do not, upon the receipt of the demand notice, they pay the money, then they would even.
Yes, you had submitted that you want to link this with this proceeding also. This is sufficient notice to give them an offer that you repay your.
That is right. Definitely. That's the point that I argued.
Yes, you argued the point.
Just to bring it to your lordship's notice,
right,
the pendency of the proceeding. So page number 21 and 22 are orders in the proceeding against the petitioner number 1.
You have referred to this in your written notes.
Yes. They're all referred. 21 and 23 onwards, 2 pages are orders passed in the proceeding against the petitioner number 2, the wife of the petitioner number 1. So, Lordship,
Mr. Bordhan, Mr. Nayak had argued that those notices should be treated to be sufficient compliance of this prior.
Very good. So, 2.6 has been, in my humble submission, complied with, read with, even independently it's been complied with, but also read with the pendency of the proceeding. Now, the second leg of my argument apropos this is that this entire proceeding as well as the demand notice has been suppressed. It does not find feature either in the writ petition challenging the identification committee order or the review committee order. Lordship will kindly allow me to place reliance upon one judgment. I have cited that in my note, but for your Lordship's convenience.
You had handed over certain copies.
This is a new order. This is a coordinate bench, my lord.
No, you had handed over on the previous section. Yes, very good.
Lordship kindly takes up page 4. There's an exactly similar set of facts, my lord.
Right.
Exactly similar set of facts where the proceeding was started against the petitioners, director and guarantor. Lordship looks at para 4.
Page 4.
It is a copy. So there is a reported judgment, but I've taken out the copy from the server. So I've handed over a copy to my lord.
Citation, but.
Not may I hand it up, my lord. This is a reported judgment. I know there's an SCC citation. I could not obtain it. I'll hand it over to your lordship.
If I refer to it, I have to refer to the.
I'll hand over the
2021 STC Online Cal 3683. Tantiato. 2021 SCC Online Cal 3683.
Thank you.
I'm thankful to my learned friend.
Yes.
So she looks at page 4. This is the second paragraph, starting with per contra. This is the counsel for the respondent bank. Per contra, Mr. Gupta, the learned advocate for the respondent, contended that the writ petitioners are not merely the promoters, directors, but they were also the guarantors. He contended that the statement made in the writ petition that no demand was made on the petitioners on the basis of their guarantee is a gross suppression of material fact, as a proceeding before the Debts Recovery Tribunal being so and so is pending, wherein the personal guarantee of the writ petitioners were invoked. He relied upon a judgment of the Honorable Supreme Court in the case of Prestige Lights Limited. Your Lordship knows this judgment my lord, and submitted that the instant writ petition is liable to be dismissed on the ground of suppression alone. So this is with respect to the suppression of the fact that there is a demand. So the OA which has been filed before the writ recovery is equivalent to a demand. Lordship kindly takes up page 5 once, my lord. Top of the page. In reply, Mr. Shah, learned counsel for the petitioner, admitted the pendency of the proceedings before the DRT. He stated that though this would be inadvertence, such fact was not stated in the writ petition. By referring to clause 2.6 of the master circular, Mr. Shah contended that a non-group corporate or an individual guarantor can be classified as a willful defaulter in case such guarantees were given with effect from September 9, 2014, and the guarantees taken prior to this date does not come within the purview of the master circular. Lordship kindly takes up page 14 once more. This is where it's dealt with. The last paragraph. By relying on the judgment in the case of page 14, last paragraph. By relying on the judgment in the case of JAR developers, Supra, Mr. Shah contended that the authorities have to discover as to whether the unit has defaulted in making its payment obligations, even when it has the capacity to honor the obligation, or siphoned off funds so that the funds have not been utilized for the specific purpose for which the finance was made available. Last paragraph, my lord, paragraph 17. I'm sorry, my lord, page 17. Page 17, my lord. Lordship looks at the third paragraph.
Yes.
Though in the writ petition, it is specifically stated that no demand was made on the petitioners on the basis of the personal guarantees given by the petitioners to the respondent number 1, that is the IDBI Bank Limited. But Mr. Shah, in course of hearing, in his usual fairness, admitted that the respondent number 1 has indeed invoked the guarantees given by the petitioners, and the proceeding in respect thereof, initiated by the respondent number 1 herein before the Kolkata Debts Recovery Tribunal number 1, being OS so-and-so, is pending. Such suppression, in my view, is a suppression of material facts, and the writ court may refuse to entertain the writ petition, as has been held by the Honorable Supreme Court in Prestige Lights, which is the judgment cited. As such, the instant writ petition is also liable to be dismissed on that ground alone. Guarantor, my lord, these are my submissions that this is a material suppression of fact. They do not disclose the fact that there is a demand that has been received by them and the pendency of the NCLT proceeding under section 95. So with respect to this, on the last occasion, my lord, I was addressing on the last issue that they had raised, which is the fact that the order is unreasoned. So with respect to that, I have to deal with two orders. One is the identification committee. One is the review committee. With the identification committee, my lord, would kindly take up page 134 once. That is the beginning of the order. (134), my lord, to 137 is essentially the 134 to 137, my lord, is an observation as to what had happened prior. So this is not the relevant portion of the order. The ordering portion starts from 138. There were two contentions taken by us. One was that there is a transfer of an asset which was beyond the permission granted, number one, and the nexus of that purported transfer with the losses suffered by the company. And the second was that this demand has not been fulfilled. This has been dealt with, my lord, at the bottom half of the page. The committee observed is under. As per the transaction audit report dated so-and-so by so-and-so, Jamguri Tea Estate was transferred to Darjeeling Organic Tea Estate Private Limited, which is another group company of the borrower. The agreement regarding such transfer was executed on so-and-so by Shri Anil Bansal on behalf of Bhumia Tea Company. This is the company for which this proceeding has been started. And Shri Sanjay Bansal, petitioner number 1, on behalf of DOT EPL, without taking any NOC from the bank through the property, was mortgaged with our bank in the account of Bhumia Tea. As per the agreement, all the profit and loss after 31st of March 2017 should have been borne by DOT EPL. However, it has been noticed that there has been loss of profit from Jamguri Tea Estate from the year 2016 to 2022. So despite the transfer, they continue to appropriate the losses in the accounts of Bhumia. That has been recorded to the extent of 15.82 crores. Lordship comes to paragraph 3. The security provided as mortgage in the account of Bhumia Tea Private Limited, that is Jamguri Tea Estate, has been transferred to DOT EPL by an agreement dated so-and-so by Mr. Anil Bansal on behalf of Bhumia Tea and Mr. Sanjay Bansal on behalf of. The committee noted that Mr. Shri Sanjay Prakash Bansal is common director in both the companies, besides being director in another group company, which is Bush. That is the other two petitions which your lordship had been pleased to segregate. Paragraph 4, my lord. The transfer of Jamguri Tea Estate from Bhumia Tea Company Private Limited to Darjeeling Organic Tea without the knowledge of the bank was made based on which order of the identification committee dated 30th March 2023 was issued to Shri Sanjay Bansal. This is the order that your lordship was pleased to set aside on the ground that relevant documents were not made over. is issued. The said transfer of Jamguri Tea Estate to DOT EPL is violation of the terms of the sanctioned renewal of limits in the account of Bhumia Tea Company Private Limited. NCLT order dated 5th of March. I will place reliance on that, my lord. 5th of July, I'm sorry, my lord. 5th of July 2022, in case so and so, hereinafter referred to as the NCLT order, establishes the fact that the mortgaged assets Jamguri Tea Estate was transferred from Bhumia Tea Company Private Limited, where she Sanjay Bansal is common director, only after the bank moved to NCLT and NCLT's intervention by order dated 5th of July 2022, directing DOTEPL to hand over the Jamguri Tea Estate back to Bhumia Tea Company Private Limited. The same was done. Lordship skips over one paragraph, my lord, comes to the next one that starts with the committee. Also observe, has your lordship found it?
Yes, yes.
Observe that no further evidence or document has been provided by Shri Sanjay Bansal and Mrs. Reena Bansal other than their letters dated 12th of July and 7th of August 2023 to justify their stand. Shri Sanjay Bansal during the personal hearing has denied having executed any agreement. This is their stand. However, this act of transfer of Jamguri Tea Estate to DOTPL tantamounts to occurrence of the following events as per clause 2.1.3 subclause D of RBI Master Circular on willful defaulters bearing. So before I take your lordship to the rest of the contention, lordship kindly takes up the order once, my lord, the NCLT order which I've handed over to your lordship. This is UCO Bank versus Bhumia Tea Company. Lordship looks at paragraph 2 of the order, my lord. Learned counsel for the RP submits that Darjeeling, this is the CRP proceeding against Bhumia. Darjeeling Organic Tea Estate Private Limited, that is R1, who are represented and the client is the same as the petitioners, is ready and willing to hand over physical possession of the Jamguri Tea Estate and factory to the applicant on or before 15th of July 2022. As regards the claim of refund of the consideration amount paid by R1 and R1 has lodged its claim with the RP, which is to the tune of rupees 100 crores. It is submitted by the RP that out of the total claim of rupees 100 crores, rupees 74 crores approximately has been admitted by the RP. I'll not suppress paragraph 3, my lord. Mr. Prosenjit Roy, Deputy General Manager, UCO Bank, is present in person. He is directed to file an affidavit on behalf of the bank, explaining the reasons as to why, in spite of the land being under its equitable mortgage, bank did not keep its eyes open to the transfer or use of the land by some other person. Why they could not take any action against the corporate debtor for use of the land for about 4 years by some other company who claims to be the owner. So I'm being castigated in this particular paragraph. So the reason I was drawing the nexus with respect to the reasonableness of the order is that this particular property, the asset, is a tea estate. So tea is being grown here. Now, for a company that is claiming to be a tea manufacturing or a tea growing company, this would be directly proportional to the revenue that they generate. Now, for the entire period for which they show the losses, the property was not in possession of the company at all. Admittedly, they are parties to this proceeding. They could have challenged the order. In fact, they represent this and want the property to be handed back. So this would, in my understanding, first leg, my lord, in my understanding would be sufficient reason. Second, even if I assume for a moment, without conceding that this is not sufficient reason, in my humble submission, your lordship will test it, the High Court will not be able to replace this.
So, Mr. Naik, do you say that in spite of there being only an agreement, there not being any formal transfer, as Mr. Bachawat was highlighting?
Yes.
Even then, as far as the usage of the tea estate is concerned, the usufructs of the same, that right there was a present transfer of that right.
So there are two levels to it. One is an agreement. The second would be a dead of conveyance. So as long as
even if there was no transfer of the property, the land underneath it, the tea estate itself had been transferred. Rights to utilize the usufructs had been handed over.
Transfer defect.
So if that is transferred, that generates the revenue. So that is the tea estate
and it's recorded in the order that they show losses for the same amount of money as against the accounts of Bhumia. So if there's a de facto transfer without there being a de jure transfer for an asset, if this was an asset that was not directly
for your purpose, the revenue is affected.
For my purpose, the revenue is affected.
All right.
That is my submission, my lord. Lordship kindly turns over to the next page, my lord. I'm sorry, my lord, the second last paragraph of the same page, my lord, 139. Clause 2.6 of the RBI Master Circular on willful default bearing so and so dated 1/7/2015, which reads guarantees furnished by individuals, groups, companies, and non-group companies. So the second leg for which they are being prosecuted is the non-payment or the non-repayment for the demand as a personal guarantor. So this is because the petitioners in this case, or the addressees of this notice, are both the directors and guarantors of the company. There is a composite proceeding which is conducted, which is not otherwise barred under the Master Circular.
Composite proceeding means?
As a director as well as a guarantor. Director because 2.1.3 subclause D and 2.6 because the guarantor. Lordship kindly
turns. It is only subject to your compliance with 2.6.
2.6.
Otherwise, you can proceed together.
In my humble submission, it's been complied. Right. Lordship kindly comes to page 140. Lordship skips over serial number 1. Lordship looks at serial number 2 and 3. Sanjay Prakash Bansal, director and guarantor. Lordship looks at the third column, my lord. At the end, clause 2.6 is stated above. And Reena Bansal, petitioner number 2, the same. So the two clauses under which they've been prosecuted are for director as well as for guarantor upon due compliance. And I'd already argued on the last occasion, my lord, that the proceeding is not rendered perverse because of the resolution plan being approved or them being absolved, because number one, the entire proceeding is concluded prior to the resolution plan being approved. Number two, my lord, they have not pleaded this. On the last occasion, slightly unfair, my lord. On the last occasion, they had said that the existence of the approval of the resolution plan was pleaded, or there's an annexure to that effect. I've gone back and checked. There isn't. There is a COC meeting, a meeting of the committee of creditors approving the resolution plan that has been annexed to the writ application, which means nothing in the eyes of law. As long as it is not approved by the adjudicating authority. And
when had the COC approved?
COC has approved, that is annexure 1.
That is before. That is before.
That is prior. That is prior. It's page 30 of the writ application. This is 3rd of December 2022.
That is only one of the limbs. Unless there is an approval by the tribunal, the
adjudicator, the NCLT, this means nothing. Section 35 IBC, they cannot do anything.
Right.
This, in fact, the adjudicating authority has.
Are you sure it's not been approved till now?
It has been approved on 28th. It's in the list of days, but that they have not pleaded it
So it's
anywhere.
It's already been approved now. So present situation is it's already been approved.
What?
This resolution plan.
Yes, they say that's after the impugned order.
But it's approved as of today.
Writ petition has been filed 1st of September 2023. The approval is on the 28th, which is after 4 days. So it was incumbent upon them to bring it to the notice of the court, and they haven't used that as a ground. They haven't said that the proceeding needs to be set aside qua directorship because the approval of the resolution plan has already taken place on the 28th of August. They have not pleaded that. They have not taken that as a ground. They haven't even annexed a copy of the order of the NCLT approving it. So in my humble submission, Lordship, tests they should not be allowed to take. I'll directly come to the second writ, my lord. I'll take 2 minutes on this. The review committee order. There were 3 submissions which were made by Mr. Bachawat yesterday. This is, my lord, 1727. 3 submissions made, my lord.
Your written notes of arguments are composite.
No, my lord, that is
different.
The first one. This one, my lord, will allow me to make, just to respond to 3 of those submissions verbally, Lordship will kindly record. My first written note.
No,
was,
it written notes review to note.
No.
Only one set of.
This was no. The written notes is apropos the first writ, my lord, the identification committee order.
Yes, it's a composite thing. No, you did not deal with.
I actually prepared that and submitted it prior to your lordship hearing it, because they had served us the copy after I prepared the.
You have covered the review also.
But it's admitted. The facts that they've stated is admitted. Well, I'm not denying them on facts. The 3 submissions made, my lord. One is that the review committee order was passed during the pendency of the. If your lordship wants, I may hand up a copy by today. If that's your lordship's pleasure. The written note for the review committee also, but my submissions will not go beyond what they're only responses.
What are the submissions? Tell me.
The first submission they made was that the review committee order was passed during the pendency of the writ application in a manner that is otherwise convoluted. That is Mr. Bachawat's submission, in a manner that is convoluted because I had come and taken adjournment on ground on one of the occasions. So therefore, the purpose was to render the first writ application infructuous. That is the first submission they make. The second submission they make is that there was no opportunity of hearing which was provided to them before the review committee. And the third submission that they make is it's a cyclostyle, even though Mr. Bachawat doesn't use that word, in a sense, that is what would be the submission. It's a cyclostyle reproduction of the identification committee order. I will address only these 3 issues with my responses, nothing else. I'm not placing reliance on anything else. First, my lord, with respect to that, after the review committee order was passed, subsequent to the filing of the writ application, that is an admitted position of fact. Despite the same, they have not been able to obtain a stay. Adjournments were sought from both ends. On one occasion, first time when the matter appeared, I had sought an adjournment, my lord, because I wanted to show judgments on the point of alternate remedy. I wanted to come back. Your lordship was kind enough to allow me to come back. The order of the review committee was passed during the pendency, admitted, but there was no stay.
No
stay. There was no injunction restraining me from taking steps. So therefore, in law, as long as they do not obtain a stay, I cannot be precluded from following the mandate of the master circular, which is incumbent upon me, apropos the passing of the order by the review committee. So whether or not during the pendency convoluted, it does not hold any water in the eyes of law. That's the first leg. Second is according to clause 3, I'm sorry, clause 3.3, master circular. But you will kindly take up the master circular once, my lord. Clause 3. You should be on page 9 of the master circular.
Page 9?
Page 9 of the master circular. Clause 3. where the entire mechanism has been provided.
Tell me just.
Entire mechanism has been provided.
Yes.
As far as the identification committee is concerned, they are required to be given a notice. As far as the review committee is concerned, they are not required to be given a notice. That is settled proposition. Even Jar developers recognizes that. Both of these authorities function independently of each other. Now, as long as the review committee does not review the order of the identification committee, the order of the identification committee declaring a person as willful defaulter does not attain finality. So whether or not they themselves prefer an appeal or a review before the review committee or not, it is incumbent upon me to review it myself for the purpose of the identification committee to be attaining finality. So when the order was passed on the 8th of August.
You put in a short written notes. I mean, 1 or 2 pages. You argue now so that Mr. Bardhan is aware of the arguments.
Very well, very well. I shall do them.
Yes.
I'll hand it up within half an hour of the matter.
Yes, yes.
I'll do that. So with respect to that, they had the option of preferring a review. The order was passed on 8th of August. The order was served upon them within the 18th. So by the 18th, they were already aware of the existence of the order that was passed against them, especially in consideration of the fact that they had entered appearance for the personal hearing before the identification committee. They chose to not go for the review. They had the option of doing that. Instead, they circumvented that proceeding, came before this court in a writ application that is otherwise barred by alternate remedy. So the fact that they were not allowed an opportunity of hearing cannot now be thrust upon me, that liability cannot be transferred to me because they themselves did not prefer an appeal. And that is recorded, that they did not challenge it. If your lordship takes up C, subclause C of clause 3, the order of the committee should be reviewed by another committee headed by the chairman and managing director. There's another point they've taken. I'll address that also, my lord. Director, the managing director and chief executive officer, CEOs and consisting in addition to 2 independent, etc., shall become final only after it is confirmed by the review committee. So merely because I have not given them an opportunity of hearing, which I'm not required to in law, nor have they come before me and asked for a review, does not preclude me from completion of the proceeding.
Good.
That is the second leg. This amply takes care of the opportunity of hearing bit, my lord. Third, before I address your lordship on the reasonableness of the order, Mr. Bachawat had taken otherwise an extremely fair point, my lord, that the order at the last page of the order, it says that it's signed by the committee or the members in the committee. It does not have specific signatures of all the members who are sitting, because in subclause C of clause 3, it mandates who are the members who are supposed to be there. I'm slightly on a weaker footing because I can't go beyond what is on record, my lord. In my humble submission, I'll restrict myself to that, is that once it is said that the members have been there, and that would fulfill the requirement of the quorum. There wouldn't have to be separate signatures in the absence of the fact that there is not one signature. If there are 3 members who are required to be there and there is only one signature of a person, then I would understand. Then Mr. Bachawat would have an extremely legitimate point. But once it specifically states that the entire committee is present, says the last page, my lord, the signature of the zonal head, Kolkata zone, on behalf of the review committee of willful defaulters, the signature of this will not tantamount to mean that the quorum was not met. And with respect to whether or not
quorum is the 4th point you are making. 3rd was replica. It's a replica of the first.
I'll address that for last, my lord, because I'll have to take your lordship through the papers. I'll address that point right now, my lord. Lordship kindly takes up page 151, volume 2 of the writ application. I think that is where the order commences, my lord. This, my lord, is the second writ application. This is 1727, my lord. Volume 2.
Yes.
151 is where the order starts, the impugned order of the review committee starts. There are observations as to what had happened, which would essentially in legal parlance be an obiter, my lord. The factual reproduction. The essential part of the order, my lord, starts from 157. They have dealt with all that has happened, including the pendency of the writ proceeding. 150, the bold emboldened portion, my lord, the middle of the page, observation of the review committee willful defaulters in the meeting held on 12/9. It goes on to the review committee peruse the decision of the committee for identification of willful defaulters and examine the relevant papers, evidence based on which the said committee passed the order. I'm not troubling your lordship with the rest of this. Lordship sees that in the same page, all the clauses under which they were being prosecuted has been referred to. That continues in 158. The review committee, my lord, willful defaulters also noted that there was no representation against the identification. Has your lordship found that, my lord? The top of the page. Identification committee order submitted to bank However, writ petition dated 1/9/2023 was filed by Mr. Sanjay Prakash Bansal and Mrs. Reena Bansal, which is the previous writ application, promoted directors and guarantors against the audited decision of the review committee, my lord, because they do not make any representation. There is no argument. They can't expect an order to be passed without them making any submissions. Now, if at all this point of the resolution plan, I am trying to be the devil's advocate for my own case for the time being, even if it is a relevant point, otherwise in the eyes of law, the review committee is otherwise equipped to decide on questions of law. Your lordship has already decided that in Kejriwal mining. So they could have taken this point before the review committee. Not only do they not do that, they also suppress that fact before the writ petition, before this court, my lord, in the writ proceeding. So naturally, all the facts that were before the review committee were the same as the ones that were before the identification committee, because it was incumbent upon them to bring it to the notice of the review committee, which they failed to do. These will be my humble. Lordship will, for the purpose of the first writ, my lord, consider the outer limit of my submissions to be the note, because in case I've missed out something, I've covered everything there as exhaustively as possible, my lord. All my lordship will consider that with respect. No, I'm relying upon them. It's in the note. I'm not. There are two other judgments which I've relied upon in the note, my lord. For the purpose of brevity, I'm not unnecessarily taking a lordship through those at the moment.
No. So, what is your argument in replica of first committee?
With respect to
that they did not.
They did not make any representation. So whatever facts that were available before the identification committee were the same fact. But I'll also go to the extent of saying this, because the review committee had taken cognizance of the writ petition, even to an extent, even though it does not bind upon me as an officer of the court, I must submit.
Ideally, should have considered the allegations made by them in the writ petition.
Correct. They should have. I know I'm bound by instructions, but I'm also a creature of common sense. I cannot say that they should. But in the writ petition, they do not aver the approval of the resolution plan. So even if that is a material fact, it was never brought to the notice of the court. So if it was, and the review committee failed to consider that, then it would have been vitiated by non-consideration of relevant facts. But because the writ petition itself does not take into account that averment, or it's not even averred as a ground. Their ground is the show cause notice, personal hearing notice given to me as a guarantor without addressing me as a guarantor. That is the entire basis of the writ application, which in my understanding, my lordship test is untenable in law. So if it was averred, it should have been taken by the review committee.
No, as of today, when the order will be passed or the hearing is done by both sides, as of that date, the approval has been there.
Yes.
So
I cannot go beyond the.
You can.
I cannot. I'm bound by that.
That remains. So what will be the effect of that? Even if they don't plead, both of you agree that yes, there has been an approval of the resolution plan by the NCLAT, and that too on 28th probably.
To that.
So what would be the effect of
my
that?
answer to that, my lord, would be a question to myself. If I go before a court of law to redress my right, and I don't argue my case, will I still be entitled to the same?
They have argued here.
No, they haven't. Not in the writ application. Not even in the second writ petition.
That's an admitted position. We cannot be so. I mean, we cannot shut out eyes to facts.
To that, my lord, I'll also have to be fair. Then, my lord, I would say that you will not record that as a concession.
No, cannot.
But this may perhaps be reconsidered by the review committee, not by the identification committee. Because identification committee order was passed prior to the approval of the resolution plan. It is not vitiated. I will go to the extent of protecting my right there. But with the review committee, because it was passed post-approval, it may perhaps be reconsidered.
If it goes before the review committee, isn't it a foregone conclusion?
With respect to directorship, yes. Not with respect to guarantors, because even the approval of the resolution plan does not absolve personal guarantors. That is a settled proposition of law. Mr. Bachawat argued that. He very fairly admitted to that as well. Right. There are judgments on that. Personal guarantors and their liabilities don't get absolved due to the approval of the resolution plan. So that point with respect, so to which I'll just conclude. Sir, act a second over there. To which I'll conclude, if your lordship is taking into consideration cognizance, what would be the effect? Then in my humble submission, lordship will not be umbraged, but this court would also naturally then have to take into account what would be the ultimate effect if it is the same person who is the director and the guarantor. If the approval of the resolution plan is a fact, then the fact that personal guarantee compliances under 2.6 was made, all the compliance under 2.6 was made, they do not pay, they suppress this fact, which alone should be the ground for dismissal of both the writ applications. Whether or not the same person being remanded to the review committee would yield a different result. in the same proceeding, where he could still be declared as a willful defaulter as a guarantor, which in a sense, all the boxes have been ticked. Prior to the puja, this is all that I'll restrict myself.
Yes.
Lord, may I respond to this question of suppression, my lord? Practice, despite the alleged transfer, my lord, what has the identification committee and the review committee held? My lord, kindly takes 140 of my first writ petition, my lord. I would have understood if, on the basis of this allegation of transfer, they held the company as a willful defaulter. I would have understood. Kindly seize 140.
140.
140. This question of, my lord, pleading in the writ petition that this resolution plan has been approved, not approved, doesn't arise. Kindly seize. Name of the company, directors, guarantors. The decision to identify the company, Bhumia TA Company Private Limited, as willful defaulter continues to be kept in abeyance. So, they have not proceeded against the company. So despite this allegations of transfer, they have not proceeded against the company. So, if they have not proceeded against the company, Milord,
No, that was still the sentence continued.
yes,
Till the implementation of the resolution plan.
So, Milord, when I'm challenging the order, if my learned friend says this is a post event, then when I'm challenging the order, as on this date, Milord, the company was not being proceeded against. As on the date of the order. And if I look further, Milord, today the company is not being proceeded against.
So how does it help you?
Milord, so when I challenge this, Milord, there was nothing against the company.
Nothing against the nothing against the company.
Abeyance. So they have still not, Milord, my writ petition was confined to the classification of a willful default, of the company as a willful defaulter. So, Milord, here, the company had not been classified as a willful defaulter because this was pending. So, as on the date when I filed the writ petition, Milord, the company was not identified as a willful defaulter. After the writ petition was filed, Milord, now the company has not been classified. At that relevant point of time, they were not being proceeded, and now they cannot be classified. So, Milord, me saying in the writ petition as to whether the resolution plan is pending or not, Milord, doesn't make any sense because they have not proceeded as a company.
Even if they don't proceed, keeping the matter in abeyance against the company is different from the resolution plan being approved by the NC.
Milord, may I put this way?
Entirely different.
Milord, may I put this way?
It was their choice, they kept it in abeyance.
Yes, Milord. So today, as on the date
that doesn't absolve the company.
No, Milord. What I'm saying is this. Today, Milord, when I'm challenging this order, I am not required to challenge this with the company because the company has not been identified as yet.
No, for your sake, you have to point out to the court that the approval has happened.
Milord, may I say this, Milord? My annexure 1, it shows that this was pending adjudication. And it is because of that thing, Milord, that fact that they have not proceeding against the company. So the fact remains, Milord, they are not proceeding against the company. And when, Milord, we say when they're not proceeding against the company, Milord, they cannot proceed against the directors.
This ground has been taken in your written notes.
Yes. And this had relied upon a judgment passed by my lord. My lord, kindly seize, my lord, 224289, Gaurav Dalmia, my lord, I've handed over to my lord.
Yes.
My lord was pleased to hold that the default of the directors, my lord, was the same default of the company. So if the company is not being proceeded against, my lord, the directors can proceed against.
That was not the
Yes, my lord. Yes, my lord.
The company was not being proceeded against, or company could not be proceeded against in Gaurav.
My lord, kindly, sir.
Use section 14.
Yes, that was section 14.
No, my lord. I'll just take a moment of your lordship. Take them down. Let's see. My lord, in view of the same default, which was marked as willful default.
Which para?
Paragraph 35. In fact, my lord, it starts from paragraph 34 onwards, my lord.
Yes.
However, as far as the subsequent event is concerned, the petitioners are justified in arguing that since the willful default tag was attached to the petitioners merely in the capacity of promoters and directors of the defaulting company, which itself has been absolved of such default.
There it was absolved.
Yes, my lord. What my lord was pleased to hold was
in abeyance is not absolved.
No, my lord, may I put it this way? If it was kept abeyance qua the company, it should be kept in abeyance qua the directors as well.
Not necessarily.
My lord, kindly cease, my lord, paragraph 35.
Here the company was absolved.
Yes.
If it is absolved, then the entire thing goes.
No,
that may be argued at least.
No, my lord. If it is kept in abeyance,
that's the discretion.
If it is kept in abeyance, my lord, qua the company, it has to be kept, my lord, in abeyance qua the directors. Why, my lord? Kindly see paragraph 35. In view of the said default, which was marked as willful default, having been allegedly committed by the company on the one hand, and the petitioners in the capacity of promoters directors thereof on the other, the declaration of willful defaulter in respect of the company and that of the directors promoters could not be segregated, since the root caused the same default. So, my lord, if for the same default, my lord, they say we are for the present not proceeding as the company, my lord.
This proposition is still valid. Gaurav.
Yes. And thereafter, my lord goes on to my lord, hold that it's the same thing, my lord. So if it cannot proceed qua the company, it cannot proceed, my lord, qua the directors. This is my first limbo argument.
Yes.
My lord, my lord. Number two, my lord. So, my lord, the company and the directors. Now the personal guarantors, my lord. All the notices, my lord, which I have shown, the hearing notices, called these two the gentleman and the lady to address is in the capacity of qua the directors and promoters. There's nothing of guarantors. Because my lord, guarantors, for classifying a person as a willful defaulter in the capacity of a guarantor, my lord, there has to be one line, my lord, or allegation saying that despite having the means to pay, they have not paid. No, that is wholly
referred to clause 2.6 in the.
Kindly cease now. Kindly cease 2.6 and 5.2. Kindly cease 2.6 once. In connection with the guarantors, my lord,
yes.
In connection with the guarantors, in terms of section 128 of the Indian Contract Act 1872, the liability of the surety is coextensive with that of the principal debtor, unless it is otherwise provided by the
Tell me
contract.
what you are trying to submit.
Kindly
Need not read the entire thing.
Kindly stick, my lord, the very next line, in case the said guarantor refuses to comply with the demand made by the creditor banker despite having sufficient means. So, my lord, the test or the scrutiny, my lord, with regard to a guarantor would be despite having sufficient means, he is not paying. My lord, this factor, my lord, is wholly absent, whether in the show cause notice, my lord, whether in the order of the identification committee or the review committee, my lord. And, my lord, if such an allegation, if I am called upon to show cause, my lord, this allegation must have been there. You do otherwise possess sufficient means to pay, but you're not paying. So this is wholly absent in the show cause notice, my lord, wholly absent in the review committee, my lord, identification committee order, my lord, and consequent the review committee order, my lord. So if I am not called upon to show cause as to whether
show cause notice, it was absent in the little.
Yes, my lord, kindly cease.
The last component, yes, maybe that you have sufficient means.
My lord, I'll show, my lord, kindly cease. The show cause notice starts at, my lord, page 44 onwards.
Yes.
The 2.6 component is wholly absent, my lord. They've just mentioned it. Kindly see page 45. Initially, my lord, they have set out the RBI circulars, the clauses. Then, my lord, kindly sees this explanation. The acts of the company's directors and personal guarantors coming under the purview of RBI guidelines of identifying willful defaulters are diversion, siphoning of funds, my lord, so this is not there. Number two, my lord, disposing of assets. Then, my lord, sees the above instances of irregularities confirmed to 213B under subclause 212BC, 213C, 213D, 2.6. So, my lord, where is this ingredient? Despite you having the means to pay, why you're not paying? They have not demanded an answer. They have not demanded an answer from me. And where's the finding, my lord?
They refer to clause 2.6. They say, why shouldn't you be
kindly cease.
classified as a willful defaulter as a guarantor? It was your incumbent duty
No,
then
my
to
lord,
reply
kindly cease.
that,
My lord,
no, I did not have the means.
kindly cease. Initially, my lord, they set out 2.1.3b, 1.3c, and 2.6. And thereafter the explanation, my lord, what they want me to explain: diversion and siphoning of funds and disposing of assets. They have not called upon me to address them on the issue that whether you have the means to pay or not.
Not specifically done in
No, no. And most importantly, my lord, neither the identification committee order or the review committee order, my lord, addresses this issue. Number one. Then, my lord, kindly sees this notice of show cause has been addressed to Bhumiyati company. Only copies thereof have been sent to me, my lord. Copies. So the show cause is, my lord, on the company. See page 46. However, if we do not hear from you within 15 days, this is quite the company. There's no show cause demanded from the this Mr. Bansal and Mrs. Bansal on the ground of personal guarantee. It's just a copy too. No, thereafter, kindly sees page 86. P14, Millard.
Yes.
As to the hearing notices, Millard, the last portion. According to the promoters, directors of the above named company are requested to make it convenient to be present. So guarantors were never called. Mr. Bansal and Mrs. Bansal were never called in the capacity of guarantors. And precisely so, because they could not have been called, because there was no allegation against them in the capacity as guarantors. So, these are so far this is concerned. Then this judgment of Tantia. Mulad, in Tantia, Mulad, the issue that was sought to be decided, Mulad, the question which has cropped up in the instant writ petition is whether the writ petitioners, being the promoter directors of a company, as well as guarantors with the loan facility, can be classified as willful defaulters even after the company is absolved of its liability. That was the question, Mulad. Said Mulad. Now, this honorable court held, Mulad, paragraph 23, Mulad. However, Mulad, this Dalmia was relied upon. This court held, Mulad, in the said judgment, the division bench held that the writ petitioners therein stood rid of the burden.
Which page?
Mulad, this is paragraph 23.
Paragraph?
Mulad has the SCC version. I'm carrying the SCC version.
No, I don't have.
Oh, Mulad, I'll just take a moment, my lord. Thus, in cases where a director. It starts with thus in cases where a director is found to be a full default. I'll just take a moment of my lord. Page 230, page 30. Last page.
Mr. Naik, you are
Page
just lazy, pure lazy. Should have handed up the SCC online copy. If you at all handed up.
Yes. Be permitted to.
No, you need not have handed up. I could have gone through that, but since you have handed up, I mean, yes.
No, this is page 13, my lord.
13.
13.
What does it start with?
It starts with, my lord, thus in cases where director.
Yes.
My lord, I'll be referring, my lord, to, however, in the said judgment, the division bench. Page 14, fourth line, my lord. However, in the said judgment.
Yes.
However, in the said judgment, the division bench held that the writ petitioners therein stood rid of their burden as willful defaulters, and their names were liable to be removed from the list of willful defaulters the moment the money due to the bank was paid in the full or was agreed to be received by way of compromise, since no personal guarantee was furnished by any of writ petitioners. So, Millard, so where the directors, Millard, once, I say once the resolution plan has been accepted, Millard, neither the company can be proceeded against, nor the directors and promoters can proceed against, Millard. I understand this probably, my lord, would not suffice as a cause of action for not proceeding against the guarantors. But for the guarantors, my lord, I'm on a separate footing altogether. I said that these people were never called upon to address the committee, my lord, on the issue of personal guarantee. So, my lord, my submission is, my lord, once they choose not to proceed against the company or keep the proceeding against the company, the bands, they, my lord, are stopped from proceeding against the promoters and directors, my lord. And in fact, my lord, this judgment goes on to hold that insofar as the personal guarantees were there, my lord, they could have proceeded on the ground of personal guarantee, but not, my lord, the Stantia says they could not have proceeded on the ground, on this facet of promoters directors. Only with regard to personal guarantors, they could have proceeded. My lord, I'm ad idem. I say in our case, my lord, they have no cause of action, my lord, to proceed against the guarantors. Company absolved, director promoters absolved, my lord, and no cause of action to pay the, my lord, the guarantors, my lord. Then, my lord, two other judgments have been relied upon, my lord. One, my lord, is WPO 1548 of 2021, my lord. My lord, this judgment is of 24th of December 2021.
Mr. Naik cited?
Yes, Mr. Naik cited, my lord. WPO 1548 of 2021.
What is the name?
My lord, this is 1548 would be.
I've not handed this up. I've not. I've cited that in the written notes, my lord. I've not handed up a copy because didn't think it was. Lordship, once I can hand up a copy, my lord.
This is Mantha's order, probably.
Justice Mantha.
Hello then.
I may hand up a copy. It's also, my lord, a server copy of the order. My lord, I slightly.
It's a reported judgment.
This there should
I don't
be
think so.
citation.
Then it has to be a server. Yes.
My lord, then this judgment, my lord, whatever it might hold, does not take care of, my lord, Gaurav Dalmia. Not relied upon, my lord. Not even referred. Dalmia was in 18/3/2020. And here's the case, my lord, where the resolution plan has been approved, my lord.
What was done by Justice Mantha?
Justice Mantha, my lord, was pleased to hold. Kindly sees. In this matter, my lord, if my lord kindly sees. This is on the moratorium under section 96, my lord. My lord, the issue that was being propped up, my lord, was that if the company.
No, Mr. Naik cited this on what?
This
count?
was only. I have not argued this. This was on the limited conspectus. There is section 95 proceeding and a proceeding under the willful defaulter identification committee can run parallel.
Yes.
Just because so that it's absolutely not relevant. Because they have not taken that point, nor has that fallen from the court. I have not taken the chance to.
If it's not relevant,
that is the only limited scope for showing this judgment. In case they would have taken this point because of the pendency, that is why I've written that in my note. Otherwise, it's not.
So, my lord, if two parallel proceedings, my lord, are allowed to continue, my lord, a notice under one proceeding, my lord, one act, my lord, on a statute cannot suffice as a notice in the other statute, my lord. So demand notice, which my learned friends were relying upon, to aid the insolvency and bankruptcy code, my lord, cannot be construed to be a show cause notice so far as this proceeding is concerned. My learned friend had said that that was a submission. There was a demand raised. Yes, yes. The demand notice would suffice as a demand to the personal guarantors. If my lord, I've understood his submissions correctly, my lord. So, my lord, if I say that two separate proceedings, then, my lord, a notice envisaged under one statute cannot substitute, my lord, a notice envisaged in the other statute. So this notice, my lord, which my learned friend refers to, and written annexed to, my lord, his written notes of arguments,
The language of 2.6 is, Mr. Bordhon, in
Yes.
case the said guarantor refuses to comply with the demand
Yes.
made by the creditor banker, despite having sufficient means, such guarantor would also be treated as a willful defaulter.
True.
So there is no particular format for that demand being under this circular or that circular.
I bow down.
There has to be a demand only. That demand was made.
The demand
That was a good ground for the other proceeding
kindly
also.
will not sees whether this demand notice contains that allegation that despite you having the means, you are not paying. Because that is the sine qua non. That is the sine qua non for proceeding.
Sufficient means must not be there. I mean, wouldn't be there, definitely. Without even looking into it, both Mr. Nayak and I can say that.
So
You
this is
have
not there.
sufficient means that is not occurred.
So if that is not Mulad, the sine qua non for proceeding against the personal guarantor, Mulad, is the asking of an explanation.
The only question which remains, Mr. Bordhan, is whether the demand has to incorporate that facet also.
But demand might not, but a show cause notice.
Yes, show cause notice.
But a show cause notice under the willful defaulter scheme, Mulad.
Right.
Otherwise, Mulad, there's no point of showing cause. If I'm not called upon to show cause as to what the allegation against me is, then the entire purpose of a show cause notice is frustrated, Mulad.
In the show cause notice, they had to say that yes, a demand has been made, but despite having sufficient means, you have not.
You have not paid. Kindly
That is one of
explain.
the grounds on which I want to proceed against.
Yes, you have to say you have the means, you are not paying, respond on this. If that is the query posed to me, if I can show I don't have the demand, I don't have the means to pay, then they cannot proceed against me. It is only after Mulad, an inquiry, Mulad, and satisfaction to that effect has been made that I have the means to pay, then only they can proceed against me, Mulad, in my capacity as a personal guarantor, not otherwise.
That would involve an inquiry. In your reply also, you could say something regarding your means and all this.
Absolutely so.
Which opportunity was not given to you?
Yes. Because Mulad, I believe, Mulad, the notice which was sent, Mulad, was sent only to the company. And Mulad, the contemporaneous documents and Mulad, the subsequent events and the facts show, Mulad, that every time Mr. and Mrs. Bansal were called, they were called in the capacity of Mulad, the directors and promoters, not as personal guarantors. Mulad.
If that notice was given only to the company, why did you respond to that in your capacity as director?
Suspended board of directors?
No.
Kindly see the show cause. Kindly seize the show cause. Show cause reply. Kindly seize. I'll just take a moment of my life.
Yes, sir.
47. The reply was by the company, page 47.
Apart from this reply, there was no other reply.
No. Reply to the show cause is only this one. There might have been other documents, other
hearing notice was given to you also.
No. Here
in the capacity of director.
If the show cause notice is silent, Mulad.
Did you ever take this point in the hearing that no hearing notice, no show cause notice was given to you?
Mulad, if no show cause notice is given to me,
you participated in the hearing
as a promoter director.
As a promoter director, even
yes.
Your point is to be accepted, Mr. Bordhan.
Suspended board.
There was no show cause notice to you at all because it was only to the company.
Yes.
Not to you in either capacity. So did you take the point that in the capacity of director or guarantor or promoter, no show cause notice was issued to me at all? You never took this point. So how can you now revive that point?
No, may I say this, Mulad?
This copy two, you responded to this copy two in the capacity of directors.
Yes, because
cannot say now that the notice.
No, Mulad, kindly see. I had to respond to this in a capacity of director of the company. So this replies to the company. Kindly sees Bhumyati and thereafter Mulad.
All right. So very well. Not in a personal capacity at director.
Yes. So I've said this.
As the limbs of the company.
Yes, I've said this.
All right. What have you said it?
I'll just take a moment of my.
Yes. In your reply.
আমার রিফ্লেকশন দেখো ওখানে বলছে সাসপেন্ডেড বোর্ড অফ ডিরেক্টরস রিফ্লেকশন দেখা
She will kindly allow me to reply on that on fact because they've
No.
admitted to.
No,
It's a new fact. They have not argued this.
No. What new fact?
They have cited a new judgment. This they've never argued.
What new judgment?
The fact that they show this letter dated 25th of March 2022 on page 47 and say that this was issued by the company. Lordship kindly looks at page 80 once, my lord, just one sentence, nothing else. Page 80, my lord. This is the new letter which has been issued by the petitioners, the Bansals. Lordship looks at the first paragraph, last line, right before a copy. In view of the same, have a Lordship found it?
Page 80.
Page 80.
Jeez.
In view of the same, being the members of the suspended board
Yes.
of directors, one second.
Yes. So this is what I'm on.
Adopt the same objection dated 25th of March 2022.
Yes.
So pursuant to the new show cause notice being issued, they're adopting the same response.
Yes. Where the directors?
The responses he says was in the
And
capacity
now
of
this makes it apparently clear. This makes it apparently clear.
The suspended board has no role to play once the CIRP has been admitted. So they have no role to play with the company. The first notice that the first reply that they gave 25th of March 2022, my lord, that notice was
if I have
post
no
CIRP.
role-
That
if I
was
have no
post
role
CIRP.
model, why I have been called? If I have no role model, why have been I called?
So this was after the approval. No, not after the approval.
All of the entire proceeding is concluded prior to the approval of the resolution plan, which has not been averred. And could I just distinguish the judgment?
CIRP.
They've shown the judgment in reply.
Which judgment?
Gaurav Dalmia, my lord.
Dalmia, I referred to this.
No.
I don't have a copy of the note.
Dalmia is there.
I
in the
referred. That
notes.
was the first judgment
During their arguments, they referred
Yes.
to Dalmia.
I don't have a copy of the note. My lord. They've
No
cited
question
the
of
judge-
copy of notes. It was argued by Mr.
Yeah, I'll not join.
These are the submissions.
Hearing is concluded. Judgment is reserved in the matter.
Was it your lordship's pleasure for me to file a written notes for the second writ, my lord?
You may not, because I've taken down the points. Review, very limited question. 4
Limited.
points you have taken. You have addressed.
Only responses to there. I've not
Yes, yes,
argued
right,
anything afresh.
Need not.
No, the review committee does not, my lord, put in any sort of mind. It's just if I could put it as the copy paste.
I would love to do that.
Lordship is extremely patient with us.
No.
Happy Durga Puja vacation, my lord.
Good arguments by both of them. Yes.
Item number 3,
Grateful.
Arindam Banerjee versus
And for the
Sridhar Bank.
petitioner, my lord.
Yes, Mr. Dutt.
My lord, I appear for the respondent, my lord.
My lord, affidavit of service. My lord, this is actually, my lord, a
My lord,
case.
I take the
Mr. Dutt,
point
you
of,
said on the last occasion that it was to appear in the list of on the last day's list, but you had to bring your learned friend. That was the direction I gave you. If
No,
you
I-
bring him, then I'll hear.
Only actually, my lord has told me that if.
Anyway,
if
now
he
both
does
of
not
you are
appear,
here.
then
Yes.
that-
Yes.
My lord, I say. My lord, this is your lordship actually basically a my lord case of the know your customer regulation of this Reserve Bank of India. So there's a latches on the part of the concerned bank, which is my main case, your lordship.
my lord, I have the maintainability point.
Why not maintainable?
Yes, my lord. First and foremost, this is not maintainable in the original site jurisdiction. My lord, kindly sees the cost title. In terms of rule, sees the cost title. Reserve Bank is only within jurisdiction. ICICI Bank, both the parties are outside jurisdiction.
What is the relief sought here?
My lord, nowadays,
There is not a single relief that has been sought against the Reserve Bank.
my
of
lord, actually, my lord, this is the non-implementation of the Reserve Bank of India guidelines. My lord, and recently I came to know that the Reserve Bank of India is very strict on these banks, and they're finding them
Let my
banks for
learned friend
this
issue a
violation.
representation
This
to Reserve Bank
violation,
of
my lord.
India, not a
So
representation.
by my lord,
of-
they're avoiding the RBI nowadays, my lord.
Why else not maintainable?
Yes,
Apart
my
from
lord.
original side, appellate side.
Apart from original side, appellate side, my lord, in terms of Sagar Thomas, my lord, the complete relief that has been sought is against a private bank. It is the RBI has only been made a party in order to file this writ petition. Not even a single representation
But
made
I'm
before.
relying upon these guidelines, RBI guidelines, only on that guidelines.
May I
Nothing
just
more, my lord.
say on the maintainability? My lord, not even a single representation. If my learned friend is so much aggrieved with the actions of the bank, not a single representation saying, not a single complaint being made to RBI. Just all of a sudden, my lord, will see that in the writ petition, RBI has been made a party. Not a single communication. And no relief has also been prayed against Reserve Bank of India. It's a complete private
Are they
dispute.
alleging violation of any RBI guideline?
100%, my lord. Only that is the case.
In their writ at the paragraph, they are saying willful defaulter. From where they are getting that? They have to agitate this point. Just by filing a writ petition will not do. First and foremost, they can't maintain this, my lord, in the original side. Second is that if they are aggrieved, the writ article 226, my lord, they want to invoke, There has to be some action.
What is the relief sought against RBI? There is
My lord,
relief
let
sought
me
against
tell you,
RBI.
Lordship, my lord, there may be, my lord, there
All
may,
the allegations are against the private banks.
but I'm saying, my lord, this is not a purely private. My lord has judgment is there, even the writ lies against my lord, that is that. But there may be two persons of the same name. Their father's name may be same, their date of birth may be same, but their PAN number cannot be same in the same bank, my lord. This is my case, for which, my lord, even the know your customer
has been done here.
Here, my lord, someone's loan has been imposed upon me without any notice, without anything, and even declared me over the server as a willful defaulter. The loan which is not mine, I was in a shock, my lord.
Willful defaulter. You have
Just which came to this knowledge in
My learned friend
Please
show
have a
that
notice.
we have declared him as a willful defaulter.
Please not interrupt. Please let
Don't
me
interrupt, Mr. Go take your seat.
Please, my lord.
Yes.
My lord, there may be, my lord, proprietorship.
Mr. Dutt, have they declared you as a willful defaulter? I mean,
yes, my lord. That
where is that?
This is my lord, CBIL, my lord.
That declaration.
When CBIL, I came to my, this is at page number, your lordship, actually prior to that, my lord, kindly read this, my lord, page 31.
31, yes.
Page 31, which is a loan recall notice I received from them, my lord. This is the page 31, my lord. Page 31, I'm the petitioner, will kindly come to page 32, my lord. Page 32, paragraph number 3, my lord.
Right.
However, contrary to the terms and conditions governing the aforesaid facilities and transaction document, you have been constantly defaulting in repayment of the contractual dues in, I don't know which loan. So loan facility by loan account number this. So despite repeated reminder requests and demands, where are these requested repeated demands and reminders? Where are, my lord, these? So thereafter, my lord, kindly come to the next page, page number 33, my lord. Page 33, which they have annexed that these are the loan accounts they are saying, my lord.
No,
This
there are two Orindam.
No, my lord.
Two separate addresses of the same Orindam.
No, my lord, this is not my case. My case is that my
page 31 gives two Orindam managers with two separate addresses. Is the same Orindam manager?
No, Arindam Banerjee is same. This is the name of the proprietorship firm, my lord. There may be one
petitioner here is Orindam Banerjee.
The petitioner here is Arindam Banerjee because his personal loan has been tagged with this proprietorship loan of someone else. He was not the Arindam Banerjee. He was some another person, maybe someone else, XYZ, my lord. But
that is the proprietorship of whom?
Someone else. Proprietorship of my lord. No, my lord. Proprietorship firm has no legal entity.
No.
It is based on the PAN card of the proprietorship. My lord.
Proprietor.
Yes, proprietor, my lord. So that proprietor has this bank account in that bank. This respondent number 3. Me too have my personal bank account and my proprietorship bank account in that bank, my lord. So there is no restriction that
who is respondent 3 is the branch manager of IC.
Yes, that person I'm saying. Respondent 3 is a branch manager. In that bank, myself has a personal account and my proprietorship account. There was a proprietorship with the similar name of the two persons. So there's my
don't have any proprietorship account.
I have that proprietorship.
You have one personal account in the name of Orindam Banerjee. You have a proprietorship account in the name of Orindam Banerjee.
Yes, Arindam Banerjee.
And there is a third Orindam Banerjee proprietorship.
No, third is not Arindam Banerjee. Third is Mr. XYZ, but his proprietorship name is the same, which is my proprietorship name.
What is the proprietorship name?
This is my SB Enterprise. SB Enterprise. Well, so there is no restriction that there may be a similar proprietorship firm in the name of the 10 persons, my lord. So that is it's supposed to be identified by is the PAN card number, my lord. So this is your lordship case. So my lord, I am incorporated my proprietorship firm in the month of September 2019, my lord. In the month of September. Thereafter, my lord, thereafter this on the basis of the certificate of enlistment from the KMC, I opened an account with the respondent bank, my lord, in the month of November 2019. So everything was smooth. So no notice, nothing else, my lord. So in the month of November, December 2022, I availed a personal home loan as a mortgage loan of the 96 lakhs, my lord. That was my personal loan and there's no default on that issue, my lord. So immediately, your lordship, on that, which I showed your lordship, the notice, loan recall notice in the, my lord, in the month of September 2023, I received this notice that I have committed a default in the payment of loan. Your lordship has just seen that words, my lord. In spite of repeated of this reminder, you are not paying the loan. So, my lord, thereafter, my lord, I made them the demand for justice that you can't. There is no mistake in rectifying the default. You kindly see that. But thereafter, they called me.
What is the page?
My demand for justice as page 34, my lord. Page 34.
34, right? Yes.
Yes, my page 34. I made them the demand for justice. There is a mistake on your part. I am not that person. Therefore, they called me over phone. Okay, you come. We will settle the issue. You pay something or do something.
Then what happened?
Issue is my only of the 79,000 rupees. That 70. When I can pay the 1 crore of my loan, why I should pay of the 2 rupees of someone else? My issue is not that. Issue is that his loan was only 79,000 rupees. So in order to hide their own laches, that mistake has been committed by them, and they have not followed that person, and they're following me, even not followed me also. No notice been served upon me. So thereafter, my lord, in September, 23rd September 2019, when I just checked my CBIL, my lord, and this on the, well, kindly come to page 39 and 40, my lord, my CBIL scores, my lord.
Page 30?
Page 39 and 40, my lord. This is page 39.
Yes.
I might kindly come to page 40, my lord. This is my Arindam Banerjee, SB Enterprise, page 39. It is very much clear over there. Arindam Banerjee, SB Enterprise, my name and my proprietorship. So here they were declared as a willful defaulter. Page 40, this is a right marks as a willful default.
Where is that?
Well, in the second column, there's a CBIL rank, and thereafter the page 40, adverse information, it is written as willful default. Well, on the left side of this is a
left side. Yes.
This is round marks up there, and they have just tick marked them. Willful default and suit file 1 to written off. So on that,
show me from your copy which location. Show me the location in the page.
Yes, this is my tick mark.
Very well, yes.
But they're saying that they have sent me notice. I don't know to whom they are sending notice. And my second issue, my lord, is there, your lordship. They know your customer rules. My learned friend know very much that banks need to check very much clearly, my lord. This is SB Enterprise. My lord, one proprietorship firm may have 10 types of business.
Yes, yes, very well.
Yes, he can do that. But this SB Enterprise, my lord, let me because only one ground which my learned friend going to say, which I next with that also, my lord. This SB Enterprise, which has committed a default with them, my lord, he has an excise license with the excise authorities. So in the year 2019, in the September 2019, July 2019, I have purchased that license from the excise authorities. So it has nothing to do with the bank accounts. I have just concerned with the excise department. My lord, even this SB Enterprise, I myself have 5-6 accounts with different banks, my lord. So this XP Enterprise, it is not that it is completely unknown to me. It is known to me because I have purchased and this excise license.
The other SB. You are speaking of the other SB.
Yes, that other SB Enterprise. So that is my lord. Where the
you know that other SB. What is your link to the other SB?
No, I have no link with that in concern with the bank account. He may have 10 bank accounts. So tomorrow all the banks will rush towards me. I am not signing this. I am taking the liability of the bank accounts. Only his excise license has been purchased before the West Bengal excise authorities. So here, when I have taken this,
so both the SBs have excise licenses.
No, but that person has to surrender the excise license to the excise authorities, and I have acquired that license from the excise authorities. Because a new excise license they are not permitting nowadays, my lord. So I have that. I have only taken his excise license. I purchased with the.
It is not transferable, Mr. Dhar.
No, that is transferred by the exchange of management. I'm showing your lordship. Page 17.
License is transferable.
Yes, but excise license, only new license, they are not permitting. I've done some cases also. Some cases which I.
No, obviously, you know. Yes,
yes,
I don't know. That's why I'm asking you.
The excise license under the change of management rules, they're transferring. Even the new license now, last 2-3 years, now they are there.
Very well, Mr. Dhata.
Page 17, my lord. Page 17.
I'll direct affidavits to them. You explain.
My lord, it will not.
It is maintainable.
My lord, no, not on the maintainability point also. That was the first point that was taken, my lord. First and foremost, my lord, page 17 is the SB Enterprise. My learned friend's client has purchased it from the earlier Mr. Soumen Talukdar, the actual fact. So it is an incorrect fact that he does not know SB Enterprise. He knows that Soumen Talukdar, doing on business in the name of SB Enterprise, was running a loan account with us. There was a due of around.
He had a separate SB Enterprise.
No, it is the same. Kindly come to page 17. Kindly come to page 17. Kindly see Soumen Talukdar on top. It has been striked off. Arindam Banerjee, writ petitioner's name written. Just thereafter below, SB Enterprise FL shop. Kindly see the address.
There is only one SBI.
Yes, and
No,
kindly,
my lord,
kindly
see
come
page
to
90,
his
my
civil
account number
report,
separate, my lord,
his
page 90.
civil report,
What
which
you are
he is
saying?
showing at page 39.
Yes.
Kindly see Aurinda Banerjee, SB Enterprise, same address. What my learned friend is saying that both are
Sir,
separate.
kindly don't mislead the court. My lord, kindly see, my lord,
And my lord,
my
second is
SB
that second
Enterprise.
point. Second point is that willful default, my lord. I have taken instruction. We have not. We have
No,
merely
this is
issued.
willful default, not under the circular.
Yes.
Willful default that they have
And my
ticked
lord,
the
my learned
boxes.
friend is having several loan accounts, which my lord will see at page 42. It from the his document only. Kindly see so many. Some other bank might
My lord,
have.
nothing, my lord, no bank had.
To an extent, our bank is concerned, we have merely issued a demand notice. There's so many banks, my lord. Which bank has initiated what proceeding against? I am not aware. At least to an extent, my bank is concerned, they have not.
So, my lord, if this bank has initiated, my lord may quash it, my lord. At the,
It's
on
a
the
demand
submission of this.
notice. It's a demand notice.
But only one condition: if he has issued, so then it is quashed, my lord. And
My
if
lord,
other
may
bank
record
issues,
my
then it-
submissions that
so
we
then
have
it will
not
sustain.
initiated.
Let it be say, my lord, because I
My
know
learned friend wants this way or that way something.
so but this is if my learned friend saying that if I have not said
it's a mere
my
demand
wrong
notice.
submission. My wrong submission is that well, I have not acquired his SB Enterprise. Well, I've incorporated my new one. If your lordship see page 13, my lord. This is page 13, your lordship. Page 13, 14, my lord. This is incorporated by me. How can there is no system for acquiring someone's proprietorship firm? This is only one part of that SB Enterprise which I have acquired, my lord. Only one, please. So, my lord, that SB Enterprise may have 100 banks account over here, and then tomorrow everyone will come to say.
And my lord, to put this thing in short, my lord, though I don't have the postal receipts, my lord, my learned friend's cause of action only arises out of page 31. That is the demand notice. Bank has taken a stand to recall this demand notice and to take steps after conducting whatever my learned friends this. Since I don't have the postal receipts, whether he has been delivered or not, it was just informed to me. I may submit that.
I'll impose costs on you for not saying this at the first.
My lord, I'm extremely sorry, but I didn't have the postal receipt or anything, my lord. So if this can put to rest, my
Then
lord.
record your submission on there.
Very well, my lord. Kindly record my submission and can dispose of.
So you can give him a hearing also.
Yes, yes, yes.
But only
On the
one
basis-
mandate, Mr. That has to be there when the hearing is.
Yes.
You have to be there, not Orindam.
Yes, my lord, your lordship, kindly. My lord, page 13, my lord, my incorporated.
That will take care of your bank.
My lord. My lord may record
So,
my submission. We have already.
Submission at the
recorded.
bar, my this submission has been made at the bar, your lordship, that I acquired his that thing.
Learned counsel for the petitioner contends that the petitioner apostrophe's name is Orindam Banerjee and he has a sole proprietorship by the name of SB Enterprise. Full stop. However, the impugned loan recall notice has been given by the respondent number 3, respondent number
2, my lord, 2. This is number 2.
2 bank, that is the ICICI Bank Limited, in connection with another proprietorship firm by the same name, that is SB Enterprise, of which the proprietor is a person different from the petitioner. For next para, it is submitted that upon such mix-up, the bank has issued the loan recall notice in respect of the petitioner, whereas the said notice ought to have been issued to the proprietor of the said other SB Enterprise. For next para, learned counsel points out that although the petitioner has had an exercise license standing in the name of the other enterprise transferred to the petitioner's sole proprietorship, the same per se does not shift the liability of the proprietor of the other SB enterprise with regard to the loan which has been sought to be recalled. Full stop. Next para, learned counsel for the ICICI Bank takes a preliminary objection as to maintainability of the writ petition. Full stop. It is contended that the Reserve Bank of India has only been impleaded in the writ petition to confer jurisdiction on this court and no relief has been sought against the respondent number 1, RBI. Full stop. That apart, the ICICI Bank is a private bank and is not amenable to the writ jurisdiction, not being not coming within the definition of state under Article 12 of the Constitution of India. Full stop. Next para. It is argued that in view of the petitioner having acquired the rights of the other partnership firm in the other proprietorship firm in the name of SB Enterprise, which is evidenced by the acquisition of the excise license annexed to the writ petition, it is the petitioner to whom the loan recall notice was rightly issued. Full stop. Next para. However, on instruction, learned counsel for the ICICI Bank submits in his usual fairness that the bank is agreeable to recall the impugned loan recall notice and to undertake the exercise afresh upon giving a hearing to the petitioner, if necessary. Full stop. Next para. In view of such fair submission made by the bank, the issue as to maintainability maintainability loses relevance as such. Full stop. In any event, since the ICICI Bank also discharges some functions in the public domain, taking a wide perspective, the said bank may also come within the purview of Article 12 of the Constitution of India. Full stop. Next para. Insofar as the dispute as to the matter pertaining to the original side or the appellate side of this court is concerned, since either way this court has jurisdiction to take up the matter, such objection as to maintainability is not entertained. Full stop. Next para. In any event, since a fair stand has been taken by the respondent number 2 bank, that is the ICICI Limited, WPO 1672 of 2023 is disposed of, recording the undertaking of the respondent number 2 bank, that is the ICICI Bank, that the loan recall notice impugned in the present writ petition shall be recalled in writing within a week from date, if not already recalled. Full stop. Thereafter, the ICICI Bank shall issue a fresh notice of hearing to the petitioner, and upon issuance of such notice, give an opportunity of hearing to the petitioner and undertake the exercise of issuance or non-issuance of a loan recall notice afresh, in accordance with law. Full stop. Next para. No orders to cause certain certified copies. It is, however, made clear that the merits of the contentions have not been gone into by this court, and it will be open to the bank, upon hearing the petitioner, to take a fresh decision on such score.
My one line may be recorded. My learned friend has submitted before your lordship that they have not declared me willful defaulter.
Yes,
This
yes,
submission may be recorded.
Yes, my
Tomorrow,
lord may record.
because no other bank is there.
Does not.
No other bank is there.
Declaration of
Only one is there. He might not be briefed properly by the concerned bank. It may be that. So, but a learned friend is saying he might not be rightly briefed.
Last, since it is insisted by learned counsel for the petitioner, it is mentioned for the records that the reference to the petitioner as having committed willful default in the civil rankings does not pertain to a declaration of willful defaulter under the concerned master circular of the RBI in that regard.
By the ICICI Bank. I'm grateful to your lordship.
By the ICICI Bank.
Yes, that is my lord.
My lord, I tender my apology. I should have first, but my lord, I didn't have that sufficient this thing. I should have stated. I tender my apology.
And wishing happy puja.
Wishing you
Yes,
happy
yes, same
puja.
to you. Thank
But
you.
before rising, my lord, may be permitted. But I'm waiting eagerly. But felling of trees, my lord, taking advantage of this long, my lord, vacation. My lord, there are ample, my lord,
8
scope.
vacation benches.
In that case, my lord, first we'll let it be transferred. Item number 18, my lord.
Transfer করতে হয় নাকি formally?
Leave to
Take the leave.
I'm
Leave to
seeking
the
leave.
leave.
I'm seeking-
Item 8.
18.
18, leave to move the vacation bench. তাহলে একটা order record করুন। Item
My lord,
80.
Mr. Ghosh is here, my lord. 1 minute is required. KMC is also with us, my lord. My lord, they are also opposing, my lord, the felling of these trees in this fashion, my lord. Let status quo be maintained for the time being, my lord. The vacation is there and all these
I
things.
cannot take up like this at this hour. You should have mentioned at 3 p.m. then.
My lord, because waiting, my lord, I am
3
expecting.
p.m. Why didn't you mention I take up to the religious?
No, my lord, I don't want to
Several
disturb. I am
people
here.
mentioned
my lord. I was at that point of time, I was here,
18
but I don't want
the
to
matter is
disturb.
mentioned out of turn for being taken up on the ground of urgency, full stop. However, comma, due to paucity of time, comma, the matter cannot be taken up this side of the vacation, full stop. However, comma, leave is granted to the petitioner to move the matter before the vacation bench.
First day of the vacation.
No, I won't specify that. Yes, we said now you were going to say something. Next matter.
Item number 4, my lord, extreme urgency.
What is urgency?
My goods, entire goods are withheld by the respondent authority, Bamar Lorry, my lord. It is 160 tons goods.
Perishable goods.
Not perishable goods. My lord,
Wait for
industrial
the
goods.
after release.
My entire business is withheld, my lord.
Several people are similarly suffering.
Lots.
Item?
Top matter.
What is the urgency?
Apartment ownership matter, the board has been.
Mr. Bhattacharya is there. How dare you? আচ্ছা item 5টা একটা লিখে নিন in view of the extreme urgency leave is granted to the parties to move the vacation bench move this matter before the vacation bench. Thank you.